DA Willis and Special Prosecutor Nathan Wade are facing allegations of lying about an improper clandestine personal relationship. They're also accused of financially benefiting from the Trump case and taking lavish trips together at taxpayer expense.
Judge Scott McAfee, who's also overseeing the election case, is presiding over the hearing. Proceedings began yesterday with intense moments in the courtroom. Both Willis and Wade say their romantic relationship started in 2022 and that expenses were split evenly and settled in cash.
Witnesses have pushed back against those claims. Trump and his co-defendants want the whole case thrown out. Let's turn now to the hearing.
And it seems we may not have that feed just yet. So let's begin with Arlene. What's your take on what happened yesterday?
Well, pretty explosive testimony from Fonnie Willis, of course, and Nathan Wade was more reserved, but he still made some impactful statements, such as that he collects cash a lot from his clients, which is, I guess it's not unusual, but I wasn't expecting him to say that because, this is, their tax returns were provided to him and shown to him. And I'm just wondering whether or not he's actually reporting that on his tax returns, that he's receiving so much cash. And it also goes to show that he must have some kind of a safety deposit box or lockbox somewhere, either in his office or at home, because the question was asked, well, what are you doing with all this cash? Where are you storing it? And he kind of said, well, maybe I'm spending it, but he didn't really give a straight answer. And he also said, well, I don't want to reveal that because I don't want people coming into my home or someplace, trying to rob me. So, it seems like he probably does have something like this somewhere. And then also Fonnie Willis, she admits that she has this kind of a practice where she stores, thousands of dollars in her home because she says she was raised that way. Her father told her, that she should always have cash on hand. No receipts, no records. They asked about, where is the cash coming from? It's okay to have cash, but where are you getting it from? So she says from her blood, sweat, and tears, from her hard work, right? Well, then there should be, and she gets her checks direct deposited. That was another thing they pointed out. So if you're getting your checks direct deposited, then you should have some records of you withdrawing that money, even if you're storing it in your home somewhere. And I think she made some kind of comment about, well, you get money here and there, $50 here, $50 there, and you throw it into the pot, kind of that kind of a thing. So where's that money coming from? So I thought that was a little bit interesting in terms of these two professional, experienced attorneys practicing that way or having that kind of a habit.
Yeah, it was a pretty big gap. I mean, basically you have Nathan Wade saying that he paid for these trips, but that both of them said that they split the money, except the money came back to Wade in the form of untraceable cash. There's no deposits, withdrawal slips from bank statements because allegedly, according to Willis, she, like you said, keeps cash at her home and on her person. Yeah, it's this really big gap of traceability here.
Yeah, and I'm not sure how the judge is going to look at that in the grand scheme of things. Is he going to accept it, that that's just how these two people live and that's how they operate and we can't judge them on that? Because it seems like they were trying to impress upon him and the other attorneys that they're just, they're a couple who were in love and they did things and they went on trips and they had fun and, trying to personalize themselves and make them seem like, they're just average people who go on trips and just like any other couple does.
And she was admonished a couple of times for speaking up too much or being out of line by the judge, but also some commentary has suggested that he may have been lenient on her because she was quite outspoken a lot of the time.
I think she took everyone aback. She shocked everyone because she just walked into the courtroom unannounced. Now that's highly unusual, and I believe she might have been watching the whole testimony of Nathan Wade, which is not allowed, right? You're not allowed to watch the testimony. You're supposed to be somewhere sequestered where you can't see anything so that you don't know what the other person said, right?
I wondered about that because the defending lawyer asked her, and if there wasn't a question of whether she could or not be watching it, then why would the lawyer ask her?
Right, so she wanted to know, how did you know to come in at the time that you came in? And she said, oh, well, I saw him leave. Well, how did she see him leave? Was she standing out in the hallway? And then she said, well, I saw some stuff. I think she did kind of admit that she was kind of watching something, but she's not supposed to be watching anything, and she just walks in and they're in the middle, her attorney is in the middle of trying to say, she should not have to testify. They're arguing about this, whether or not she should have to testify. And her attorney is saying, no, she shouldn't have to. Nathan Wade has told you everything you need to know. She's just going to repeat the same thing. She doesn't have to testify. And she walks in and says, I'll do it. You know, very bold. And I think she took everybody by surprise, especially the judge.
Right, and we are actually going to see quite a bit more of that. Fani Willis will be having her testimony continue today, and we are getting notice that we're having the live feed come in, so we'll tune into that now, and we'll be back with Arlene Richards soon.
We talked to him in the car on the way here on speakerphone, Mr. Merchant and I, and he said that he didn't tell Mr. Abadi any of that information, doesn't know where Mr. Abadi got it from. Mr. Abadi says that he did, so, you know.
If there's any clearing of the air that needs to happen, and if we need to get to that, I think the right time would be once we've actually seen all the evidence that comes out. So,
thank you. I just wanted to let the board know. Thank you.
and in terms of the privilege issue, if you're planning to recall Mr. Bradley, and you've actually typed out some specific questions, then yes, I think that would be helpful and might allow things to proceed a little more efficiently through his testimony. So, to the extent you've got those typed out and are willing to provide those to counsel for Mr. Bradley and the state, I'd encourage you to do that. And before we call him, we can get into that as well.
Okay, great. Thank you. And I have a copy for the court. I have one copy for either Mr. Evans. I know Mr. Abadi was objecting to privilege yesterday, but I think it's actually Mr. Evans that needs to do that.
Was Mr. Evans is here? Okay. All right. Anything else from any counsel?
Both the rule, make sure it's still in.
Rule is still in place. All right. Not seeing anything else. If we could bring back in Ms. Willis.
Actually, Your Honor, the state has no further questions for Ms. Willis, so
All right.
no need to recall.
Okay, Ms. Merchant. Next witness.
I think we're about to hit the privilege issue.
We are about to hit the privilege
There we are.
issue.
Okay. Then do you need counsel need a moment to take a look at her questions?
Yes. So I've got a copy. Oh, I guess Mr. Evans.
And then do we have Mr. Bradley somewhere in the whereabouts nearby?
Mr. Chopra, I informed Mr. Chopra that he's still under subpoena. So
Well, him and his client.
Yes, I'm also with Mr. Bradley, and he's actually not here today.
We need you to identify yourself for the record, sir.
My name is Van Ward. He's not here at this moment. He has a doctor's appointment that he's currently in as we speak. And his representation is on the way here as well. I'd love to be able to get one of the
You have a copy of that?
I just need Mr. Evans.
Do you have a time estimate of when he's supposed to be here?
I have one copy for y'all. Of the questions?
Where's the doctor in relation to here?
Yes, at the very earliest, it would be free about 10 o'clock, 10 to 10:30.
All right, he's currently driving here as we speak.
He's at the actual doctor's office as we speak.
Okay. And
And I think the council was informed of that last night, that he would not be here until at the earliest 10 to 10:30.
all right,
I wasn't until 10 or 10:30, but
sure. Ms. Merchant, other than Mr. Bradley, did you have any other witnesses?
not that I can call before Mr. Brown.
But I do think we can take up some of the privilege.
Sure. No, I think we can use this time to do that. So why don't y'all take a moment to look at the questions and then let me know when you're ready to proceed.
My part of it doesn't have to do with questions. I understood yesterday. I don't want another of these gentlemen looking at the same time. So you want me to wait until they've had a chance to.
Well, I think you're about to maybe make a legal qualification here, so why don't we hear what you got?
Yesterday, it sounded as if the witness was going to decline to answer any questions at all in relation to communications or observations or anything, be it independent source or otherwise, that took place during the time of the alleged attorney-client privilege relationship, which is 2015, I think, until the present. I understood that as referencing not simply attorney-client privilege communications, but what we commonly refer to under 1.6 as confidences and secrets, which are not covered by the attorney-client and are not barred from testimony or evidence in a courtroom. But it sounded as if the court is going to have to order Mr. Bradley to testify, and then Mr. Bradley will have to take a position of whether he's going to follow the court's order, heed the court's order, or whether he's not. If he does, then we'll be able to get in hopefully to the questions that Ms. Merchant has prepared on Mr. Roman's behalf. If he says, I'm not going to comply, then theoretically we're in a position in which the court will have to hold him in contempt. And then, at that point, my guess would be that somebody would say, I would like him to have the contempt stayed while I take it up on appeal. So I'm just trying to play through where we're going to be. Because if we're going to do that, we might as well know this before we start putting them on the stand.
I think that's a good thing to flag now, and I agree that yesterday during the hearing there was some intermingling of 1.6 and attorney-client privilege, and now having had the time to kind of parse through that, and it does seem that there is a distinction between the two. One is not covered by the evidentiary privilege, and pulling the case of Tenet Healthcare Corp., 273 Georgia 206. Supreme Court doesn't make that distinction. So to that end, Mr. Evans, as we work through these issues, I would say that when Mr. Bradley takes the stand, I would be directing him to respond and be responsive to any questioning that may be covered by Rule 1.6. That would be the order of this court. But that still reserves the issue of attorney-client privilege. So as you're reviewing those questions, we'll keep that in mind, and I'll be interested to hear your response. Anything else you think we should clarify before we take a break to look at the questions? Do you have a copy for me?
Yes, I do. A copy of the questions, Judge, and I also have copies of there's the exhibit that I would be filing. Would you like that as well? I just took those.
So I have an objection to filing. You say you want to file it?
No, that I'm going to use Mr. Bradley's testimony. I think it would help, but we can wait and I can use it. Yeah, for a strict question that I gave Mr. Bradley.
All right, and counsel for Mr. Bradley, I'm sorry, can I get your name one more time? I didn't write it down.
Maybe I would.
Mr. Ward?
Yes.
Okay. All right, Mr. Ward, if we could get some regular updates of where he is and how he is progressing towards the courtroom. And then when everyone has had a chance to read these questions in the interim, let me know and we can take this up. Mr. McDougall.
I have a text message from one of Mr. Floyd's lawyers that he's logged in on the Zoom conference room.
Okay. Is someone joining us by... Thank you. Is someone joining us by Zoom that wants to appear for the record?
Yes, Your Honor. Chris Kucherov for Mr. Floyd.
All right. Thank you, Mr. Kucherov. And I think we had a legal assistant here announcing on Mr. Floyd's behalf, but I think it would be better to have counsel of record any announcement in terms of Mr. Floyd's presence this afternoon, or excuse me, today.
I'm sorry, Your Honor. I don't know. Did you ask a question?
Yes, sir. So Mr. Floyd joined us yesterday, but I do not see him here today. Do you have an announcement about his presence for today's hearing?
No, he will not be present, Your Honor.
All right.
We would waive his presence.
Okay. Thank you, Mr. Cottrell. All right. We'll be in recess until I hear from the parties.
Thank you.
All right, as you just heard there, Fulton County prosecutors declined to call Fani Willis to return for questioning for day 2 of the questioning. We were all expecting her to show up, but it looks like it'll be a very different kind of day, as yesterday was really ruled by her testimony.
Yeah, I gather that maybe they don't want to let her to continue to perform that way today, and there's a risk to that. And also, how do you get around it? How do you defend that testimony, right? It might be just best to just leave it as it is and let the rest of the process play out. Now, they also said that Terrence Bradley was not coming in or was not there yet. Now, Terrence Bradley is the former business partner of Nathan Wade, who did appear for a very short period of time yesterday. I think he was maybe the second witness, and he claimed attorney-client privilege. Now, he was representing Nathan Wade in the divorce proceeding. Nathan Wade, divorced from his ex-wife, Joycelyn Wade. And he says the privilege started way back in 2015, which is a little unusual. And the story he gave was that back in 2015, Nathan Wade came to visit him because they were friends and partners, and he didn't have his ring on. And so he asked him about it. And he says right at that moment when he started to tell him about the marriage is when the privilege began. But I recall Nathan Wade saying at one point, and maybe he misspoke or he didn't realize he was saying it, but he said the minute he filed the divorce complaint, which was in 2021, he said that's when the privilege began. Now, I'm not sure that the defense attorneys caught that, but I wrote it down, and I'm pretty sure that's what he said, that in 2021, when he filed the complaint, then that's when the attorney-client privilege began. And then there was also some conversation about 2018 it began. But whenever it began, they're trying to protect this man, Bradley, from talking about the relationship that the two of them had, which he would know a lot about. And apparently before he was called as a witness, there was some back and forth between him and the defense attorney, Ashley Merchant. And she felt that he was going to tell everything. But apparently his friends, some of the other attorneys that were part of the practice, I guess, and they were calling him and encouraging him not to talk. That came out on Monday, and the attorney had asked the judge to put a stop to it. And by the time this Bradley came in, he said, I'm here against my will. I don't want to testify. And then he invoked the attorney-client privilege.
And the divorce eventually, as it came about, was a lot about the relationship between Nathan Wade and Fani Willis, if I'm correct.
Well, I don't know if it was a lot about it, but the issue of him having a lot of money, because the wife, I guess, is supposed to be getting some kind of payment through their agreement. He's supposed to pay her. And she complained that he had this money, $700,000 or nearly $700,000 income, that he wasn't sharing with her. And that's kind of how it came about.
So there would have been some amount of information about that relationship in the divorce filings, I'm assuming.
Yeah, I think there was, because that's how they were able to file their motion to disqualify them. They got that information from the divorce filings. Yes, that's correct.
Oh, I see.
And Arlene, I want to look at this privilege question. Why does when the privilege began matter?
Well, they're trying to establish that the relationship started in 2019, and that by the time she hired him in 2021 as the lead prosecutor, they were already in a romantic relationship. And so, she's hiring her boyfriend to take on this job, and her boyfriend has very little experience as a prosecutor prosecuting a case of this magnitude. I think most of his work is in personal injury and as a municipal court judge. So he really has very little experience in handling this kind of a case, and the other prosecutors have an abundant more experience than he does doing these kinds of cases, and they're not getting paid as much as he is. So it goes to, why she chose him. Why did she choose him and not someone else? And how is she benefiting from that? She's paying him the top dollar, and he has the least experience. And she's getting, he's taking her on these lavish trips. He's not giving any of the money to his ex-wife. There's a lot of factors here, and I guess that came out in the divorce proceedings.
So what else could we expect information to come from Bradley's testimony?
Well, they're hoping that he's going to talk about the relationship and when it started, because he, as his partner and as his friend, would have seen that. And I think he actually, I think he gave the attorney the impression that he could talk about that. And she was very confident on Monday that he would tell everything. He knows it all. But his friends, I think, put pressure on him.
But considering Ms. Yurti's testimony already clarifying this point, at least from her testimony, how important is it to get another testimony saying the same thing?
Well, it's always good to have more than less, because you've got Wade and Willis saying that's not the case. It was 2022, and they're very adamant about that, and they're very strong and forceful about that. So you need a little bit more than just this one friend. And this is an ex-friend. Remember, Fani said, she's not my friend anymore from what she did, whatever that was that she did a year ago. And she said, I haven't spoken to her since. So she's, maybe not such a credible witness. So you need more people to say this to make it more credible.
Do we know, what do we know about the other witnesses expected to testify today?
As far as I know, there are some of the other attorneys. There's one attorney, a prosecutor who's been working closely with Nathan Wade, and we've seen her a lot. Calling her, and I think there's a couple of other attorneys that they want to call that are maybe working on the case. They want to call some county employees that work in the DA's office and work with Fani Willis, and also her security detail, who would have been responsible for transporting her everywhere that she goes. And the question came up of whether or not Nathan Wade was also riding in her security detail with her to different places.
And this also comes down to the fact that it's likely that even though they both say they're highly private people, the people they both work closely with and most closely with would have known or observed something about their relationship. Mm-hmm. And so in some way it looks like this could reflect quite poorly on the whole department.
I don't know how significant that is. I mean, and a relationship by itself is not a bad thing, but the fact that they are benefiting from the case is what's bad, or allegedly. It hasn't been proven yet, but that's the allegation, that they're benefiting from the case. So there is law that says it's not a conflict of interest, right, to have a relationship. You can do that, right? But if you're doing this and also you're scheming behind the scenes to help your significant other to make money on a case, and then you're also benefiting from it, then that's a conflict of interest, because you want to prosecute 19 defendants so that you can make a lot of money. That's a conflict of interest, right? This case is going to take 6 months to a year to prosecute. It's not going to take 2 months like they've been saying. It's going to take a long time to prosecute this case, which might be why they've been trying to get people to plead out, because there's too many, it's too much to handle.
Yeah, and speaking of time, how long do you think these proceedings surrounding Willis and Wade could last?
Well, yesterday the judge said at the end of the hearing that it could go into Monday. He's hoping it will end today. Since Fani Willis hasn't come back, that probably speeds it up a little bit. But yeah, I'm not sure now. Terrence Bradley is not there yet this morning. He's on his way, so that's delaying things. We have, now we have a break that we're delayed for that. And then we have to see if the other witnesses are going to come forward today. If they don't all come forward and the judge thinks it's worthwhile to speak with them, then it's going to pour over into at least Monday.
Now, Fani Willis, part of her campaign for a district attorney was about targeting Trump and prosecuting Trump. Does that play in at all or impact the allegations about her intentions regarding her lover?
I don't think it has come up yet from these attorneys, that point necessarily. I think it's may go to the case itself and her prosecution of President Trump at some point in the trial itself. But in terms of this disqualification, it's more about how she's benefiting from this case.
Yeah, and there was that moment where she was at a church on, I think it was Martin Luther King Day, where she said that these charges against her, these allegations, could be racially motivated.
Yeah, I think President Trump's attorney has raised that in his filing papers. The judge said that that was not to be really included in this hearing. He didn't think it was relevant. He said that prosecutors can talk about cases under certain circumstances, and it's not unusual for a prosecutor to make comments about a case. So the judge didn't seem to be inclined to let that play out during this disqualification hearing. As far as the race card goes, some people have said, well, you know, she's saying that they're picking on Nathan Wade because he's black, but there are several black prosecutors in Georgia that could have taken on this case that have way more experience than him. So it's not the fact that he's black, but it's his experience level is what some people have been criticizing or pointing out. Like, why did she pick him?
And if that's not relevant to the hearing, why do you think Donald Trump's attorney brought that up?
Well, he thought it was relevant, but of course the judge is not going to allow it in. But
why did you think he felt it was relevant?
I think he thinks she's trying to play the race card, which she said she's not. She said in the actual speech that she gave, she said, you know, people are going to say that I'm playing the race card. I'm not playing the race card, but you know, I kind of think it is. You know, she's trying to turn this into a racial thing that, you know, they're picking on her and her boyfriend because they're black, you know, and that's also, I think it's kind of doesn't look well for her as the district attorney of Fulton County, which is a huge county. It's, you know, it's like, basically it's Atlanta, and what she's representing, you know, she needs to be a little more professional in her responses, I think.
Yeah.
I've seen some commentary suggesting that in her position, you know, she also has the opportunity later on, if she finds any kind of misconduct out, not related to this case, but just in general, in regards to Judge McAfee, that she could also target him and, you know, potentially prosecute him for some other kind of misdeed, and that I'm not sure what you think about these allegations, you know, that could impact a judge's, you know, a judge's own.
Well, I'm not so familiar with that kind of an allegation, but I think there is some news out there. I don't know if it's true or not, but that the judge actually maybe worked for her at some point in his career, in his early career. He might have worked in the DA's office, and I think that might be impacting how he is treating this, because he's trying to give her the utmost respect as much as he possibly can. He's trying to make sure this doesn't get out of control, but then she comes in and blows it all out of control. And he lets her do it for a while. You know, he's not very forceful in calming her down until finally one of the other attorneys, I think President Trump's attorney, stood up and said, you know, Judge, you know, what's going on here? You know, this lady's out of control. And then he said, okay, let me handle it. And he told her, you know, I'm warning you. You know, if you don't stop, we're going to strike your testimony. She continued. He warned her a second time. I'm warning you again. But I feel like he's still kind of holding back, like he's not really being very forceful with her in terms of letting her know that he's in charge, not her. But she took control of the whole courtroom. She took control over her own attorney. She did her own objections. You know, yeah, it was really something.
And he did warn her twice throughout the day, and he sort of warned that could lead to the end of her testimony. How does that work? Is it 3 strikes and you're out or something like that?
Yeah, I don't know. I think it's up to the judge's discretion when he thinks it's too much out of control, but obviously he let her continue because I think she carried on like that throughout her testimony from what I could see.
And what could happen if he decides to strike her testimony?
Well, then she doesn't have a defense. You know, she's there to defend herself. She's there to defend, you know, that she's not trying to financially, you know, get financial benefit from this case, and that, you know, she's not the one that's on trial. They're on trial, and she feels like they're trying to flip the script, right, and turn it around and make it look like she's the one who should be on trial. And so, you know, if she can't defend herself, then, you know, maybe everything else becomes true.
So is there any chance that, you know, yesterday she showed up to give her testimony in defiance of her own team's denial that they didn't want that. Today, it seems they don't want it today. She hasn't shown up yet, but do you think there's a chance she may, she still wants to get her word in based on answers from her own side?
Well, we don't know why they've decided not to call her, and they've already said they're not going to call her. But I find it unusual that, now the defense doesn't get an opportunity to get another chance to ask her questions, because they would have gotten another chance, right, based on what she says to her attorneys. Then they can, come back and cross-examine her. So now they're not going to have an opportunity to do that. I think they probably had a discussion, last night after her testimony, and all agreed that it would be in her best interest not to come back.
Now, while I was reflecting on this last night, I was thinking about how, these are attorneys, prosecuting attorneys, and I imagine cases where it's attorneys prosecuting regular people look very different. Or is this more of a Fani Willis kind of moment? Yeah, I'm wondering.
In terms of her behavior?
Yeah.
Yeah, I think if she was just a regular defendant, you or me or someone else, the judge would have put a stop to that much more quickly than he did. But she is well respected. She's the district attorney, the security guard that brought her to her seat. Even before she asked for it, he brought her eyeglasses, if you notice that. She was looking at the paper, and before she even opened her mouth to say, I need my glasses, he was right there with them already. So she has a lot of high respect here, and so the judge, as well as other staff who are there, are trying to give her that respect. And she's expressing that, how could you disrespect me like this? This is what she's saying to the attorney. All these lies you're telling about me, you're damaging my reputation.
And that is the key issue here. How likely is disbarment, do you think?
Well, I don't know about disbarment, but there's a risk that she could lose her position as the district attorney at some point, right? I mean, there's already an investigation by the lawmakers are already investigating her for this case to begin with, and now you have this. So.
And Nathan Wade, I felt that he seemed to be a lot more on an even keel than Willis yesterday. I wondered how this could potentially impact him. He's got his own business. Otherwise, obviously, if it goes sour for him, then that wouldn't be great. But it may not impact him quite as much.
In terms of his practice and disbarment and this sort of thing, I don't think this will hurt him that much. But in terms of how he's viewed and his reputation, it might be a little bit of a hit, yes. It's not very proper and appropriate for a respected attorney to reveal that he's accepting cash and perhaps maybe not, reporting it on his tax returns. I mean, that's, maybe that's not such a big deal. And then, yes, to be involved with this woman who's acting the way she is, I think it might hurt his reputation a little bit, but not for long. It'll pass, I think, for him.
All right, thank you so much for that, Arlene. We're about to go into commercial break, and hopefully soon we will have our hearing back on the air. They're currently breaking. Some of the witnesses weren't showing up. We'll get back to you after the break. Thank you.
Hi everyone watching at home. We're here to remind you that if you or someone you know were injured in an accident that was not your fault, listen up. We have live agents available right now to answer your questions and tell you how much your case is potentially worth. Hi, I'm Gina Bellich, here with spokesman and TV personality Tom Mustin with us in the Help Center. So Tom, phones are really busy over there. Tell us what kind of calls you're seeing.
Well, Gina, first off, thank you for having me here in the call center with you. We always enjoy talking to the viewers and getting folks the compensation that they deserve. You know, we're seeing calls about all kinds of accidents, but the most common by far has been car accidents. So if you or someone you know were injured in an accident that was not your fault, give us a call right now. You'll speak with a live person. They'll answer any questions you have and tell you if you have a case and how much your case is potentially worth.
Thanks, Tom. All right, folks at home, you heard it. Take advantage of this opportunity and call now.
This is such a gentle painting, so beautifully portrayed.
A group of people reading together in this simple, everyday-looking living room. A young girl reading along with an adult, a grandparent sitting in the lotus position, a businessman in his typical suit.
You see all those people, they look like they have quietly settled down there. And you as a viewer, it looks like you've just stepped in the door.
You can't see what it is they're reading, so you're a little bit curious and you're kind of invited to walk in.
This harmonious feeling is not by accident. It is the very subject of the work. The book they are reading is the main text of Falun Gong, which is an ancient Chinese spiritual discipline in the Buddhist tradition. At the core of Falun Gong are the values of truthfulness, compassion, and forbearance. Unfortunately, the practice is banned in China, where the artist resides. Thousands have been killed for their faith. Golden energy blooms into the room as a result of their steadfast faith. The painting on the back wall reminds us of this work's title, Plum Blossoms in a Muddy World.
It's also a metaphor for the practitioners that are sitting in the room as plum blossoms.
They signify perseverance and hope that all brutal winters end and life is renewed once again.
It's a magical painting.
Welcome back. Thank you for staying with us. We are tuning in to a hearing in Fulton County, Georgia, focusing on Fani Willis's relationship with Special Prosecutor Nathan Wade. Their relationship is under scrutiny because, Fani Willis is bringing this case against Donald Trump and numerous co-defendants, and at the same time, she had an intimate relationship with the Special Prosecutor in that case. So we're unpacking this. The entire world is watching. So far, Fani Willis, looks like she's not going to testify this morning. She was expected to. She testified yesterday. And right now we're waiting for Terrence Bradley to show up. I guess he was at a doctor's appointment. Maybe he wasn't expecting to testify this early. Maybe he was expecting Willis to testify. And so he was at a doctor's appointment. He's heading there now. That's what we're being told. We're expecting to hear from him soon once he shows up at the courthouse. But we have with us NTD's legal correspondent, Arlene Richards. Arlene, give us a synopsis of where we are right now.
So where we are right now is we've talked to Nathan Wade and we've talked to Robin Yurdy. Robin Yurdy was a former employee of Fani Willis's and a friend. And those two are on the outs, but Robin Yurdy did reveal that the relationship started in 2019, which is what the defense attorneys are trying to establish here. And that's important because Nathan Wade's contract began in 2021. And so the defense wants to establish that by 2021, they were already in this romantic relationship and she essentially hired her boyfriend. That's important because then it goes into the income. And they're saying that she paid him top dollar, which is $250 an hour. She paid the other prosecutors $150 an hour, and the other prosecutors have significantly more experience than he does. So he had to invest hours and hours and hours and hours of billable hours to get up to speed on this case. He was involved in the investigation and he testified that 90% of his time and efforts were in this case, and 10% or 99.9% and 0.1% was in his own practice with other matters. So this was his job, this was it, and this is how he was getting paid from at least 2021, and she put him in that position, and he potentially was already her boyfriend. They're contending that the relationship didn't become romantic until 2022, but they had met back in 2019. They didn't know each other well. They were colleagues. They kept in touch. Sometimes they had lunch, and it evolved into this relationship by 2022. Now they say the relationship has ended. He says it ended in June 2023. She says it probably was more like August 2023, but they're saying the relationship ended, which is a little, I'm a little confused by that, because I thought he said in the affidavit that that was attached to her response that they were currently in the relationship. So I'm not sure, I haven't looked at that recently. But it came out in court that the relationship has ended, and now they're just very good, close friends.
And it was a lot about defining their relationship in various periods of time, and about the definition of a romantic relationship really came up quite a lot. You know, they both spoke about whether they were having a sexual relationship at that time or not. And I noticed Fani Willis trying to define this and grapple with this terminology, saying, I'm not a hand holder, so at a particular time it wasn't an official relationship. So there's a real gray area.
Well, she's saying they're not kids. They're not like teenagers who say, okay, will you be my boyfriend? Will you be my girlfriend? She said it's not like that. So she can't pinpoint, an exact date on when they decided, that this was going to be more than just a friendship, right? So she's saying, it could have been November, it could have been October, I don't know the exact month. I think it's basically what she was trying to say, but she knows for sure it was 2022.
Right. And talk about a bit more about the relevance of when the relationship started.
So I think they're trying to point out that she hired him for this job because he was her boyfriend, and they were kind of scheming on this together, right? So we'll put together this big RICO case because you can make a lot of money from it. Now
That's the allegation?
No, I'm explaining to you what I think is behind this, right? So this is not what's in the papers, but I think this is what they're trying
analysis.
Yeah, this is what they're trying to bring out, right? They're trying to bring out that this couple, schemed to create this huge case. So, and she, as the district attorney, has the power and control to decide how much money he makes. There's also another issue about the fact that she didn't go through the proper channels to get this approved. And there might be testimony from other county workers who are responsible for giving that approval, who say that she didn't come to them and they had no idea what was going on. Now, I don't know how that could be that they have no idea what's going on, because the paperwork's going through and he's getting paid. So somebody has to know about that. But there's some testimony that she tends to just kind of do things her own way and skip over certain procedures that need to be done. So she has that power. And maybe if he was her boyfriend when she hired him in 2021, if he was already her boyfriend, maybe this is something they cooked up together to help him make some money. Maybe, and so we don't know what his business practice was like at the time. How was that going? I think that a couple of questions came up about, how was your business? How was that going? Were you being successful, or, were you struggling? And I think he said it was kind of 50-50. It was like he was getting 50% of his work from his own practice and 50%, from the county or something like that. So we're not sure what his financial situation was before she hired him.
And how important is the definition? At one point yesterday, they were trying to parse out the definition of whether Mr. Wade was an employee or not, and whether Fani Willis considered him an employee. And she said eventually she considered him an agent.
So an employee would have a set salary and they could receive overtime pay. You can get overtime pay as an employee, but on a contract, as a contractor, independent contractor, in the contract, which I think her attorney brought out on cross-examination, the contract said that there was a cap. He can only make so much money, and after that, whatever hours he worked, he wouldn't get paid for. And they went through this process of showing him some records of hours that he worked. And she asked him, did you get paid for those hours? And he kept saying no. And he goes, oh, you're going to make me cry. You know, I have to look at this, you know, all these hours I worked and I didn't get paid for them. So I think that's the difference.
And as far as I can tell from the testimonies yesterday, he was paid $250 an hour, and the other attorneys working on the case were paid $150?
I believe so. Yeah, but I think she had said in her speech at the church that she paid them all the same, paid them all the same salary or hourly rate.
I guess this would be like fairly easy to access that knowledge for the attorneys looking at it if they have his tax records.
I think it should be easy to, I mean, if they have his contract and they can get the contracts of the other attorneys, then they would see, you know, what the rates were for each. But I'm curious as to whether any of those, I think that the one prosecutor she's trying to call as a witness, and I'm curious if that, her knowledge of that now about the differences in the pay will impact her testimony. We'll have to see.
All right, thank you for now. Arlene, we'll come back to you in just a moment. We have some highlights from yesterday's hearing. Let's tune in.
What you are seeing on the left is highlights from yesterday, just in that box to the left. Fani Willis yesterday with that huge testimony coming out, and the judge speaking with her there.
Yeah, she showed up and she was clearly flustered. We know that she just marched down from her office. She was there in the building in her office, which is in this building where the courtroom is. And
this looks like the beginning of that session of testimony there. When she arrived, to everybody's surprise.
Yeah, I mean, she boldly came in and she asked for 3 documents. She wanted the 3 papers that were filed by that defense attorney. She asked for that right away. I want them here, right here in front of me. And so the judge took a 5-minute break to accommodate that, and someone went and got copies for her. And then when she got them, she dramatically held them up and said, these are all lies, lies. Everything is lies in here.
Yeah.
Yeah, and we just saw on the screen Robin Yurti in her testimony about the beginning of their relationship. She was testifying about those so-called lies, saying that Willis and Wade had a romantic relationship as early as 2019.
Yeah, I mean, as a friend at the time and an employee with a DA, she saw them in many different settings, and she did say she saw them being affectionate with one another.
And Willis took over Ms. Yurti's lease at one point, and it looked like the defense attorneys were trying to. They said that would have been moving out and away from her father. Willis said that, for example, Nathan Wade never visited her at her home with her father, but that he did visit her multiple times, upwards of 10 times, at her new condo.
Well, there's some conflicting testimony there, I think. Yurti's testimony was that Fani Wade wasn't getting along with her father, or she needed a break from her father, and she wanted someplace else to live. And Yurti was about to get married at the time, and she wanted to leave. And so she said it just kind of worked out, you know, that Fani Willis wanted to get a break, and so she came in, took over the lease, and she moved out and got married. But Fani said that she had to move out of her home because she was being threatened. She was constantly being threatened, and she feared for her life. And she had to go elsewhere where people wouldn't know where she lived, right? So this was like her, I don't know if this was the safe house or not. That kind of got mixed up because she was talking about a safe house. But she did move to this condo, and she was there for some time paying the lease and paying it to Yurti in cash.
Or via Cash App.
Or via Cash App. And then her father stayed at the house. He stayed there. So they asked, you know, wasn't he afraid? And she said, well, he's tough, and, you know, he stayed behind and he didn't feel the need to leave. And one of her daughters was back and forth staying at the house. but she said she couldn't because she was constantly being threatened. And as far as the visits go, Nathan Wade testified that he hardly ever went there, and when he did go there, it was to sometimes visit Yurdi, Ms. Yurdi, and sometimes for Fonnie Willis to go over a document or something.
Yeah, so there's a lot to parse out here, and we will be back with more coverage of this testimony and this hearing. Day 2 of the Fonnie Willis, Nathan Wade hearing in the Georgia Fulton County case against Trump. Join us after the break.
Stay tuned to get 2 rolls of alien tape free. You wouldn't stick your mother-in-law on the wall, but you could with alien tape. It just sticks. Just peel and stick to make anything stay in place quick. Brick, pavers, marble, tile, plastic, even leather. Nothing works better than alien tape. You wouldn't stick your fishbowl on a moving car, but you could with alien tape. The secret is nano-stick technology that grabs and locks on to secure one side of the surface to the other. Alien tape secures in seconds, then twist, pull, and rinse to reuse. Call or go online to get your first roll of alien tape for just $19.99, plus shipping and processing. But to make this deal really stick, we'll give you 2 more rolls absolutely free. You get 3 rolls of alien tape for one low price. Order now.
To order, call 1-800-490-1364 or go to tryalientape.com. So call 1-800-490-1364 or order online at tryalientape.com.
Hello, I'm Mike Lindell, and I'm here to tell you about my new product from MyPillow, towels that actually work. Watch this absorbency test. Here's another towel that we randomly went out and bought. Here's one of my towels with the nice design. I don't know if you can see this, but you could line a swimming pool with this. I mean, this is crazy. Get rid of it. Towels that actually work. What a concept. I'm interrupting this commercial to let you know you can get our 6-piece My Towels, regular $69.98, now only $29.98. Or you can save 25% on our brand new kitchen towels, made with the same technology as our famous My Towels. Also, we have bath sheets, bath towels, washcloths, hand towels, and so much more. And the best part, with your promo code, your entire order ships absolutely free. So go to mypillow.com or call the number on your screen. Use that promo code to get deep discounts on all My Towels. And for a limited time, your order ships absolutely free.
Thanks for staying with us. Day 2 of the Trump trials, our coverage of the trials that are happening this week. Today, we're tuning in to testimony, a hearing about the Fonnie Willis, Nathan Wade aspect of the Georgia Fulton County case against former President Trump. Of course, we're looking and honing in on the relationship between District Attorney, Fulton County District Attorney Fonnie Willis, and Special Prosecutor Nathan Wade. And we'll show you some sound bites from yesterday, which was a very dramatic day of hearings. So just to recap, stay with us.
Do you know if Miss Willis and Mr. Wade started dating in October of 2019?
I don't know if it was October of 2019.
Could it possibly be November of 2019?
Could possibly.
Okay. And when we spoke, you said it was shortly after the municipal court conference, though, correct?
Yes.
Okay. So you know that their relationship, their personal relationship, began shortly after this municipal court conference.
Yes.
And when I say personal, romantic. I just want to make sure we don't get in an argument over what personal and romantic is later. When I ask you personal, do you take that to mean romantic?
Yes.
Okay. And do you understand it that their relationship began in 2019 and continued until the last time you spoke with her?
Yes.
And you were essentially her best friend during this time, right?
Not best friend, good friend.
Okay. Good friend. Okay, close friend. And so would you frequently socialize with her?
Yes.
And you saw her at work every day?
Yes.
So you had a chance to see them interact together on a personal level?
Yes.
And so from everything that you saw, heard, witnessed, it's your understanding that they were in a romantic relationship beginning in 2019?
Yes.
Are you certain that Ms. Willis told you about the romantic relationship with Mr. Wade prior to November 1st of 2021?
Yes.
Now, did you also have observations of Mr. Wade and Ms. Willis together prior to November 1st of 2021?
Yes.
And are those observations, were those in a social setting?
Yes.
And did you observe them do things that are common among people having a romantic relationship?
Yes.
Such as, can you give us an example?
Hugging, kissing, just affection.
All before November 1st of 2021, correct?
When did your romantic relationship with Miss Willis begin?
2022.
When in 2022?
Early 2022.
So you were appointed in November of 2021.
Yes, ma'am.
And your relationship started early. What's early? January? February?
Around March.
Around March. But you two met at an October 2019 judicial conference, correct?
Yes, ma'am.
And describe your relationship at that point then.
Which point?
2019.
So I was at a judicial conference to teach a course, if you will, to newer judges. I did that in 2019. As I was exiting the conference, another judge was standing outside who was a friend of mine. I stopped and exchanged pleasantries with her. And standing, talking to her at the time was then Judge Willis. She introduced us at that time. We shook hands, exchanged business cards, and I got into my vehicle and left the conference. So that meeting was probably 3 minutes.
I'm asking if you took a cruise in October 2022 with Mr. Wade.
Yes, and his mom.
And his mother. That's what I was asking.
Yes.
Is that the first time you met his mother?
Yes.
It was on that cruise. And that was Royal Caribbean, I believe?
I honestly don't remember what ship. I know we've taken 2 cruises. I don't know what the ships were.
But he paid for the flight and the cruise on Royal Caribbean that time.
So yes, he paid. He is the original one that does it. He has something called.
We're just watching some recaps from yesterday's hearing featuring Fani Willis, DA Fani Willis of Fulton County, and Special Prosecutor Nathan Wade, the two who've been working in the Trump, Georgia case. We started with Robin Bryant Yearty, who was friends with Fani Willis from about 91. They were saying 91, 1990. until about 2022 when they cut off their relationship due to some kind of unnamed dispute. And she was saying that the relationship started in 2019.
Robin Yurdi.
Yeah.
Yeah, she said it started in 2019. I believe there was one point when Fonnie Willis came in the beginning of her testimony when she was sort of attacking the defense attorney and saying about all the lies she was making in her papers. And she said that the defense attorney accused her of sleeping with Nathan Wade the night she met him at this municipal conference. Now, I'm not sure that that's what her papers actually said, but I think what Yurdi established was that it was very soon after that conference that they got together in a romantic way, whether it was weeks or days. It seemed pretty close. Now, she said she wasn't sure they got together in October in a romantic way, but likely in November, which seems like it was only a few weeks or a month after they met.
And you mentioned earlier that the characterization of the relationship may have an impact on the validity of the testimony, that they had a falling out. I don't know if that's exactly what you were saying, but they also characterized their relationship quite differently. Yurdi had said that they were close friends or had been close friends, and Ms. Wade went to some lengths to suggest that they just partied together with many of their girlfriends. So I wonder what impact that could have.
Well, it just goes to Yurdi's credibility, I think. Fonnie Willis is defending herself, so she's trying to distance herself from Yurdi and make it seem as if they had more of a professional relationship, and there was this incident in the office because I think she testified that, or I don't know if Yurdi might have testified to this too, that there was an option. You either quit or get fired, or get let go. And, so something happened, and she said for what she did, after what she did, I don't know what she did, whether it was professional and part of her job or whether it was something between them in a personal way, but the relationship, the friendship ended.
And Arlene, I just want to come back to what Yurdi was saying about the start date of the romantic relationship. It was really explosive in the coverage we saw across the board. Basically, if Yurdi is right about the start date of this relationship, it has enormous consequences for Wade, Willis, the Fulton County Court, this lawsuit against Donald Trump and these co-defendants. Can you talk about this?
Well,
the magnitude?
She could be
what it could mean.
She could be disqualified, right? Her and Nathan Wade could both be disqualified from this case. And at that point, they have to find prosecutors to replace them and to take over the prosecution of this case. And from what I understand, there was a previous case that she was disqualified from because I think one of the defendants, she was helping someone politically. She had a fundraiser at her home of someone connected to the case. And I think she admitted at that time that she should be disqualified. And that case is still in limbo. They have no prosecutor for that case for 18 months. So, and that case was smaller than this case is. So to find someone else to be assigned to take over this case might be difficult to do. And then you have the fact that former President Trump is one of the defendants. And so for this judge, he's got to decide if he's going to allow this case to be put on hold when it's against former President Trump and what that looks like, because I think there's a huge population of people in Georgia who thinks he should be hung out to dry, right? And then this judge is the one that helps him to not have to see through this trial. What's that going to look like for the judge? So, there are some variables here, even though she looks as though she's appearing very unprofessional, there's other things, other factors.
And you said Willis was disqualified from a case previously. Did I hear you correctly?
Yeah. I don't know the name of the case, but there was some commentary by some attorneys who live locally. A defense attorney who lives in Atlanta who said that she was disqualified from a previous case, and that they haven't found a replacement in 18 months.
How common is the disqualification of a prosecutor like this?
I don't think it's so common. I mean, it's a huge deal, of course, to be accused of prosecutorial misconduct, and it doesn't reflect well on your reputation, on your record. You know, and I'm not sure, but I feel like she hasn't been the DA for very long. I don't know if you two have any more information on that, but I feel like she hasn't been the DA. I understand that she was a prosecutor for about 16 years. She left to go into private practice, and then she ran for DA, but I'm not sure how long ago that was. So if this is happening in a short period of time, you know, it doesn't reflect well for her.
Yeah, and I know her Twitter handle is something like Willis for DA or Fani for DA or something like that. So it's probably pretty recently that she became...
It might be, yeah. I'm not sure. Within a few years, or I'm not sure.
Yeah, and also in those clips we just watched a few minutes ago, we heard from Nathan Wade, special prosecutor in the Georgia case, Trump's Georgia case, saying that he started dating, that his relationship with Fani Willis became romantic in March of 2022. That contradicts directly of what Yurti was saying.
Yeah, and Willis is also saying the same thing, right? They're consistent on that it didn't turn into a romance until 2022, but it's, you know, what happened before that? What was the relationship like? And I think Willis testified that, you know, it started out as colleagues. They were both municipal court judges at the time, and it evolved over time. They did go out to lunch occasionally, but she characterized it as just professional, colleagues having lunch together and communicating. And then it evolved later, which would put it after she hired him to be the lead prosecutor, that this relationship developed. I think his contract was signed in maybe November 2021. I'm not 100% sure. And then the relationship started in early 2022. So it was only a few months after he came on as the lead prosecutor that it blossomed, I'm assuming.
Yeah, and I think one of the issues here is that fact alone. It already looks a certain way when you're hiring your boyfriend for such an important case. I mean, this is major case against the former president and all these co-defendants. But we will have more on this after the break. Thank you so much, Arlene, covering the hearing about District Attorney Fani Willis's relationship with Special Prosecutor Nathan Wade. We'll get back to the coverage after the break.
Is beautiful, breathtaking, timeless, and moving. Experience art with 5,000 years of history, inspired by the divine. Experience Shen Yun.
There's cultures that have been lost, but this culture hasn't been. The artist is showing us our sense of who we are, where we came from. You look at his hat. His hat is knitted probably by a man because a man traditionally knitted the hats. That hat tells you the story of who this person is, what his place in the culture is, the animals around him. Everything's all contained in the messages in the hat. And the tool that he's carrying over his shoulder. This is a centuries-old tool that has been able to rework the mountains. Those traditions are invaluable, and if we don't honor those traditions, then we're rootless. The artist is showing us the value of maintaining our culture and respecting our culture.
These are all farmers. Maybe
No,
not
there's
this
not a
one.
farm anymore.
But here's a farm, right?
No, there's also not a farm anymore.
All these people shut down because of the government policies?
Yeah.
The government wants to control the food. So we don't eat meat, but we eat insects.
As the price of staples goes through the roof, people will say, I can't afford a steak anymore. So, all right, I'll eat your stupid crickets.
Welcome back to our special live coverage of the Trump trials. We're focusing today on the case in Georgia, specifically the relationship between DA Fani Willis, Fulton County DA Fani Willis, and Special Prosecutor Nathan Wade, which has come under scrutiny because, like we were talking about before with NTD's legal correspondent Arlene Richards here, she basically hired her boyfriend to be the special prosecutor in this case.
Or that's what the defense lawyers are alleging. She's saying that they weren't together at the time that he was hired. So that's still being decided.
That's still being decided on. I mean, this is what the hearing is all about. The judge has to determine whether or not there's enough evidence to prove that this was actually occurring and whether or not to disqualify them for this. So, you know, it's really crucial, this time period of when they were actually romantic. When was it, you know, a more serious relationship and not just colleagues?
And as we saw in the highlight reel earlier, Ms. Urity's a close friend or a friend of Fani Willis's gave testimony yesterday, and that will be a big part of the defense's arguments in this aspect of the case. But one thing that they were examining was how and if Fani Willis paid Nathan Wade back for the trips that they went on, the lunches they went out to. And she's saying that she paid approximately half and that she always paid her way. There's no trace of that. And of course, both of them say that they do keep cash on hand. So they've got reasons for that. But we also can look at what came out yesterday was that Fani Willis paid Ms. Urity most of the time, she said, the vast majority of the time, for example, the condo that she stayed in, via Cash App, which would have created a trail, whereas she paid Nathan Wade, she said, just in hand. So how much does this delineation matter?
Well, I think she did say that she might have paid Nathan Wade also once or twice via Cash App, from what I can recall. But the next step would be for the defense attorneys to request those records, right there, because she said it. So now the next step is to try and get those records. They'll probably try and block that and resist them from getting those records. Nathan Wade's attorneys tried to block them from getting his business records, his banking records. But you know, this is what's going to prove the case. This is the evidence, right? The written records are the evidence because you know you have to be able to impeach their testimony. You know, they're saying this, but the records say this. So what's the truth? The truth is going to be the records. So if you don't have the records, you know, all you have is their word.
And the lawyers have subpoenaed Nathan's bank records. They've declined to relinquish them. So where does it go from there?
Well, I mean, they can try to get a court order for them to release the records. Now, subpoena, I believe the judge has already granted their motion to quash the subpoena, which means to refuse it, to say no, you know, you don't have to produce those records. But, you know, maybe at the end of this, he'll decide that it is important and it is key and we do need them, you know, after this testimony.
Yeah, and we were talking before during one of the breaks about the money that Special Prosecutor Nathan Wade was paid, saying that it came down to about $9,000. Can you tell us a bit more?
So, yeah, he said the $300,000 check was paid by the county to the law firm of the partnership that he had with two other attorneys. So once it goes into the law firm, he said it's not in his pocket, it goes to the law firm, and then it's divided up a third, and a third. So the third from that goes into his personal or his his sole proprietor practice. He has a solo practice as well. So it goes into that bank account, the 1/3. Then once he takes all of the expenses out of that roughly $100,000, he's down to $9,000. Now, I don't know what these expenses are that he has that are so significant that it brings it down to $9,000. But I think, this practice of, a third, a third, and a third is not common among attorneys, among law firms. Usually it's the person who brings in the business gets the bigger chunk of the money that comes in, and the partners get a smaller amount, a smaller percentage, or it just goes to the firm itself and gets recirculated into the firm. But whoever brings in the case is the one who gets the most money. That's usually how it works, and we haven't seen the records yet on that. And so they might request, law firm records.
What do you think that could yield? Why is that of interest? You said it's unusual. Is it worth looking into? Could they actually end up requesting this?
It goes to how much money he was paid in his pocket, how much money he received from this case, and then that enabled him to then pay for lavish vacations for her, in which she benefited from. So he's trying to say, I didn't really make that much money. I worked all these hours. I got very little money out of it. I'm not benefiting here. I'm doing a service, right? I'm helping to bring justice, to this case, and I'm not making much money for it. I'm just a good, honest working attorney. And she's saying, he was the best man for the job. I picked him. And, and he's doing a lot of work for us, and he's doing a good job, and we're trying to defend this, we're trying to prosecute this case against these criminals. You shouldn't be bringing us, you shouldn't be doing this to us, right? You shouldn't be trying to call us out and accuse us of something. You're trying to take the attention away from what's really at hand here, which is this prosecution of this big case.
Yeah, and you mentioned these trips in what you were saying just now. We spent a lot of time covering those trips. The prosecutors were asking questions of Fani Willis and Nathan Wade about these trips that they went on. Sounds like they went on a few trips. What happened with that?
What do you mean? What happened with that?
What came out of that line of questioning? What did we learn?
I think they were trying to learn whether or not she was helping to pay or not, because they're saying they're splitting it 50-50, but all the records show that he's the one that's paying for the trips. So the explanation is, I paid initially because I'm the one that has the connection with the travel agencies. She said he's a world traveler. He travels all the time. He always does this. So just let him handle it. Let him handle it. Let him pay for everything, and I'll just reimburse him. So that's they're trying to establish that he is the one that's paying.
And do you think the prosecutors are satisfied with that response?
You mean the defense attorneys?
Yeah.
The defense attorneys, well, again, where's the proof? Where's the proof that you are reimbursing him? They're trying to find out, where are the records? Can we get the records? It's just your word. And I don't know, how the judge is going to view that, whether he's just going to say, okay, you can't get anything else out of her. There's no records. She said this, and I have to take her word as the truth. That's the thing. You have to try and prove that she's not telling the truth. And how do you prove that if you don't have the records?
So another aspect of this, obviously we're looking mostly at whether she benefited and at the expense of taxpayers in this investigation, this aspect of the investigation. But another aspect is why, if the relationship, it's it's whether it started before in 2019 or after Nathan Wade was appointed, but it's also the fact that they didn't disclose that relationship, even if it did happen after he was appointed. Is she required to make that known? They both said that they were private people and that was their justification. You can understand it in a common sense, but in her high profile status, her role, is she required to make that known?
I don't know what the law is on that, whether that's a requirement or not. I think that in and of itself alone is not a problem to have a relationship with someone, but how it impacts your work and what you do is another story. So He said they were trying to keep it private because they couldn't go out and have a meal without people coming up to them and asking them all kinds of questions. And they had to travel, 4 or 5 hours away in order to have a peaceful lunch, And that's his and her explanation for that. And so it's not wrong to want to have some privacy, but when it becomes something that impacts your work and how you go about your work, and what kind of cases you decide to bring, then that's where it becomes an issue.
Well, thank you very much, Arlene. We'll be coming back with more legal analysis after the break.
Chief Division Counsel and DOJ have approved a no-knock breach. We want the subject to be on display, doing the walk of shame, full visual impact. Any questions?
Are we becoming a police state? We don't need to have a crime. What we need is a person to look at. And then we go find out what crime you did.
FBI! Our focus is shifting. Our main priority as a bureau is going to be domestic terrorism.
Really paints anybody who's right of center. If you're a pro-life, pro-family Catholic, they define you as radical.
These are anti-government.
We have freedom of religion and freedom of speech.
Violent extremists, and they must be dealt with. We can do anything we want.
This is such a gentle painting, so beautifully portrayed.
A group of people reading together in this simple, everyday-looking living room. A young girl reading along with an adult, a grandparent sitting in the lotus position, a businessman in his typical suit.
You see all those people, they look like they have quietly settled down there. And you as a viewer, it looks like you've just stepped in the door.
You can't see what it is they're reading, so you're a little bit curious and you're kind of invited to walk in.
This harmonious feeling is not by accident. It is the very subject of the work. The book they are reading is the main text of Falun Gong, which is an ancient Chinese spiritual discipline in the Buddhist tradition. At the core of Falun Gong are the values of truthfulness, compassion, and forbearance. Unfortunately, the practice is banned in China, where the artist resides. Thousands have been killed for their faith. Golden energy blooms into the room as a result of their steadfast faith. The painting on the back wall reminds us of this work's title, Plum Blossoms in a Muddy World.
It's also a metaphor for the practitioners that are sitting in the room as plum blossoms.
They signify perseverance and hope that all brutal winters end and life is renewed once again.
The magical painting.
Welcome back to our special coverage of the Trump trials. There's a lot happening this week, but to begin with, some breaking news just in this morning. Jailed Russian opposition leader Alexei Navalny has died, according to the Russian prison service. He was 47 years old.
The Federal Penitentiary Service said in a statement that Navalny felt unwell after going on a walk and almost immediately lost consciousness.
An ambulance arrived to try to resuscitate him, but he died. The cause of the death is still being established.
Navalny was a longtime vocal critic of Russian President Vladimir Putin. A Kremlin spokesman says Putin was informed of Navalny's death and that the prison service is investigating it.
So So big news there, and we will be keeping you updated on any revelations about the cause of his death.
And we're joined with us right now by NTD's legal correspondent, Arlene Richards. We're talking about the case in Fulton County, Georgia right now, the hearing that's going on there, focusing on District Attorney Fani Willis's relationship with Special Prosecutor Nathan Wade. The two are the ones leading the prosecution against former President Donald Trump and 18 other co-defendants. Arlene, we were talking before about the issue of taxpayer money being used to pay for, Willis's trips in her relationship with Nathan Wade, but you're saying that's not the biggest thing.
Well, the biggest thing is that they are taking advantage of this case. They're taking advantage of this case in order to get a higher salary so that they can benefit in this way in terms of these vacations. Yes, it's coming from the taxpayers' coffers. Taxpayers are the ones that, pay their taxes to the county, and so that's where the money is coming from. But I don't think that's the biggest point that's trying to be made. That is a point in the case, and it's bad. It makes it look bad. But the part that's a conflict of interest, that is what they're trying to disqualify them for, is the fact that they're benefiting.
So it's almost like the picture these defense attorneys are trying to paint is that Willis almost created this case in order to benefit. Is that what you're saying?
That's the way I see it. I mean, I think that's the way some of the legal experts are analyzing it. Some legal experts say that she didn't have to have this big of a case, that if she wanted to get Donald Trump, she could have gotten him back in 2021 when he had the conversation with Brad Raffensperger, which is, a big deal in this case. And why did she wait? Why did she conduct this huge investigation over, 2 years and wait until 2023 before she brought this RICO case and bring in all these other people and turn it into a conspiracy? Now, Fani Willis supposedly is known for doing RICO cases. This is her thing. And why is that?
And of course, she would say that she did say yesterday that people were saying that she should go for this, and she prayed, and that was about assuming the position, and she decided that was her role, that she should step up into this. I did say earlier that she campaigned on doing a Trump trial. I'm not too sure about that. Definitely Attorney General of New York, Letitia James, did, but her defense is that this is a worthwhile case. She hired the best person that she could find at the time for the job. That happened to be him. He's a good guy. He was a judge, had his own business, was very knowledgeable. It sounds like the way their relationship developed was that she turned to him for counsel, for advice, legal advice, for at least a year or so after they met in 2019, and that he became someone that she went to. Nathan Wade had said yesterday that perhaps due to the racial makeup of some of the other people that she could have turned to, that she felt safer going to him, or more comfortable going to him for her own advice. So it seems that she looks up to him. That did come across quite strongly in her testimony.
I think, you could argue that was because they were already in this relationship, that she felt so close and trusting in him and not someone else. Now,
potentially.
You mentioned earlier, about the racial aspect of it and her bringing that up. And, like I said earlier, according to one local defense attorney, there are several black prosecutors in the area who could handle this case. And she didn't have to pick him, if she wanted to have a black prosecutor.
But does she have to defend choosing him? I understand that he doesn't have as much experience as the other lawyers on the case, but
that's an issue the judge said was not an issue. So he's not allowing that to be an issue in this case. The fact that, or I don't know if it's factual or not, but the allegation that Nathan Wade has very little experience in prosecuting a case of this magnitude, let alone a criminal case. I believe his experience is mostly in personal injury, and then he was a municipal court judge, but he didn't himself, prosecute in this way.
And Arlene, we were talking before about why Fani Willis would have waited to bring this case in 2023. Of course, the 2024 election is just a few months away now. I've heard speculation about that being part of the reason why she might have brought this case in 23.
Well, Former President Trump has said, you know, it's election interference. He says that about all of these cases, these indictments that are against him right now, that they're election interference. Nathan Wade has tried to push this case to begin before the election, and Fonnie Willis as well has tried to push this case. They've said they could do it in 2 months. The judge doesn't believe that. I don't think anybody believes that that could happen. And the judge is not really inclined to let this case go forward so soon and let them say that it can be done in 2 months. Now, they've knocked down the number of defendants to, I believe, 15 now, because 4 have pled out of the case. I don't know what's happening with that, whether they're trying to get more of these defendants to plead out of the case. But they have 15 defendants. How are they going to handle that? It's going to be very complicated to handle that and get it done in 2 months, because if one person objects, you can have 14 more people object to something, and then you have to discuss it for each and every defendant. It's going to take a long time.
And we saw kind of the impact of that also on yesterday's testimony hearing, where each defense lawyer had questions for the defendants.
Yeah, and there was only 3 or 4 attorneys, 3 or 4 or 5 maybe attorneys in the courtroom yesterday. But if there's 15, you know, it's going to take a lot longer.
That's right. And we do have some highlights from yesterday's hearing for everyone to watch. We're recapping the hearing of focusing on District Attorney Fonnie Willis's relationship with the Special Prosecutor Nathan Wade in Trump's Georgia case. Let's watch a bit of a recap from yesterday.
Do you know if Ms. Willis and Mr. Wade started dating in October of 2019?
I don't know if it was October of 2019.
Could it possibly be November of 2019?
Could possibly.
Okay. And when we spoke, you said it was shortly after the municipal court conference, though, correct?
Yes.
Okay. So you know that their relationship, their personal relationship, began shortly after this municipal court conference?
Yes.
And when I say personal, romantic. I just want to make sure we don't get in an argument over what personal and romantic is later. When I ask you personal, do you take that to mean romantic?
Yes.
Okay. And do you understand it that their relationship began in 2019 and continued until the last time you spoke with her?
Yes.
And you were essentially her best friend during this time, right?
Not best friend, good friend.
Okay. Good friend. Okay, close friend. And so would you frequently socialize with her?
Yes.
And you saw her at work every day?
Yes.
So you had a chance to see them interact together on a personal level?
Yes.
And so from everything that you saw, heard, witnessed, it's your understanding that they were in a romantic relationship beginning in 2019?
Yes.
We just watched part of the testimony of Robin Bryant Yearty in the hearing focusing on the relationship between DA Fonnie Willis and Special Prosecutor Nathan Wade. She was talking about when that relationship started, which is really essential to understanding this case, and it's one of the key focal points of this hearing and these allegations against DA Fonnie Willis.
And as you mentioned earlier, what we saw just here was that Ms. Yearty believes that their relationship started shortly after they met in 2019. Ms. Willis did spend some time yesterday sort of defending her reputation about how soon after she would be likely to enter into an intimate relationship with a man, and in regards to Nathan Wade, suggesting that the defense lawyers who were questioning her were maligning her reputation there. But it looks like Ms. Yearty had said that they started dating shortly after they met, however long that is.
And she said, I think it's important, she said she's certain that the relationship started prior to November 2021. It sounded like they pressed her in from multiple angles, and she was expressing a strong degree of clarity surrounding that.
Yeah, and she's also said that she's witnessed it, right? She's witnessed them being affectionate in public, at public settings or social settings. They were friends, they were good friends, she says. She says they were good friends. And so when they were good friends, they did things together, you know, her with her husband and Fonnie Willis with Nathan Wade, likely. I mean, I don't think she said that exactly, but, you know, they did things together as friends. And so now, even though they're not friends anymore, it doesn't cancel out the fact that they were, and there was a time when she would have seen this.
And that is contrary to Ms. Willis's testimony, saying that they basically just partied together as girlfriends would in a group.
Yeah, she characterized it as they met in college and they kind of hung out together with other people.
And went to different colleges.
Went to different colleges, and then they didn't communicate for a while. You know, yeah, so she made it seem like it was less of a good friendship.
It sounds like we're picking up feed from the courtroom there.
All right, as you can see in the box just here, it looks like they're still on a break, but we may be coming back soon to that. We are waiting for Mr. Bradley, which is Nathan Wade's divorce lawyer, to appear, and we heard earlier that he would be appearing at around 10 or 10:30 Eastern, which is, it's 10:35 now. That was Mr. Ward. Bradley's counsel showed up this morning to alert the judge of that.
Yeah, and it's interesting because we were expecting DA Fonnie Willis to continue her testimony today. She testified for an hour or more, maybe a few hours yesterday. And we were expecting her to continue her testimony this morning, but we haven't had that. So we've been discussing the case since then. My understanding is that Terrence Bradley, the business partner of Nathan Wade, was supposed to testify starting at 10:30, but he was at a doctor's appointment. Maybe he was anticipating that Willis would testify first and he'd have some time, but yeah, now I guess he's being rushed in.
I think there was some question as to whether they would be bringing him back or not, because there's this whole issue of the attorney-client privilege and what he's willing to testify to, which is kind of a problematic. And I'm not sure they've taken care of that yet or not in terms of having arguments about this attorney-client privilege and what he can say and he can't say. But Nathan Wade has the power to lift that, and he said he's absolutely not going to give that attorney permission.
Yeah, it sounded like they were going to try and work that out, parse that out this morning. I'm not sure if they would be doing it in the courtroom or behind closed doors.
It should be in open court.
Yeah.
There was an argument by President Trump's attorney about it, and the judge said he hadn't had an opportunity to look at all the different laws that are involved, the different rules. So I don't know if he's done that now during this break, and maybe he'll come back.
And there was another phrase used this morning in regards to Mr. Bradley, which was competencies and secrets. The audio feed was quite narrow and was quite low at the time, but is that something that relates to attorney-client privilege?
I'm not sure. I didn't hear it, so I'm not sure what that means.
Okay. Basically, the judge was saying, or the lawyer was for, I believe that was Mr. Ward, was saying that, no, the judge was saying this thing is not contained in attorney-client privilege, competencies and secrets.
There was something that was brought out yesterday in terms of conversations that Nathan Wade had with Terrence Bradley. And he said, and when you talked to him about that, was that attorney-client privilege? I don't remember what it was, what the subject was. And he said no. So now President Trump's attorney is bringing out that not every conversation they had was attorney-client privilege. There were some things they talked about that were not. So he's trying to parse out the differences, right? And so these two rules that they're referring to, attorney-client privilege, and I believe there was like a rule 1.6 or something
yes,
the
1.6.
judge mentioned, which is a local rule there that I'm not familiar with. But under that rule, I suppose there are some things that they can talk about. And so they're trying to parse that out.
So
they haven't done it yet, because I think the judge said he had to like review it a little more.
I see. So it's potentially that, you know, Mr. Bradley is on his way now from his doctor's appointment, as outlined by Mr. Ward earlier this morning. He could arrive and parse this out, this definition of what's attorney-client privilege with him at the stand. With each question by question as it kind of began that way yesterday.
That might be how the judge handles it, or the judge might flat out say, okay, these are things you can talk about and these are things you cannot, and then they'll proceed. So we'll have to see. And then if he's reluctant to answer, then the judge will have to decide whether he's going to order him to answer or impress upon him the importance of him answering the question.
Which he likely will be, as you said earlier, that he may have been pressured, is that right? He may have been pressured and from his colleagues and now is no longer a willing testimony giver. There was there was a definition
zoom out
just about...
and look at the at what's at stake here, the big picture. For DA Fani Willis in this hearing?
So for her and Nathan Wade, this hearing is all about disqualifying them from this case, from this huge, case that was brought against 19 co-defendants. If she and Nathan Wade get disqualified, who's going to take over the case? There's been a past disqualification, and that case is still in limbo for 18 months now. They haven't gotten a replacement. And then there's the question of, even if they get another prosecutor, that prosecutor has to get up to speed. There's a lot that person or those persons will have to do. Now, they have other prosecutors on the case working with Nathan Wade, and perhaps one of them could take the lead, and then they will be up to speed already. But if none of them wants to take the lead, then they have to find someone who does want to do that.
And that could be another 18 months potentially if you're comparing it to the other case.
We don't know. If they find someone right away, but that person still has to get up to speed on the whole case. Yeah, so that could take some time.
And Arlene, I'm being told we are joined by Mike Lee, the host of the Can We Please Talk podcast. Mike, thank you so much for joining us. We want to focus. We want to focus on the New York civil fraud trial. We're expecting a verdict from Judge Engoron today. Talk about this.
Yeah, so this is obviously the civil trial that's been going on about his business dealings. Obviously, for people that are not been following this, look, it's tough to keep up with all of this stuff. There's civil, there's federal charges, there's state charges in Georgia. And so what's at stake today in Manhattan is really around his business dealings. He could face a massive fine, upwards of $360 million if they rule against the former president, in addition to what he's already having to pay with the E. Jean Carroll settlement that happened a couple weeks back in the $83 million lawsuit. So that's really what's at stake, and the potential for the former president to not be able to conduct business in the state of New York.
And I'm sorry, that's Mike Leon, host of the Can We Please Talk podcast. These charges, these numbers they seem big at first glance. Can you talk about the scale of this?
Well, it's a wide scale because Letitia James, who's the Attorney General in New York, these are charges that happened, I believe, about 12 months ago or so, where her office kind of put this together. Again, this is separate from the Alvin Bragg case that's happening on March 25th that just got announced yesterday about the trial date and that starting. That's something completely different. So again, and that's obviously criminal charges. This is a civil matter with respect to what's happening here. So the wider implication is really on the business dealings for the former president. It's the inordinate amount that, he would have to pay. Does he have I don't know, many people that have $367 million on hand, in addition to $83 million that they just got hit with a couple weeks back in a lawsuit settlement there with E. Jean Carroll. Not a settlement, excuse me, a decision. But so there's a lot at stake here. But the biggest thing on the civil part of this is to remember that these are civil. This means money will be exchanged, and the former president will have to pay these fines in accordance with whatever the court has or whatever he sets up from a payment schedule. So that's the real big takeaway for whatever comes out of today's decision.
And Mike, like you mentioned, the $370-something million is not something everyone has just lying around. And even for a billionaire, that's still, that could be a lot of money. Can you talk a bit about what that kind of cost could mean to former President Donald Trump?
Well, I mean, for people that don't know, when the former president came into office, obviously he disassociated himself from his business dealings. So, which was something that, he turned over to Don and Eric in terms of running the Trump organization. So he had to disassociate that when you become president of the United States. Now that he's back to being a private citizen, he's working at the organization, but also you have the campaign part of this, which is the campaigns raising money to be able to obviously do all of these appearances and push out all these messages to prospective voters, Republican primary voters. So, like you said, Chris, I wish I had 367 million lying in my mattress somewhere. That is a huge fine for anybody to undergo, take. And so how money would be shifting from the former president to be able to pay for some of this is something we really don't know. I don't even think the former president may know. People maybe close to him that are accountants and stuff like that would have to figure out how they would go about paying this. But the bigger implication is, after you get past the money part of this, is really the business dealings, because anybody that knows the Trump organization, or at least knows not only from the hotel and what he does from a licensing perspective for his name, but then the properties management business that they have. They're in the golf business as well with some of the properties that he owns. Some of those are located in the state of New York, and a lot of the money comes from the state of New York. So this would have a trickle-down effect for employees of the Trump organization that operate in the state of New York.
Yeah, and to your point, what could it mean for other businesses? Could this change precedent in any way?
Well, I mean, if somebody from that business is running for office, right? I mean, it could, but also we'd have to see what comes out of this. Like we said, a lot of moving pieces. I can't get into Letitia James's head or even Alvin Bragg's head at the local level. So I would think that other folks, once the president, the fine is levied, other folks would kind of look at their books a little bit more closely. But again, this is such a unique case because we have a former president of the United States that at the time in 2016, was operating a business and then became president of the United States. Now he's running again for another 4 years in office. So it's very unique, the circumstances, at least around the individual that's being charged in this civil matter.
And let's look at what Trump is saying. Can you tell us a bit about how he's commenting on this?
Yeah, well, I think for the former president, look, these are free campaign stops. I mean, he's mentioned this before, that like a lot of his campaigning has been done outside of a courtroom. Well, guess what? I mean, this is free for him. Like, this is free pub. There's no such thing as bad publicity, right? All of the cameras are there. Reporters from major outlets, including this one, are there covering this, listening to what it is that he's saying. And I think the biggest thing, though, and takeaway, again, for how you feel about him politically, I think he needs to start addressing not only the cases themselves individually, but stop repeating some of the talking points that he's saying. Save those for the campaign trails where you're around your voters. This is the time right now to kind of get in front of why you feel some of the charges are wrong, get into the case specifics, get into some of the things that his lawyers have argued in court that maybe have fallen on deaf ears for the judge. I would, if I was advising him, again, I'm not, if I was advising him, get in front of some of the case particular matters and save some of the campaign messaging for when you actually go on the trail and you're speaking to Republican primary voters that do you want them to come out and vote for you in the primaries?
And Mike, you mentioned these particular matters. Can you reiterate some of those for us?
Yeah, so again, a lot to cover, and you can check out Can We Please Talk podcast. We cover a lot of this. Obviously, I just had one of former Trump's attorneys that handled the Mar-a-Lago case. So again, four jurisdictions, 4 cities. You've got federal trials that would happen in D.C. around the retention of classified documents in the Mar-a-Lago case. You have the January 6th stuff, which is obstruction of an official proceeding that happened there. So those are 2 separate cases, again, happening in Florida and D.C., but in the federal courts of both jurisdictions. In New York, you've had civil matters. So you've had the E. Jean Carroll civil suit that happened last week and the judgment that came out of that. You have today with the business dealings of the Trump organization and what will come out of that. But then you have on March 25th, which is Alvin Bragg, and that's a criminal charge with respect to the hush money payments that were made on behalf of the former president to Stormy Daniels in that case. And then last but not least is what we're kind of watching from the Georgia perspective, which is the RICO case where 19 co-defendants, including the former president, were charged in this conspiracy to, overturn the results of the Georgia election. And that involved the phone calls that the former president made to Secretary of State, then Secretary of State Brad Raffensperger, about trying to find 11,000 or so votes. That case, the reason why we're watching it today is because the District Attorney Fani Willis and Nathan Wade had an inappropriate relationship. He was a special prosecutor, appointed by her in terms of handling this case and kind of bringing all the evidence together and helping with the charges. They had an inappropriate relationship. They didn't go through the proper paperwork of disclosing some of that. There were some payments that were made, trips that were taken by the two of them. And so that's why we're hearing today a motion that was brought together by one of the defendants that was charged in that RICO case, in addition to the former president's lawyers that are piggybacking on this, that are saying that they should be disqualified from presiding over the case themselves, or their office handling the case themselves. And if the motion is upheld in this regard, it's going to be damning, because for Georgia, they're going to have to find a new prosecutorial office that will oversee this case, and that's going to delay this case. And Fani Willis has been wanting to bring these charges before November, which is the goal of a lot of these prosecutors. Let the voters see what happens to the former president in court before November. But as lawyers have told me, including ones that are defending the former president, there's a lot of paperwork and a lot of moving pieces that you'd be hard-pressed to have any of these trials start on time.
And Mike, do you think that DA Fani Willis will be disqualified based on what we've heard so far in this hearing?
Well, I mean, it's very tough, because Judge Scott McAfee yesterday, they took a couple intermittent recesses there. If you noticed, there was points of contention when Fani Willis was talking about, that she's getting lied on and stuff like that. I think I mentioned yesterday to Steph that there was a discussion from when Nathan Wade was being questioned, but he was being questioned by an attorney that was representing him in his divorce proceedings previously. A lot of moving pieces here. I just don't know. Again, there's the legal part of this, and then there's the political part of this. From a legal perspective, I don't know if there's enough, having talked to folks in the legal community, including ones that have worked in the Georgia prosecutorial office. I don't know if there's enough to disbar her or disqualify her, from this case. Disbarring her would be totally different. In terms of the political matter, though, this is ammunition fodder for the former president, for Republicans in the state of Georgia. We've seen Marjorie Taylor Greene mention this. It's tons of fodder for them to be able to use to say, look at how politically motivated some of these charges are, where you have an office that doesn't even have their ducks in a row because the prosecutor in the case has a relationship with the special prosecutor that she appointed and is making payments to. So it just looks messy. It looks terrible. And there's a lot of reasons why people did not want Fani Willis's office to bring these charges in Georgia, mainly because of this, and mainly because a lot of the stuff is covered in Jack Smith's indictments.
Mike, Fani Willis showed up to testify yesterday with a lot of heat in her voice. It was quite dramatic. Can you comment on that?
Dramatic is an understatement, Chris. I mean, look, there's two things to this. The first thing is that if for anybody that was not watching it yesterday, she was watching the proceedings take place from her office. She was not scheduled to be called as a witness. She was watching it from her office, just like we were watching it. She went down to the courthouse and decided to testify. So she didn't have to. So she went there, guns blazing, came in with some paperwork, some markings, said that some of the things were being lied on. So it was kind of a surprise to everybody to see her in court. So that's the first part. The second part of this is, look, Fani Willis, you decided to engage in this relationship, not us. You can't blame the defense lawyers that are bringing this motion, because you were the one that was carrying an inappropriate relationship. You knew that this was inappropriate. You knew that you had hired this person to kind of help with gathering the evidence and charging the co-defendants in this RICO case. This is all of your doing. So to get mad at people for something that you caused is wild to me. It should be wild to anybody watching this. And again, it gives the allure and appearance to the former president and the co-defendants that are charging this of like, this is improper, right? So what else could she have swayed, or the prosecutor in this case, Nathan Wade, what else could she have swayed him in terms of charging these co-defendants? Now, to her testimony overall, again, legal, political. the problem is that we're losing sight of the 19 co-defendants and the RICO charges. We're losing sight of when this case will actually happen because we're dealing with this. And so the political part of this, it gives the ammunition to the former president to say, look at how politically motivated this is. Look at what's happening in Georgia with Fani Willis.
Mike Leon, thank you so much for your insights on this one. Host of Can We Please Talk podcast. Thanks for good to see you today. We're going to tune back in to the courtroom in Fulton County, Georgia. Let's check it out.
And it looks like Terrence Bradley still hasn't arrived yet, so defense lawyers are planning to call other witnesses instead. We're just seeing that all take place. You can see many lawyers and other witnesses all lining up behind to observe. And we'll see who is called to the stand first, but it does look like it's possible that Fani Willis's father will show up today to give testimony. He is actually also a lawyer and a criminal defense lawyer. So that's how Fani Willis found her interest in law, attending, according to the Atlanta News outlet, attending hearings on weekend mornings and deciding to continue in her father's footsteps after that. Of course, Fani Willis gave testimony yesterday about
Ms. Cross,
her
assuming
father.
This may be a 10 to 15 minute witness. Does the state have other witnesses on deck that they'd like to go forward with as well?
Yes, we called to gather everyone we could, so we can go forward with another witness, I believe, after this.
All right, appreciate it.
Right, so we're back to the courthouse in Georgia in the case looking at the hearing today, looking at the relationship between Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade. We do have a witness taking the stand today. Let's find out who that is.
I do.
Okay, former Georgia Governor Roy Barnes.
Eugene Barnes. Royeugene. Barnes, B-A-R-N-E-S.
Say, good morning, Mr. Barnes. Can you tell the court a little bit about your background as it relates to your service in public service?
I was first elected to the state senate in 1974 from Cobb County, and I served 16 years there. And then in 1990, I ran for governor and was defeated. And 2 years later, I went back to the House of Representatives. I was elected to the House of Representatives and served 6 years until I was elected governor in 1998, and I served in that position until January of 2003.
And after serving in the position of governor, can you tell the court a little bit about what you transitioned into after your public service?
I did exactly what I was doing before I was elected. I went back to practicing law in Marietta, Georgia, with my daughter, who's now a judge of the state court, and my son-in-law. And now we have, I think, 6 or 7 lawyers. Charlie Bailey back there was one of them at one time.
Okay. And Governor Barnes, would you consider yourself to be a trial lawyer?
Yes. We don't write contracts or we don't write wills. All we do is try cases.
And I want to direct your attention back to 2021, where you were approached by the District Attorney of Fulton County, Fani Willis, about being a special prosecutor.
I was. I don't recall the exact date, but I know it was sometime in 2021. And she asked me to come down, and I met with her and Nathan Wade, and there were several other in the meeting. She asked me, said they were beginning this investigation, and she asked me if I'd be interested in being special prosecutor, to which I replied that I had mouths to feed at a law office, and that I would not do that. And also, I just had a bad, well, I won't say bad because it happens from time to time, but I just had a FBI to report a fella, a militia trainer, to me that said they were concerned that he was making threats against me, and because I thought it was because of the flag, but I asked him and he said no, it was because I was too close to the Jews, quote unquote. And I told D.A. Willis I'd lived with bodyguards for 4 years, and I didn't like it, and I wasn't going to live with bodyguards for the rest of my life.
Ultimately, you turned down.
Yes. Yeah, I told her. I said, I'm not interested.
Nothing further from the state.
Ms. Merchant.
Morning, Governor Barnes.
Morning.
How are you?
Just fine. How are you?
Good to see you.
Good to see you.
You said it was sometime in 2021. Do you remember?
I think it
early?
was. I don't remember the dates. They all go. I could look it up on my calendar at the office, but I don't have that.
Well, I want to ask you about some statements that Ms. Willis made March 28th, 2021. She was talking about assembling a team for this case. Are you familiar with her work assembling a team for this case?
Well, I assume that's what she was talking to me about. But besides that, I don't know.
And I know you had said you had a meeting with some folks, and Mr. Wade was at that meeting?
Correct.
Okay. So he was with the district attorney interviewing you about taking this case?
Well, of course, I know Nathan very well, as you do.
Yes.
And I exchanged pleasantries with him, but the conversation was with Ms. Willis.
Okay, with Ms. Willis. Were you aware at the time that her team consisted of Brian Watkins, Megan Vargas, Sonia Allen, Shannon Trotty, Sal Chan, and John Floyd? She had reported that was her team on this case.
I know John Floyd was involved, and she probably told me the others, but listen, I barely remember what case I tried last year, much less every word that was said in the conversation.
I understand, fair enough. But she said she was looking to hire more lawyers and investigators to work on this case?
She told me, it was to me, she said, would you be interested in being special prosecutor in this case? And I gave the reply that I've already known. I mean, about hiring other lawyers or whatever, I don't know. All I can testify to is what she told me.
Did she tell you at all why she wanted to hire special counsel and not use someone who was an ADA, not have an actual employee?
No, she did not. I mean, we did not discuss that, and but I would assume it was because in a case as big as this that you'd have to have some decision help. I know John Floyd has been in some cases over the years out in Cobb County, for example, and others.
Would you agree that an employee of her office, someone who was paid a state salary or a county salary as an ADA, could handle a case like this?
I couldn't tell you that unless I knew the person, knew their experience, and really had been with them in a courtroom.
All right.
Has an opinion on that.
Thank you.
Yes, ma'am.
Say no.
Hello, Mr. Sadow.
It's been a while.
It has been a while.
I hope you're well.
I'm doing fine, just getting older, but that beats all time.
That's true, but that applies to all of us, I believe.
Yes.
I think you indicated that if you had your calendar, you'd be able to pinpoint a date for us.
I would.
Is there a way for you, for example, at a break, before you actually leave, to contact your folks to see if you can get a date?
I guess I could. I don't know how far back we archived those, but I assume I could.
Would you be willing to give that a shot for us?
I mean, I'll do whatever the court instructs.
So if I ask the court and the court says go ahead and you could do it, that's all right?
I'll do whatever the court instructs.
I hear you.
And you should too.
I try to live by those words. I'm not always successful, but I try. If I pinpoint a date, for example, I think the record is clear that Mr. Wade was hired for the position on November 1 of 2021. Does that help you at all?
No, it does not.
Okay. Then let's go to the meeting. It sounds like it was just one meeting.
Yes.
And could you tell us where that meeting took place, if you remember?
It was in the conference room adjacent to the district attorney's office.
So it was in this, or the adjoining building?
It was in the Lewis Slayton building.
And District Attorney Willis was there, obviously, right?
Yes. Yes.
And Mr. Wade was there?
The best I recall, now I could be mistaken about that, it's like anything that far away, but that's my recollection.
Do you have a recollection of anyone else being present?
Yeah, there were some other folks, but I don't remember.
Do you remember, were you introduced to Mr. Wade by anything other than you already knew him? Was he given a title or anything? So at least as you're there, if I heard you correctly, Miss Willis did all the talking, Mr. Wade did not.
I mean, we exchanged pleasantries, but as far as the basis of the conversation, the reason I was there, Ms. Willis did the talking.
And would you be able to give us an estimate how long this meeting lasted?
Probably,
just rough.
Probably an hour.
And during the meeting, you made it clear, but it was the thanks for the offer, but no thank you.
Oh, yes, I did. As I said, I started off as a prosecutor, and for about 10 or 15 years, I did nothing but criminal. And then, but I've tried to move away from it and do primarily civil now. Mr. Gillen and I have done some white-collar cases over in federal court. I've got one over there right now. But it's generally business related, where I have a client that's got a kid or him getting indicted. And the case I have over there now is an alleged fraud case.
Fair to say that based on your career and the work that you've done, you've handled high-profile cases, correct?
I have. I've handled some pretty good cases. I sued Syria one time for beheading a client of mine, recovered $82 million. I guess that's the best high profile, but that was in D.C. I tried that up in D.C.
And what would be considered complex cases, you've handled those as well, correct?
Yes. I mean, we regularly do mass torts, class actions, business torts, breach of contract, and most of those are complex, requiring many experts. We also do malpractice. I did malpractice defense for about 25 years, but since I've returned from the governor's office, I try not to represent an insurance company anymore, and I just tried a malpractice case before Judge Edlin in November. And those are complex cases because of the type of, medical knowledge and that you have to have, and also because of the many experts that you have.
Thank you. Did Miss Willis, and this is the last question, did Miss Willis tell you why she had sought you, why you had been her choice?
No, I hadn't, but, I get consulted fairly often on major cases.
Would you believe, based on circumstances in which you were given the offer, that it had to do with the fact that you had handled complex and high-profile cases in the past?
It could have been. I know her very well. I tried a case against her. She worked for the JQC, and I represented Judge Robert Crawford, Mac Crawford, and she prosecuted him, and I defended him. She beat me at the trial. I turned it around at the Supreme Court.
So you had some experience with
I had plenty of experience with it. She's a very qualified young, well, everybody's young to me, but she's a very qualified young woman.
After that, that one occasion.
And we are turning now to criminal defense attorney David Gelman. David, thank you so much for joining us to reflect on everything we're seeing now. In the Fulton County, Georgia case, there's this hearing focusing on DA Fani Willis and her relationship with Special Prosecutor Nathan Wade. Currently testifying, like we were just watching, is former Georgia Governor Roy Barnes, who served from '99 to 2003. What are we learning about him so far? We're just getting started with that testimony.
Hi, Chris. Well, number one, thank you for having me. And what are we learning? We're learning what a attorney or what an individual should actually be doing on the stand when testifying. Now, this gentleman, Governor Barnes, is doing what I like to call a master class on the stand. All right. He's calm. He's collective. He's a gentleman. All right. He's answering the questions that are being presented. He's not being argumentative. He's not wishy-washy. He's not saying I think or maybe or giving questions back. He's answering them to the best of his abilities from what I can see. All right. He's being kind, polite, cooperative. That's everything you want. All right. You can look at his demeanor, and demeanor is everything when you are a witness in a trial or in a hearing. And this is perfect. This is a 180 from what Fani Willis was yesterday, obviously. And so this is a welcome, if you will, for the judge and for both both parties, or the defense and the prosecutor, or the plaintiff, I should say, for Fani Willis's hearing for today.
Yeah, and you mentioned Willis's testimony yesterday. What's your synopsis of that? What's the significance of the nature, the attitude in her testimony?
I don't think we have enough time. It was horrible. I mean, I don't care if you are a Republican, a Democrat, whoever you are. The testimony yesterday was beyond horrible. How she is a prosecutor, a DA, is you cannot possibly explain. The rules of professional conduct just alone boggle my mind. Just again, she should know more than anybody else. Being the prosecutor of a county, you have to hold yourself to a higher standard. All right. I was a former prosecutor, and I was always taught that you never lose your cool. She lost her cool the second she sat on the stand. All right. She had an attitude walking in. I don't know if you caught this, Chris, but when she sat on the stand, she gave a wink. I don't know who she gave a wink to, whether it was a bailiff or another attorney or whoever.
Yeah.
But that just didn't sit right with me. And then she just had an attitude the whole time. She was being very combative, and it was a circus. And I commend the judge yesterday, really, because the judge, he really kept that courtroom in as well as he possibly could, because it really became just like a Jerry Springer show, if you will. And it turned out incredibly bad, I want to say, for Fani Willis. And the judge really let her go on. And I think he did that because he wanted to create a record. Because I think what's going to happen, because of what she did yesterday and because of what Mr. Wade said and their inconsistencies, I think that she's going to be disqualified. And by the judge allowing her to go on and ramble on and just be very combative with everybody, including the judge, by allowing her to say that he made a record in case that she appeals, which most likely she will, in the event that she is disqualified. So the judge, I thought, did an excellent job yesterday.
And was there anything else we saw yesterday besides her conduct that leads you to think that she's going to be disqualified?
Yeah, there was a lot.
Yeah.
Number one, the the whole cash situation where she mentioned multiple times regarding that she has all this money stashed away, and she was talking about also campaign violations. I don't know if you caught that, but she was talking about during a campaign where she actually said she took money from a campaign and put it into personal accounts. That is called a campaign violation. She's literally going after Donald Trump for that reason. So besides that, and then talking about, well, she didn't talk about this, but a friend of hers or a former friend said that her relationship with Mr. Wade started in 2019, not in 2022, as Mr. Wade and her are stating that it actually did. Well, if that's the case, then her and Mr. Wade are both going to be in a lot of trouble ethically, potentially criminally. So, Chris, I would not be surprised at all, number one, if both Wade and Fonnie Willis are both going to be disqualified from this case. But number two, I have a feeling that the ethics committee of the bar of Georgia are going to be looking after these people very, very thoroughly now. And after that, I think criminal charges are going to be going to go after Fonnie Willis for some campaign violations, but potentially for some money laundering issues, because there's no reason that to be where's a prosecutor getting all this type of cash? I know what prosecutors make. They're not making a lot of money. I was a former prosecutor. I didn't make a ton of money back then. So I don't think she's making this type of money where she's carrying around thousands and thousands of dollars. This is very, very fishy, and she's being a little too loud, if you will. And when I say loud, I mean flamboyant. And when you're doing that type of stuff, you're going to get caught eventually. And I think by her testimony yesterday, it's putting a nail in the coffin.
And our legal correspondent, Arlene Richards, was saying before that she was actually disqualified from a previous case. Do you know anything about that?
So I know that is being reported. I do not know all the details about that, so I don't want to speculate about anything, but I do know that has been reported. And look, it wouldn't shock me at all. Frankly, her demeanor yesterday was an abomination, especially as a chief law enforcement for the Fulton County. So for her to be disqualified from another case, I wouldn't be surprised one bit.
How does her demeanor reflect on the Trump Georgia case?
Well, if you remember, Chris, she campaigned specifically on on pretty much getting Donald Trump, right? So if she is campaigning on that particular reason, and now looking at what she's doing in court, being again the chief law enforcement officer for Fulton County, Georgia, where you have a higher standard, whether you like it or not, to act in a court, just in a different light than other individuals. All right. And remember, Fulton County is a very large county in the state of Georgia. You have a lot of individuals looking up to you. Her office has hundreds of other attorneys that work for her. So she has other individuals that are looking at her. So are you going to tell me now that these other attorneys who are working for her are going to be acting in the same light as her in court? Other judges are never going to stand for this. I mean, the Attorney General's office, I guarantee you, are going to have to step in on this immediately if she's not disqualified. And frankly, the Governor Kemp, I guarantee you, him and his legal team are going to be on this. They have to be on this, because if not, this is becoming a total mockery.
And David, can we talk about the verdict in the New York civil fraud trial? We're expecting to hear that today.
For Donald
President
Trump,
Donald Trump, yeah.
Look, I don't think it's going to be a surprise of what's going to happen. I think we all know what's going to happen. Donald Trump is most likely going to be found guilty of that. Erdogan is not a fan. We see it, we've seen it multiple, in multiple instances. It looks like he's going to take the licenses of President Trump and the Trump organization away. Well, he's going to try to, and he's going to fine him hundreds of millions of dollars, which is unprecedented. All right, this is a total sham. Now, I believe that this will be appealed immediately because this has never happened in the state of New York. Nothing of this magnitude. And again, there's not even a crime that's happened here. All right, and even you can go civilly or criminally, whichever one you want to go at. So nothing has happened. So I don't really understand how this is even, how Erdogan has even gotten to this point. But we all know that this is going to, that Erdogan, where he's going to go here. Nobody's surprised. In fact, even his attorneys, I know have been on different shows over the last couple of nights and have even said, if they could appeal it before the decision comes out, they would. So nobody is surprised. This will be appealed. I don't know when the decision will happen, but everybody's saying it's coming down today. But again, there has not been a victim in this. In fact, all the testimony that has come out has been from the banking institutions, where they have even said that Donald Trump and his companies not only have paid on time, but they paid with interest. So they've made money. So again, there hasn't even been a victim in this.
David,
again,
what could come out? What could come out of any appeal in this New York civil fraud trial?
Well, there's a couple things. Number one, I think that there's going to be a reversal. But number two, I think that there's going to be some discovery issues that will be coming out, but that could potentially, and look, again, I'm speculating, but I think that there could be some political malfeasance that could potentially come out of it, that might be able to show that, there's a little more to this than meets the eye. This is just something that, that's never happened in
David,
state.
we have to wrap up now. We have Fani Willis's father about to testify. Thank you so much, criminal defense attorney David Gelman.
Thank you, Chris.
Can you tell the court a little bit about, did you work in the legal career? Were you a lawyer?
I was an attorney. I practiced law. I've probably tried 1,000 cases. About 50% of my practice was criminal law. 25% of it was family law. And the rest was whatever walked through the front door could pay for it.
Okay. And
could we wait 1 second? If the governor's come back, he might have.
I do. My calendar shows it was October 26, 2021.
All right. And would defense counsel accept it as a stipulation, or is there any follow-up questioning needed on that? Mr. Barnes is still considered under oath on this point. All right, I'm just going to look for a show of hands or for someone to speak now on Zoom, and hearing none. Thank you, sir. You're excused.
And, sir, can you tell the court, are you from Atlanta?
No, I grew up in South Central Los Angeles. I spent most of my legal career, I would say, in Washington, D.C. was kind of the circle, but I've tried cases all over the country, and I tried the longest. I was the first lawyer to try an international criminal court. I was with the International Criminal Tribunal for Rwanda. I was in trial there for 4.5 years in Arusha, Tanzania, and Hague in the Netherlands.
Okay. And when you weren't there, it sounds like your kind of center of gravity was Washington, D.C.
Correct, but I've tried cases in West Virginia, Maryland, Florida, California.
All over.
Yes.
And do you, sir, can you tell the court, do you have any children?
I have one daughter, Fani Willis.
Okay. And I want to direct your attention back to 2019, okay?
Yes.
Back in 2019, can you tell the court, did you move here to Atlanta?
I was living in Johannesburg, South Africa. And unfortunately, for some reasons, I could not get an extended visa. When I retired from the practice of law in 2018, I moved to South Africa, and I had to leave South Africa, and I did then come to Atlanta.
Okay, and do you, sir, remember about the time period in 2019 when you moved in with your daughter here in Atlanta?
It would have been the spring or summer of 2019.
And after you moved here, did you get a driver's license to kind of confirm your residency within Atlanta?
Well, my driver's license for the District of Columbia was going to expire on my birthday, which is in October. And yes, I did get a license here in the state of Georgia.
Your Honor, may I approach the witness?
Yeah.
If you could just take a look at what's been marked as Stacey's.
Okay, Your Honor, would you, if you don't mind, my eyes are very bad, which is one of the reasons I retired, and so I need a magnifying glass, so I'll be constantly. Thank you. Yes, I see it was issued on 9/28/2019.
Okay, so before we get there, do you recognize State's Exhibit 2?
Yes, just my driver's license.
Okay. And is State's Exhibit 2 a fair and accurate copy of your physical driver's license?
Absolutely.
This time, Your Honor, the State would tender what's been marked as State's Exhibit 2 into evidence.
Seeing no other objections, it's submitted. State's Exhibit 2 is submitted for the record.
Now, and for the record, Your Honor, the State is going to supplement State's Exhibit 2 with a redacted copy of the license. The current copy is not redacted, with the address and things of that nature.
Right. And do we need to mark that differently in any way?
I will mark it as State's Exhibit 2A.
Perfect.
Now, you talked about when your driver's license was issued. Can you tell the court when was that driver's license here, your Georgia driver's license issued?
It was on 9/28/2019.
Okay, so September 28th, 2019. Now, when you moved into District Attorney Willis's home, who lived there?
Well, my daughter lived there. I lived there, and from time to time, my grandchildren would come.
Okay, and did your grandchildren, were they at school coming and going?
Exactly. I think they were in school in various jurisdictions.
And during the time, how long did you live at or with Miss Willis and at her home here in Fulton County?
She was forced to move after she was elected. I don't know if you want me to go through the whole thing, but that, Your Honor, if Your Honor will indulge me. After she was sworn in on January 1 of 2021, and on or about the 3rd of February, at probably 5:30 a.m. in the morning, there were people outside her house cursing and yelling and calling her the B word and the N word, and just, it was bizarre. Okay,
Sorry? Pause, sir. Mr. Abadi. Here's the objection to you.
I would say it's effect on listener. He was present while all of these things were occurring, but I can.
No, that's. And he's saying he was personally present to hear these things?
Yes.
Okay, overruled.
Okay, and fortunately, the neighbors called the police and disbanded the group, and it was just, I hadn't seen anything exactly like it before.
Okay, and after that happened, can you tell the court, did Miss Willis have to move from her home?
Yes, she was forced to leave.
Okay, and can you tell the court, after she was forced to leave, shortly after she was sworn in, did you remain at her home in Fulton County?
Yes, I stayed there really until 2022, I guess.
And from what you described, did you fear for her safety?
Absolutely. Not only did I do that, I mean, the South Fulton police, they brought somebody, a man with a dog, because there have been so many death threats. And they said they were going to blow up the house. They were going to kill her. They were going to kill me. They were going to kill my grandchildren. I mean, on and on and on. It just, it became, and I was concerned for her safety.
And after those concerns came to your attention, and after what you heard and saw that day, you remained at the house?
Yes.
And can you tell the court, with what you just described, why did you remain living at the district attorney's home here in Fulton County?
I'm sorry, I don't see how this is relevant.
Mr. Bond?
I believe it's relevant based on a lot of the questions that were asked yesterday of Ms. Willis as to about the security threat and the fact that it was implied that those threats were not necessarily real, in the sense that Mr. Floyd remained in the home. There were many questions about the fact that he remained and her children could still come and go to the house. I think it's relevant based to the testimony that was elicited from defense counsels yesterday.
Overruled.
Well, these South Fulton police, first they put a car in front of the house that was there permanently, a police car. That was thing one. Thing two, they brought a person with a dog, sometimes more than once a day, twice a day, and they would circle the house to look for bombs. I knew that was a house that my daughter had worked for. It was a brand new house. She's the only one who had ever lived there. It's a 4-bedroom, brand new house, and somebody needed to protect the house, and I stayed there to basically take care of the house, to take care of the yard, to take care of that. Also, somebody sprayed, again, the B word and the N word on the house, and I don't think my daughter even knew that. I cleaned it off and called the police, and South Fulton police, they have, I'm sure, all the records of all the things that happened. And all of the neighbors, I notified all the neighbors to look out and to watch out. And it was so crazy. I mean, it was just so crazy. We'd have people would show up and park car. There was a guy parked for probably 8 hours out in front of the house. It was just, and we'd call the police, and,
Now, at the time that you lived there with Ms. Willis, and I guess even when you remained, so during the time period of 2019 to the end of 2020, are you aware if Ms. Willis was dating someone?
Yeah, she did. She had a boyfriend when I first got there.
Okay. And did you meet her boyfriend?
Yeah, I met him often.
Okay. And did you know him by any specific nickname?
Yeah, Deuce.
Okay. And can you tell the court why you were living there? How often would you see him?
Sometimes every day, sometimes, every other day. He was a disc jockey or something, and he had all this paraphernalia that I'd have to move out. There was a thing with the keyboard, things that play music and so forth and so on. So.
Now, when you moved in 2019, and then throughout the years in year 2020, 2021, had you ever met someone named Nathan Wade?
I did not meet Nathan Wade until 2023, about a year ago, when a reporter by the name of Issakoff interviewed me. I met him. That was the first time I had met him.
You said that was in 2023?
2023, right.
And I know you said you hadn't met him until 2023, but when you were living at Ms. Willis's house in Fulton County, did you ever meet Mr. Wade in the year 2019?
Absolutely not.
How about in the year 2020?
Absolutely not.
Did you ever see Mr. Wade at Ms. Willis's Fulton County house in the year 2021?
Never.
And is it your testimony that the only time or the first time that you met Mr. Wade was in 2023?
Let me say something. Mr. Wade said that he remembers seeing me, and I do remember some banter. I'm a member of Kappa Alpha Psi fraternity, and there's kind of this thing that goes on between fraternities, and Mr. Wade is a member of Alpha Phi Alpha, and I do remember there was some kind of banter when my daughter was sworn in to be district attorney between me and a couple of guys, and he said he remembers me. I don't remember him.
And prior to that experience that you're talking about, as well as, I guess, your official meeting in 2023, had you ever even heard his name?
No, never.
I don't think I have any further questions, Your Honor.
Ms. Merchant.
Yes, thank you, Judge. How are you?
Fine. How are you, counsel?
Good, thank you. Just got a couple questions. On Monday, we heard you were in California. Do you have a place in California?
People always ask me about where do I live. I guess I live right here, sitting in this seat right now. But yes, the answer is I have a place in Los Angeles.
Okay, you do. All right. So do you share time or split time between Los Angeles and Georgia?
Actually, I'm working on a documentary film, and I'm supposed to be being filmed not for this trial, but I'm supposed to be being filmed right now. It was planned, and we had to stop it because they asked me to come here. But the answer is I'm working on a documentary, and I'll be in California until I finish the documentary if we don't have another actor strike and we don't have another writer strike.
So do you own property in California?
No, I don't. I live with a friend of mine.
Live with a friend of yours. Okay.
Yeah.
And when did you first move? Let me qualify with the dates. Did you spend any time in 2019 in California?
No, and the reason I didn't is that when I first came here, the answer is no, I did not. What happened was COVID. Once COVID hit, I was just paralyzed. I couldn't go any place. I couldn't go anything. I mean, I'm a theater buff. I used to go to theater at least once a week. But when COVID hit, I just couldn't. I couldn't go to the dentist, which I need to do. Or, it was just a thing. So I was just stuck. I was just stuck there.
I may be wrong, but I believe COVID hit in 2020. So I was asking about 2019. In 2019, did you spend any time in California?
Before COVID was even here in the United States, remember I lived in South Africa and I've traveled the world. I knew COVID was coming before. I knew COVID was around before. They may have announced it in 20, but in fact, I knew about it and I knew what was happening in 19.
Okay, so let's walk through 2019 then. You said you moved here in September. So
no, I didn't say that. I moved here probably prior to September. In September is when I got the driver's license. I probably moved in the springtime.
I'm sorry, you did. You said spring, summer. I see that in my notes. So spring, summer 2019 is when you moved here. So up until spring, summer 2019, where did you live?
I lived in Johannesburg. Well, I lived in Washington, D.C., 2018. I had planned to retire for the rest of my life in South Africa. I had worked for Nelson Mandela and the Free Mandela and getting that. And someone I'd gone to law school, he had located there after Mandela was freed from prison and became president. I was going to live there for the rest of my life, but unfortunately, because of political reasons, I could not stay in South Africa, and I was forced, in a sense, to come back to the United States.
Okay, so let's just focus in on the period from, let's just start with October 2019, okay? We'll call that the relevant period. October 2019 until the end of 2019. Were you in Georgia every single day of that year?
Absolutely.
Okay. So now let's move to 2020, okay? And every single day, before I move on, every single day in 2019, you slept at your daughter's house, correct?
That's correct.
Okay, so let's start in 2020. All right, so 2020, the entire year, did you travel anywhere?
No.
You didn't travel at all that year?
No.
So,
and I didn't go to the movies, which upset me also.
So that entire year, 2020, you remained here in Georgia?
Right.
In 2021, did you do any traveling?
No.
Okay. So when did you move back, or when did you start this documentary film in Los Angeles?
What I had been doing to occupy time is I was writing my own memoir. as I delved into my family background, I discovered something, and that's what got me to working on the documentary. So I want you to understand what was going on in my life. I pitched I have a movie script called Bad Blood. I have a movie script I was trying to sell. So I tried to sell that, and I just happened to mention something that happened during the civil rights movement. SNCC, it's called the SNCC 5. The legendary Peter Fitzsimmons was interested, and so with Peter Fitzsimmons and Leah Smith, we're now doing the documentary. So
I don't want to interrupt you, but what I was asking was when you moved to Los Angeles, not what you moved there for.
Well, you keep saying moved. I haven't moved to Los Angeles. I spent more time in California, in Oakland, if you really want to just be, because Peter is basically San Francisco based. So we're working on the documentary.
Okay.
I was in Los Angeles because I was going to the Pan-African Film Festival, and that's why we were there. And the way Hollywood works is, you know, when you make connections, and film festivals are a place to try to sell ideas and meet people and organize things.
You still own property in Washington, D.C., correct?
No, I don't.
You don't own property at 1467 Roxana Road Northwest?
That's where I used to live.
That's where you used to live. Did you own that property?
Yes.
Okay. And you owned that property when you moved here in 2019?
Yes.
And you owned it in 2020, correct?
Well, now you talk about a very complicated issue. I left the property. There was a dispute between me, and I had gotten a reverse mortgage company, and there was a dispute between me and and I just I walked away from it.
Okay, you walked away from it with almost $300,000.
Yeah, what is the relevance of that?
Where he lived and registered to vote. That's what they brought in. So that's.
Why is the money he got from the sale relevant at all?
It's the only proof I have of that he owned that address. So I can move on though. Right. Okay. When did you sell that property?
I didn't. The reverse mortgage company took it.
Oh, okay. So in 2019, when you got your driver's license here,
yes,
the next day you registered to vote, correct?
I think it may have been the same day, but maybe it was the next day. I don't remember.
But you didn't own property here in Georgia that day?
No, I was living with my daughter.
Okay. You said that you met Mr. Wade, that you remember you met in 2023, right? That was the first time you
Correct.
remember? Okay. And I wasn't really clear. You said something about meeting him. Was it with Mr. Isikoff, or did Mr. Isikoff tell you?
No, I was being interviewed by Mr. Isikoff.
Okay.
And he walked in, and I met him. That was the first time. He walked into the office. And
where were you being interviewed?
At the district attorney's office.
And Mr. Wade walked into that interview?
Yes.
And so Ms. Willis had not told you about Mr. Wade prior to that?
Absolutely not.
So she didn't tell you anything about their relationship before you met him that day?
No.
But Mr. Wade remembers meeting you in 2020?
He said that at my daughter's swearing in. I do remember that we having some banner about fraternities, but other than that.
Oh, at your daughter's swearing in, okay.
Right.
That's all I have. Just one moment, Judge. Nothing else. Thank you.
Morning, sir.
Good morning. How are you, counsel?
I'm fine. I'll try to ask you some specific questions if we could, okay?
And I'll give specific answers if I can.
Perfect.
Okay.
The driver's license address, I'm not going to publish. That is State's Exhibit number 2. But is the address on that driver's license the home that you're referring to as your daughter's in South Fulton?
Absolutely.
Okay. It was unclear to me, maybe no one else, but it's unclear to me, when did you stop living at what I would call your daughter's home in South Fulton?
Things got so bad and threats got so many even against me, that the house became basically uninhabitable. I got tired of sleeping in one room one day and one that. I would say December of 2022, something like that.
December of 2022.
Right. That's about right. Yeah.
Now, let me change and go back for another date. You had indicated, and I didn't hear it. When was your daughter, Miss Willis, when was she sworn in as district attorney?
On January 1, 2021.
Okay. And did you indicate that there was an incident, and I know you've described it, was that incident on February the 3rd, 2021?
That's my best recollection.
Okay. So my question then is, after February 3rd of 2021, how much longer did Miss Willis stay at the house before she moved somewhere else?
Very short period of time, and I cannot be precise, but I would bet all the money I ever made, it wasn't more than a month and a half, if that long.
Okay, so we're talking about, best of your recollection, end of February into the beginning of March, give or take, of 2021, when Miss Willis would have moved to a different location.
Exactly.
Okay. And did Miss Willis return to the house, that is, the house that you were in, at any point in time that you can remember?
From time to time, she and her security might show up for her to pick something up or take something or something, okay. But she always would come with her security.
Okay. My question was poorly worded, I apologize. Did she come back permanently to her house?
Oh, absolutely not. Okay, absolutely not.
So as far as you're aware, that once Miss Willis left the house, her house, South Fulton House, so the record's clear, in either late February or into March of 2021, best of your recollection, she's not returned to that home to live.
No, it became uninhabitable. It just, that's okay. I would have to walk around that house looking out of every window. I made a habit of having to walk around the whole house. I got lights so that if somebody would come at night in the back, so that those kinds of reflecting lights, I had those put up.
I don't mean to cut you off. Okay. All I was interested in is whether she had ever returned.
No, the answer is no.
Okay. Now, when Miss Willis, when your daughter left the home, time period, end of February, beginning of March, give or take, 2021, do you know where she moved to?
No, and I didn't want to know. I intentionally did not want to know, because I was not, if somebody stuck a gun to my head and I could tell them, I wasn't going to tell them anyway, or I'd have made up something, but I didn't want to know.
Okay, so would it be fair to say that if you didn't want to know, you never visited her at the place that she moved to?
Oh, I never did.
Never did?
Never did.
Okay. Do you know how long she stayed at the first place that she went to after she left her house before she moved to a second place?
What I know, and this is hearsay, Counsel, is that my daughter has had to move something like 4 times.
But do you know any potential?
No, I don't know any place. I was taken one time for Christmas Day. I've only seen my daughter, and this is very hard for me to say, but during the period my daughter left, I've only seen my daughter 13 times, because I can't, and we've never seen each other more than maybe 3 hours because of, the nightmare threats against her and me.
And I understand that, and from the perspective of being a father myself, I understand what that means. So I'm going to move away from that. I was just trying to get an idea of date-wise, okay? So let me try to get one more date. In 2023, when you were being interviewed by one of the gentlemen that wrote the book at the DA's office, and Mr. Wade came in, can you give us, other than 2023, what the date would be?
I'm sorry, I can't, Counsel.
How about spring, summer, any idea?
I would guess spring or summer, but I can't. Okay. I don't. I'm sorry.
And you've already indicated, at least to your recollection, that was the first time that you'd met Mr. Wade.
Oh, absolutely.
Okay, I'm not arguing with you about that. I want to go to Miss Willis's boyfriend that you referenced. Okay, you met Miss Willis's boyfriend, as you've characterized it, when you came here in 2019.
Correct.
And you met him on one occasion, several occasions?
Oh, no, I saw him often.
Oh, so you mean there was no secret that she was dating this man?
Not from me.
Not from you.
And not, he was a disc jockey of some kind. I think he had a government job during the day. I don't know what it was, but apparently he would do weddings and so forth and so on. He was a disc jockey, play music. So he had all his stuff was always in the way, and I was always having to try to push it aside. And anyway.
But Ms. Willis, your daughter didn't keep him from you, correct?
No.
No, I mean, there was no doubt he...
I mean, we lived in, my daughter and I lived in the same house. I mean, he came and went,
Right. Now, when did you learn that your daughter had a romantic, personal relationship with Mr. Wade?
Well, about 7 weeks ago when as a matter of fact, I just found out when other folks found out. Okay.
That is, your daughter, as I understand it, never told you one time in the year of 2022 that she was dating Mr. Wade, correct?
That's correct.
And until recently, you didn't know from anyone, including your daughter, that she dated Mr. Wade, correct?
That's correct.
That is, whatever the relationship is between father and daughter, she kept that a secret from you, correct?
Correct.
That's all I need to know.
Mr. Stockton.
No.
Good morning, Mr.
Good morning.
Correct.
Good morning, Counsel.
When your daughter moved or left the house that she owned, did she say anything to you about having a large savings of cash?
Oh, no, no. See, maybe, excuse me, and Your Honor, I'm not trying to be racist, okay? But it's a black thing, okay? I was trained, and most black folks, they hide cash or they keep cash, and I train. You always keep some cash because I've been places, and just because of the color of my skin, for example, I took a fellowship at Harvard when my daughter was just if I might, Your Honor, when I was just, she was just, maybe 3 years old, and I remember going to a restaurant in Cambridge, Massachusetts, and I had a American Express credit card and maybe a Visa or whatever. And I had a lot of what they call traveler's checks. I don't even know if they still have traveler's checks, but traveler's checks. And there was a sign said, with the credit card. For whatever reasons, the man would not take my American Express credit card. So I pulled out my Visa card, and he wouldn't take my Visa card. So then I pulled out my traveler's checks. He said, we don't take checks. Now, these were traveler's checks. This was money. I had a $10 bill. I'll never forget this as long as I live. And he said, the bill for my wife at the time, Fonnie's mother, Fonnie, and myself was like $9.95, and I had a $10 bill. That was all that. I always remember that. But even before that, I've always kept cash, and I've told my daughter, you keep 6 months worth of cash always. For example, I had 3 safes in my house. I put some of my clients' stuff there too, things I didn't want other lawyers to be, because you're always in a firm, and I knew that there were special conditions, so some of my clients' things I would bring home, put them in the safe. But I've always kept safes, and as a matter of fact, I gave my daughter her first cash box and told her always keep some cash.
So is that a yes?
Yeah. Oh, absolutely.
That's all I got, Judge.
Mr. Durham.
No questions.
Mr. McDougald.
No questions, Your Honor.
Thank you. Mr. Rice.
No questions, Your Honor.
Mr. Gillen.
It's still morning. Good morning, sir.
Good morning, Counsel. How are you?
Just fine. Just a few questions following up. When you were talking about when you learned about Mr. Wade and your daughter, correct? Correct. Now, did your daughter tell you in around October of 2022 that she had gone on a Caribbean cruise with Mr. Wade to the Bahamas?
The answer is I knew that my daughter had gone, but I did not know who she went with or what the circumstances were. So I knew that she had gone out of town, but I didn't know with whom.
I see. And did she tell you in November of 2022 that she had gone to Aruba and stayed at the Hyatt Regency Resort there in Aruba for 3 days with Mr. Wade? Did she tell you that?
The answer was, again, I knew she went out of town. I didn't even know where she went. I knew she was going out of town. She told me she was going out of town. I think she might have said she was going out of the country or something. She'd be gone. But other than that, that was all.
Okay. And did she tell you in March of 2023 that she was going to Belize for several days with Mr. Wade?
The same answer, that I knew she would tell me she was going out of town, and she may or may not have told me where she was going, but she'd be gone for a couple of days.
Okay. Now, in 2023, you were in many days you would be out in California, correct?
Some days I'd be in California, correct.
Okay. Well, did she tell you in May of 2023 that she was traveling to Napa Valley with Mr. Wade, so maybe y'all could see each other when she visited California with Mr. Wade?
The answer is no.
And so the first time that you ever met Mr. Wade or learned about Mr. Wade, to your recollection, was in 2023?
That's correct.
That's all I have, Your Honor. Thank you.
Mr. Kucherov on Zoom.
Yes, Ron, just a couple quick questions. Good morning, sir. I know I can't see you.
I can't see you either, but
we can take a moment.
Good morning, counsel.
We can take a moment. Let's just pause, see if we can change the screens to show Mr. Kucherov. Sorry.
Your Honor, I'm on a phone, so it's kind of difficult.
Can you turn your screen on now?
I'm trying to. Does that work?
Just to hold one more moment? All right, there we go. You can proceed, Mr. Kucherov.
Sir, you seem to know about the issue of cash in this transaction. You said it was a black thing. How did you know that the cash was going to be an issue in this testimony?
Because I was asked for it, and I was prepped by the lawyers, and they asked me about it. What else?
And did you speak with Mr. Wade about your testimony?
No.
Did you speak with your daughter about your testimony?
She may have been present when the lawyers were. I really don't remember.
If Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
What do you? Maybe I'm not understanding your question, counsel. So maybe you want to restate. What is it that you're asking me?
Yeah, if it wasn't clear, I can re-ask the question. I'll rephrase it.
Yeah, right. Yeah,
Mr. Wade. If Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
I did not know that they were dating. And when were you talking about the cash? I didn't know that. I don't know what you're asking me. What I told my child from the time she was a child is always have some money. Always have some money. If you go on a date so that people don't try to stick you and you want to leave whoever, always keep some cash, okay?
Mr. Floyd, you answered the question that the attorneys prepped you for that, so that's all I wanted to know.
Anything else, Mr. Kucherov?
That's it, Your Honor.
All right, Mr. Cromwell.
No questions, Your Honor.
Mr. Abadi?
Your Honor. Mr. Floyd, now, it wasn't common for your daughter to confide in you about her romantic life at all.
No, and I haven't confided in her about mine before when I had one, okay?
And you wouldn't have known about her boyfriend, the disc jockey.
Hey, Debs.
Got an objection?
I think that might have just been a still off mute.
Okay.
Let's keep going.
Now, you wouldn't have known about her boyfriend, the disc jockey, had you not been living with her, correct?
That's correct.
I'll allow overruled.
I have nothing further.
Did he answer the question?
He did. He said that's correct.
All right. By show of hands, any redirect on those points only. Ms. Merchant.
Yes. I just wanted to know when you were prepped by the lawyers, when this prep session was.
I just got off the plane on, what was it, Tuesday night? I think I was probably drooling at the mouth. I was so tired. So it must have been, I got in Wednesday. It must have been Wednesday.
Okay. And did you talk about any of the testimony from yesterday or watch any news reports or anything like that?
Oh, absolutely. Google, you can't cut the TV on without seeing this. The first thing, and I listen to conservative radio a lot, and, you know, last night for 5 hours, all they talked about was this case.
So you were aware of what the testimony your daughter gave yesterday was?
Yeah, unless you don't cut the radio on, unless you don't cut the television on, unless you don't read the AJC or any other, the New York Times or whatever, which I do every day, yeah, of course.
So is it fair to say nobody instructed you that you were under the rule of sequestration?
Right, and I'm not under subpoena either.
Thank you.
All right, anything else? Seeing and hearing none, thank you, Mr. Floyd.
Thank you very much, Your Honor. It's a pleasure to appear in front of you, Your Honor.
Thank you. All right, Ms. Cross, let me check in. Was the state planning to call additional witnesses?
Not at this time, Your Honor. We're again trying to accommodate if there's a lapse in schedule to be able to this afternoon. But right now, that was our last witness.
Okay, so even if Mr. Bradley testifies to some extent, it's still the potential that the state has no further witnesses?
I anticipate at least one more will be available this afternoon, but that would be it.
Okay, so there are potentially more state's witnesses. All right.
Judge, before we move on, I'd move to strike the last witness's testimony as a violation of the law.
All right, so I think the rule is invoked and the instruction was for the parties to tell all witnesses subpoenaed or expected to appear about the rule. I don't think the remedy is necessarily striking. I think it can go also to this credibility as well. So to that extent, unless Ms. Cross, you want something else to be heard on that, point is made. All right. Do we have an update from Mr. Bradley?
Yes, Your Honor. Yeah, he should be here at 12:20, 12:25.
Okay. Then what I think we should do is have these preliminary conversations about privilege, see if we can make any headway, and then take our afternoon break. So to that end, counselors, I don't know if you just want to argue in place there or go to the table, whatever makes you comfortable. But Mr. Chopra, I think maybe it was relayed to you since you weren't in the court earlier this morning. We'd had some initial conversations about the distinction between the privilege and Rule 1.6, and it sounded like you wanted to be heard on that.
Your Honor, it was brought to my attention, and I apologize because I don't have things.
What do you need?
Well, a copy of the case in front of me would be helpful, but it's not necessary. It would just take me a second to keep looking at my phone to respond to the court.
Whatever you need to do.
Your Honor, I believe the case before the court in anticipation of piercing the rule 1.6 is Owens Corning fiberglass versus American Centennial. Is that correct?
Pardon me, it's difficult hearing counsel. Could you?
There's a microphone there at the jury box. You can try to
hear what he's saying. Thank you.
either try to lift that microphone up and speak in the jury box, or make your way over to the podium or table. Sorry.
Is that any better?
All right, and no, that was authority provided by Mr. Sadow over our morning recess, and I think that was indicated to go more towards a potential crime fraud argument. I don't think we've really gotten there yet.
It's not crime fraud per se. It's the same notion. It's fraud on the court, different proposition.
Okay.
But yes, and to attorney-client privilege waiver.
Right.
1.6 competency and secret threat.
The case that I had cited to this morning, showing the distinction between the two, was tenant health care. So that's where we were on the threshold issue. Did you have something that you wanted to address on that?
I have not been able to review that, Your Honor. I was unfortunately unaware.
All right, Mr. Ward, your co-counsel with Mr. Bradley? remind me why you are here.
I'm here to just assist you. You just assist me. Bradley, counsel, this counsel.
Okay, so you are co-counsel on this.
Well, this morning when you were asking where he was, I had to make sure everybody knew there was no one was here. That's what I was doing this for.
Okay.
Oh, this is, the judge is saying it's 10.
Right, and the citation for that is 273 Georgia 206.
Judge,
And I'll give you time to review that. In the meantime, what other things did you want me to know? And perhaps at this point we just take our break now, unless you also want to talk about the questionings that were provided by Ms. Merchant, seeing if there's anything we can achieve.
so that I can be clear, it is apparent that at this point we're going to go into whether or not 1.6 provides privilege for Mr. Wade, even though he has specifically stated that he does not waive that privilege. Therefore, it would be incumbent upon the court to issue an order.
All right, and now we are tuning in to have a chat with Jesse Banal, constitutional attorney for President Trump in his civil cases. Jesse, welcome. Great to have you on. There's so much happening for Trump this week legally. I just want to start with how you think Trump's legal team in his Georgia case will be expected to move forward from this point. What kind of strategies will they be using to next?
Well, thanks so much for having me. And, his legal team, I think, as we've seen the past couple days, has been absolutely on top of these issues, both in Georgia and all around the country. I don't represent him in any of these criminal cases, but my colleagues that do have done an absolutely outstanding job making the case. It's very difficult. It's really unheard of to be in a situation like we're in right now, where you have so many prosecutors that are blatantly trying to be involved in election interference. Jack Smith goes almost all the way up to the line in the Supreme Court right now, effectively saying that this case has to be fast tracked. It has to be, he won't say why it's so important to be fast tracked, but left unsaid. That extra logical step is it's very clear that it's fast tracked because he wants this case to affect the 2024 presidential election. So whether it's here in Georgia or whether it's any of these other criminal cases, New York, Florida, Washington, D.C., it's very, very clear that these cases are all about, at the end of the day, they're about election interference, because these prosecutors, and unfortunately, it's some of the judges haven't stood up to them the way that they should. But these prosecutors are afraid of the decision the American people are going to make at the ballot box. So they want to make their voice heard in the courtroom and take the choice away from the American people. And that's what these cases are all about.
And we heard yesterday in the New York civil case that the trial date would begin on March 25th. But Trump's team, as I understand it, on these various cases is wanting to delay or extend the start dates, which for quite a few of these cases is being decided at this time. What's the strategy there in terms of delaying it? Wouldn't Trump want to kind of have his say in court and have justice served sooner?
Well, I think that what President Trump's lawyers, I think, have been saying continuously is that, good or bad, these cases should not be allowed to interfere with the presidential election. The Department of Justice for years has had a very strong policy that says that they will not use cases to affect presidential elections, and they will adjust the timing, or any election for that matter. So they will adjust the timing of cases to make sure that these cases don't interfere with with elections. President Trump's lawyers are the only ones right now that are standing up for that long-held policy, that policy that is really incredibly important for any representative democracy, where you do have elections, because you don't want to encourage prosecutors to try to do exactly what's happening here and time their cases so that, win or lose, these cases are going to impact the election. And even if it's not just, the results of the election, it's about taking a candidate off the campaign trail. In New York, in the height of the presidential primary seasons, the effort here by Alvin Bragg, and unfortunately the judge is going along with him, is to take him off the campaign trail for 6 weeks. We know why they're trying to do that. They're trying to do everything they can to help Joe Biden and hurt Donald Trump.
And as you mentioned, this could have a very practical implications for Trump in terms of where he can be at any given point in time, speaking directly to voters on the campaign trail. How does Trump's team manage communicating that with the general public and with the media, who perhaps, we're seeing also some conversations about that it's important to try him in the court of law for democracy's sake?
Yeah, well, I mean, first of all, the American people understand exactly what's going on, and I think we see this by the amount of support that you're seeing from President Trump right now. You see this talking to voters, you see this in polls, that the American people understand and know that these cases are about political interference, that, it's not just an accident that these cases are all being timed to come up in, right in the middle of the presidential primary season, that they are being timed to interfere with the election. The American people know that. And, the American people are a special group of people. I think the biggest way to get them get their backs up, get their ire up, is to tell them they can't do something. Tell them what their choice is. Try to, inflect the government and bureaucracy's view on what democracy means to the American people. And so I think what they're doing right now, and why a lot of these cases are backfiring, is they see how much the bureaucratic establishment in Washington, D.C. and other places like New York absolutely hate Donald Trump and will pull out all the stops to try to return him from coming back to the White House. And the American people aren't going to stand for it, and they are just itching right now to get to the ballot box and vote for Donald Trump.
And I want to look at New York civil fraud trial, which, that's also being decided. Possibly today, there might be a decision from Judge Engoron. Can you provide insights into President Trump's legal team's perspective on the allegations of fraud and misconduct that have been leveled against him in this case?
This case should have never been brought. It was brought, again, by the New York Attorney General, who campaigned on going after Donald Trump. That's not the way our justice system is supposed to work. It is obscene that they're bringing a case where they suspect that Mar-a-Lago, that's worth hundreds of millions of dollars, if not possibly over $1 billion, is somehow worth only $18 million, for instance. That's just preposterous. Everybody knows that that's wrong. This case has to do. The theory of the state is that somehow Donald Trump pulled the wool over the eyes of some of the biggest lenders in the world. And those lenders have come forward and said, that they didn't rely on any statements, that they knew that that President Trump actually had a statement in his papers saying that they shouldn't rely. But on top of that, they got all their money back. That there was certainly no fraud, because they were paid back every dime, including interest. They got the deal of a lifetime by lending money to the Trump organization. So it's a preposterous case. It's being run, unfortunately, by a judge who should never have been on this case. This case should have been handled by the commercial court in New York, a court that understands these complex commercial issues. But this judge demanded to keep the case himself, and then he proceeded to even publish stories in his high school alumni newsletter about how he was the judge in this case, effectively bragging about the fact that he was going to stick it to Donald Trump. And when you look at that, the unprofessional mugging that he's done for the cameras, unfortunately, he's become the poster child for a crisis of conscience that we see in judicial chambers right now in places like Washington, D.C. and New York, where there is such a poison in a lot of these chambers, not just among one judge, but I think within the entire chambers themselves, against Donald Trump, that there's become this desire among judges to inject themselves within the political debate. And it's a very, very dangerous thing that we're seeing. And we really need to expect more of our judges and demand that they stay out of politics, quite frankly, that their views aren't and impacted by whatever news channel that they're watching, but rather the evidence that's put in front of them, which is what they're sworn to do. And so, we'll see what the judge does today or whenever he hands down his decision. But from what we've seen from him so far, unfortunately, I'm expecting another political decision.
Right, and one of Trump's other attorneys, Alina Habba, also said about as much recently about this particular case and the decision that we're all expecting and wondering what will happen potentially today. So what kind of impact could that have on Trump? Because, this could severely hit his finances and in terms of his campaign trajectory, financing.
Well, let me first say it's preposterous that someone that has done as much as he has, put everything he has on the line for the American people, that it should have to go through this. Let's remember that this is the first president of the United States in history where this is the first, when he took the oath of office, it's the first time that he was ever, a public employee, ever. Every other president at some point had some other government job, not Donald Trump. He has taken and put everything aside to stand up for the American people. And luckily, he's somebody that can weather these storms to stand up for the American people when most people would be broken by this. We still have a president in him that is one of the most dedicated, fierce defenders of liberty that history has ever known in this country, and we're lucky to have him, because the permanent bureaucracy is going to do everything they can to destroy him. Because in the past, regardless of whether it was a Republican or a Democrat in office, they have always bent to the will of the bureaucracy. The bureaucrats may let them have a little issue here and there, but by and large, it's been the bureaucracy that's been running the government in this country for far too long, and Donald Trump is the first president to ever stand up to him, and we see what happens. And so, I think he's going to be able to continue to withstand this storm. I think the American people are hungry to get him back in the White House, where he's going to be fighting for the American people like never before.
And just as we've been touching on the timing aspect of all of these cases, and yesterday we heard, as I mentioned earlier, about the trial date beginning March 25th in the hush money case in New York City. What does Trump's team, how do they see the timing and scheduling of that particular case starting March 25th? How could that impact Trump? Just briefly,
I think it's like we discussed previously. I think it's very clear that is another very unfortunate example of, in this case, a judge who's actually a Joe Biden donor, a judge that even if he really thought he could be fair. And he says that he did a lot of inner searching and decided he could be fair. But that's not good enough for judges. That's not what we expect from our judges. It's not that they think that they can be fair. It's that the public knows that they're fair, that there's not even an appearance of partiality from a judge. That is what our justice system demands in order to live in a country that has the rule of law. And the fact that somebody who's a Joe Biden donor would stay on a case and then schedule that case right in the heart of primary season leading up to the convention, so that he could very clearly help the man who he's already donated to, Joe Biden, by hurting the presumptive nominee for the Republican Party, is completely outrageous. Our justice system demands more. The American people really demand more than this. And I think, like I said, this crisis of conscience that is present in too much of our judicial chambers in this country right now. Something needs to be done by that. We need to really demand more from the ethics of our judges.
Jesse Banal, great to speak with you. Constitutional law attorney for President Trump in his civil cases. Always great to have you on. Thank you so much, Jesse.
Thank you so much for having me.
And next, we're going to tune in to a speech by President Biden. He'll be speaking on and that's going to come up soon. But first of all, we're going to check back in with our legal correspondent, Arlene Richards. We have just seen so much, just heard from one of Trump's legal team. We've seen so many interesting points come up in the Georgia case. What struck you the most?
Well, as you said, some things are coming up. I think Fonnie Willis's father's testimony struck me more towards the end than in the beginning. And I think towards the end of his testimony, the questions got a little more difficult for him to answer truthfully, and he started becoming a little bit combative. He started to say, I don't understand the question, and he started to seem like he was irritated in his responses. And I think that was when they were getting into how did he know, or whether or not he knew about the trips. Yeah. This was talking about the trips, and did he know that she was in California on a trip in May 2023 and she didn't reach out to her father, who she hasn't seen in a while, and try to connect with him? And he insisted that he didn't know anything about who she traveled with. All he knew that she traveled somewhere. Now, seems a little strange to me because earlier he was expressing how much he worried about her, with the threats that were coming to her home, and he was so worried about her and wanted her to leave and be safe. So you would think a father would be concerned about you're going on trips with people where are you going? So at least I know where you are. I think that would be.
And we did hear earlier that, in yesterday's testimonies, that Fonnie Willis did go on one of these cruises with Nathan Wade's mother. So there was that level of intimacy. Their families were connecting and that kind of closeness.
Yeah, it seems strange that he never met Nathan Wade. She never introduced him and said, this is my boyfriend, or we're dating, when she was meeting his mother. Right, that's a good point. She was meeting his mother, and she seemed, when they asked her about it yesterday, she seemed to have like a endearing look on her face, like, yes, I met his mom. Like, that's a big move for a couple, right, to meet the parents. Yeah. And yet she wasn't trying to have him meet her father.
I was wondering a little about the line of questioning where they were asking, one of the defense lawyers was asking whether Mr. Floyd, Willis's father, owned his place in D.C. I'm not sure where that might lead, but earlier in yesterday's testimony and questioning, one of the defense lawyers was wanting to find out whether Willis and Wade had ever been in D.C. at the same time together. And as I recall, Willis said that they had both visited D.C. on various occasions for work, but had never been in D.C. together.
Well, what came up today was that this was a property that he left. He left it, and he said there was some kind of a dispute with some mortgage company or something. But I think they're trying to establish that he owned a property, and if they were meeting there, they probably could have stayed at his property, right, as a couple. But he kind of canceled that out by saying there was a dispute and it's a sore spot, it's complicated, and he left it and they took it over, they took it away.
But we don't have a date for that, do we?
I didn't hear what the date was, but just the fact that he's trying to say, no, I don't. I did own it when I lived there, but when I left,
2018.
Yeah, when I left, then that was the end of it. And they're trying to trying to establish, like, how long did you own it?
Oh, I see. So I'm not sure when he moved to Georgia to live with Fonnie. That was at least between October and December of 2019, I believe.
He said it was in the summer, spring or summer of
okay.
2019 when he moved to Georgia.
Okay.
Yeah.
Yeah, and some interesting comments about COVID that he brought up and whether he wanted to leave his home. He said he was pretty much housebound in 2019. So that kind of corroborates some for him, his side, about whether he would have known about or been in contact with, seen Nathan Wade at that point in time if Fonnie Willis and Nathan Wade.
Well, I think he was establishing that she had a boyfriend. She had a different boyfriend, right? This disc jockey person who was always at the house, coming and going. Deuce, yeah, Deuce. So he's saying she had another boyfriend, so she couldn't have been with Wade because she already had a boyfriend. Okay. And I saw him a lot because I lived there, and he was coming in and out quite frequently. So to establish that she was in a relationship with someone else, I think that's kind of what he was trying to establish there. Mm-hmm. Some of the lawyers were trying to establish that they didn't talk about her relationships, so he wouldn't have known anything about Deuce if he hadn't even lived there. So,
Yeah.
Because at one point, one of the defense attorneys was saying, well, did your daughter ever tell you about, Nathan Wade? Did you know? And he said, no, 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 no. But then on cross, the state tried to establish that if he hadn't been living there, he wouldn't have even known about Deuce because they didn't talk about each other's relationships.
Mm.
And we're about to go to John Malcolm, the VP of Heritage Institute for Constitutional Government and the director of the Meese Center for Legal and Judicial Studies. John, we spoke to you yesterday twice. Thank you for joining us again. We just heard so far this morning from Roy Barnes, former governor of Georgia, as well as the father of Fani Willis, John Floyd III. We were supposed to hear from Willis. We were expecting to hear from her, but it looks like she's not testifying. Same thing with Nathan Wade's business partner. What does all this tell us? What are you picking up here?
Well, I didn't see much point to this morning's testimony, so it was widely reported that Fani Willis had asked other people to appear as a special prosecutor before going to Nathan Wade, and Roy Barnes confirmed that. Okay, you got, I suppose, a little bit of mileage out of that to rebut the notion that this was always about just padding the bank account of her boyfriend so that he could spend some of that money taking her on lavish vacations to Belize and Aruba and all the other places that have been talked about. Wasn't 100% sure about what the testimony from Fani Willis's father was designed to elicit, other than the fact that he had clearly advised her that she should keep some cash around based on his own past experiences, and that he only had a vague idea about who she was dating and when she was dating people, and certainly was unaware of any romantic relationship between Fani Willis and Nathan Wade until I think it was sometime in 2023. I don't think that any of those were particularly earth-shattering points. Now we're going to have some discussion about whether Nathan Wade's divorce lawyer, who also was practicing law with him, will be compelled to testify. There's questions about whether his testimony would be covered by the attorney-client privilege. That could be very interesting testimony if the judge compels him to testify. And then I'm not sure what other witnesses we're going to hear. You're going to still hear arguments from counsel. Some of this will be about when they started their relationship, and the defense attorneys expressing, I suppose, incredulity that she was spending thousands of dollars in cash without any records to account for any of this. But there'll be other arguments too, such as about the speech that she gave at church, accusing some of the defendants and their defense attorneys for being racists, or even bringing up this issue. And there may be other issues that come up. The judge has already said that there only has to be an appearance of a conflict, that it's a relatively low bar that has to be cleared before disqualification can take place. And I think the odds are still pretty decent that at the end of the day, he is going to disqualify Ms. Willis and her office from continuing to prosecute this case.
Wow. And what do you think that would do to the case?
Well, it would be reassigned to another prosecutor. There are several, dozens of DAs, district attorneys in Georgia. There's also a special prosecuting counsel who could appoint another special prosecutor untainted by any of this to look at the case. It would certainly delay things, but I would assume that a new prosecutor would take a look at all of the evidence and decide whether to continue with the prosecution, pare it down by eliminating some of the defendants, or dropping the whole thing entirely. I certainly think, for instance, that a new prosecutor may look at Ms. Willis's use of the Racketeering Influenced and Corrupt Organizations, or RICO, statute. I've always thought that this is an aggressive and somewhat dangerous charge to bring. And she's essentially said that an entire presidential re-election campaign was a racketeering enterprise. I would be surprised if another prosecutor decided to continue with that particular charge, but we'll see.
And now Willis was again supposed to testify this morning, but she didn't. What does that tell us?
Well, it either says that she felt she'd made her points and that that she was unlikely to make any more headway, or she figured it was time to cut her losses and to argue based on her testimony so far. She certainly was belligerent and combative. calling all of this lies. At one point, she leaned to Miss Merchant and said, "I don't need any other evidence. My word is good enough. Are you accusing me of lying?" I mean, it was a very contentious hearing, to put it mildly. I don't think that she came off looking particularly good or credible by her belligerents, but that will all be determined by Judge McAfee.
Now, you were saying there wasn't a lot that came out of the testimony so far we've heard today, but yesterday had a lot of headlines, people reflecting on that. You've had a few hours to digest what happened yesterday. What's your biggest takeaway at this point?
Well, this is a train wreck, and her, behavior was unprofessional, and it's been an embarrassment to her office and to the state, regardless of what happens. It's imperiled this prosecution, and even if the prosecution is allowed to go forward and her office is still in charge of it, any conviction is likely to be tainted in the court of public opinion and could well result in a reversal on appeal. So that if she is disqualified, she will really have no one to blame but herself for this. Although I'm quite sure she will not accept the blame, and she'll point the finger of blame at others.
And some of the more critical people are talking about the possibility of disbarment. What do you think about that?
Well, disbarment is a rather extreme remedy. I suppose there's also the possibility, even worse, that she could be criminally prosecuted if it really is believed that she was authorizing all of these payments to her boyfriend so that she could accept a lot of this money on the back end in the form of lavish vacations. She could be charged with, theft of honest services. She could be charged with accepting kickbacks. So she faces a lot of peril. Certainly already, for instance, so she was supposed to make financial disclosures in which she was supposed to report aggregate gifts in excess of $100 from a prohibited person. A prohibited person would include someone doing business with the county. Nathan Wade was clearly doing business with the county, clearly spent over $100 in a given year on her. And her explanation of, oh, well, he gave me money, I gave him money, I didn't really consider these gifts. It was at the very least extremely sloppy, not the kind of thing you would expect from an elected official.
Yeah, and that was some of the commentary we heard earlier today. Her conduct in the hearing yesterday was really intense. One of our guests called it like Jerry Springer.
Yeah, it's a little bit like that, in that you find yourself watching something, you can't quite believe it, but you can't quite take your eyes off it either. I cut people a little bit of slack in terms of saying, look, if people were saying really nasty things about me, and I was all of a sudden on the witness stand having to talk about it and reveal all kinds of personal details about my life, I might be a little bit indignant too. But she certainly was going very, very far. I mean, she was throwing papers on the ground, and she was acting in a very, very belligerent fashion. It's not quite what I would have expected. I mean, she charged into that courtroom like a bull in the center of a ring going after a matador. And it's not, I don't think it did much to enhance her credibility.
Okay, now I want to look at the New York civil fraud trial. We're looking at the verdict today there. Obviously, Trump is expected to appeal anything that comes out of that. I want to focus on what that path to appeal looks like. But first, I want to hear your reflection on that case so far.
Well, I don't think there's any question of what the outcome is going to be. Most of it was decided before the trial actually began. Judge Arthur and Goron looked at the papers that had been filed by both parties and had determined that liability existed, that he had dramatically inflated his assets and undervalued his debts on various bank loans, and that constituted actionable fraud. Really, all that we are talking about now is how much of a penalty he is going to assess. The Attorney General in New York, Letitia James, is asking for, I think, something like $350 million in penalties, and to bar former President Trump and his family from doing business in New York and to place the businesses that he does have there essentially into receivership. That's an extraordinary remedy, particularly when you consider the fact that none of the banks here suffered any losses whatsoever. But it's been quite clear which direction the judge is going. I don't think that the former president has also been quite belligerent with the judge and took on not only the judge in terms of accusing him of a political bias, but also the judge's principal law clerk who's been in the courtroom throughout this entire trial. So I think the president is going to get whacked today by Judge Engoron, and he will have a number of issues to appeal. And that's going to be the state of that.
And with that appeal, what does that path look like?
Well, it's going to raise a number of legal issues, essentially sitting there and saying, look, there was no fraud here, that the banks, in addition to the fact that the banks didn't lose any money and there was no victim, that the statute that is being used, which is essentially a consistent pattern of fraud in the conduct of businesses in New York, is extremely vague, quite possibly unconstitutional, probably unconstitutional as applied to him. And he has said, look, I had various disclaimers in my financial statements that said, look, these are my best estimates, but don't trust those estimates. Go do your own due diligence. And that those statements put the onus of responsibility on doing due diligence on the banks, and was basically telegraphing them to the banks that they shouldn't really trust these statements in the first place. Other arguments that he's made is that, in fact, with respect to some of these assets, not all of them, I mean, there were points that he overstated the square footage of his unit in Trump Tower, but that for some of these assets, he understated the value because of his brand as Donald Trump, that brand in and of itself increases the value of his assets. And so that if anything, with respect to a number of these assets, he was conservative in his estimate. All of those, he's got some experts that back that all up, and they'll put all of that before an appellate court to say no harm, no foul, and certainly not to the extent of hundreds of dollars in penalties from doing business in New York.
And let's look at this. It's a smaller thing, but smaller than what we're talking about, at least. There's a Trump ballot challenge moving forward in Illinois, looking to remove him from the ballot there. I'm wondering what you're hearing about this and what you're thinking about it.
Well, I don't know what the basis of that challenge is. I'm assuming that it is the same type of challenge that was just argued before the United States Supreme Court last week. It already seems like it was weeks ago. That he is disqualified from being on the ballot for being an insurrectionist who had previously taken oath to defend the Constitution. And so he's disqualified under Section 3 of the 14th Amendment. That issue, the Colorado Supreme Court, in a closely divided decision, said that's right, he can be disqualified from being on the Colorado ballot. The Supreme Court immediately decided to hear this case, particularly after the Secretary of State in Maine adopted Colorado Supreme Court's opinion and ordered him off of the ballot in Maine too. That argument has taken place. I think it was crystal clear from that argument that the Colorado Supreme Court's opinion is going to be reversed. I think that there are at least 5 justices, and quite possibly all 9 justices are prepared to say that Donald Trump, for any number of reasons, either one, that that provision does not apply to presidents and vice presidents, that they are not quote unquote officers of the United States under Section 3 of the 14th Amendment. They could also say that that provision is not self-executing and that it requires an act of Congress to determine a procedure for reaching that conclusion. They could also say that the only federal statute that is arguably germane is a criminal statute for engaging in an insurrection. That's Title 18 United States Code, Section 2383. Donald Trump has not been convicted of violating that provision. He hasn't even been charged with violating that provision. That was part of the second impeachment proceeding brought by the House of Representatives, but he was acquitted by the United States Senate on that point, and the justices made
John,
it quite clear
sorry to interrupt you,
not...
John. We're going to turn to President Biden reflecting on the death of Alexei Navalny, the dissenter from Russian President Vladimir Putin. Thank you so much, John Malcolm, VP of Heritage Foundation's Institute for Constitutional Government.
Good to be with you.
He had him arrested. He had him prosecuted for fabricated crimes. He sentenced him to prison. He was held in isolation. even all that didn't stop him from calling out Putin's lies. Even in prison, he was a powerful voice for the truth, which is kind of amazing when you think about it. And he could have lived safely in exile after the assassination attempt on him in 2020, which nearly killed him, I might add. But he was traveling outside the country at the time. Instead, he returned to Russia. He returned to Russia, knowing he'd likely be imprisoned or even killed if he continued his work. But he did it anyway, because he believed so deeply in his country, in Russia. Reports of his death, if they're true, and I have no reason to believe they're not, Russian authorities are going to tell their own story. But make no mistake, Putin is responsible for Navalny's death. Putin is responsible. What has happened to Navalny is yet more proof of Putin's brutality. No one should be fooled, not in Russia, not at home, not anywhere in the world. Putin does not only target his citizens of other countries, as we've seen in what's going on in Ukraine right now, he also inflicts terrible crimes on his own people. And as people across Russia and around the world are mourning Navalny today because he was so many things that Putin was not. He was brave, he was principled, he was dedicated to building a Russia where the rule of law existed and where it applied to everybody. Navalny believed in that Russia. He knew it was a cause worth fighting for, and obviously even dying for. This tragedy reminds us of the stakes of this moment. We have to provide the funding so Ukraine can keep defending itself against Putin's vicious onslaughts and war crimes. You know, there was a bipartisan Senate vote that passed overwhelmingly in the United States Senate to fund Ukraine. Now, as I've said before, and I mean this in a literal sense, history is watching. History is watching the House of Representatives. The failure to support Ukraine at this critical moment will never be forgotten. It's going to go down in the pages of history. It really is. It's consequential. And the clock is ticking. And this has to happen. We have to help now. You know, we have to realize what we're dealing with Putin. All of us should reject the dangerous statements made by the previous president that invited Russia to invade our NATO allies if they weren't paying up. He said if an ally did not pay their dues, he'd encourage Russia to, quote, do whatever the hell they want. I guess I should clear my mind here a little bit and not say what I'm really thinking, but let me be clear. This is an outrageous thing for a president to say. I can't fathom. From Truman on, they're rolling over in their graves hearing this. As long as I'm president, America stands by our sacred commitment to our NATO allies, as they have stood by their commitments to us repeatedly. Putin and the whole world should know, if any adversary were to attack us, our NATO allies would back us. And if Putin were to attack a NATO ally, the United States will defend every inch of NATO territory. Now's the time for even greater unity among our NATO allies, to stand up to the threat that Putin's Russia poses. You know, I send my deepest condolences to Alexei's staff and supporters. We're going to continue his work despite this loss, despite all of Putin's desperate attempts to stamp out the opposition, and most of all to his family, especially to his wife, his daughter, and his son, who've already sacrificed so much for their family and a shared dream for a better future for Russia. So I just want to say God bless Alexei Navalny. His courage will not be forgotten, and I'm sure it will not be the only courage we see coming out of Russia in the near term. Thank you. I'll be happy to take a couple questions.
Sir, first, was this an assassination?
The answer is we don't know exactly what happened, but there is no doubt that the death of Navalny was the consequence of something that Putin and his thugs did.
And to be clear, you warned Vladimir Putin when you were in Geneva of devastating consequences if Navalny died in Russian custody. What consequences should he and Russia face?
That was 3 years ago. In the meantime, they faced a hell of a lot of consequences. They've lost and/or had wounded over 350,000 Russian soldiers. They've made them in a position where they've been subjected to great sanctions across the board. and we're contemplating what else could be done. But what we were talking about at the time, there were no actions being taken against Russia. And look, all that's transpired since then.
Can you say whether you're looking at increasing sanctions on Russia right now?
We're looking at a whole number of options. That's all I'll say right now.
Is there anything you can do to get ammunition to the Ukrainians without a supplemental from Congress?
No, but it's about time they step up, don't you think? Instead of going on a 2-week vacation. 2 weeks. They're walking away. 2 weeks. What are they thinking? My God, this is bizarre. And it's just reinforcing all the concern and almost, I won't say panic, but real concern about the United States being a reliable ally. This is outrageous.
Are you more confident now that you'll get the Ukraine aid given what's happened today?
Well, I hope to God it helps. But I mean, the idea we need anything more to get the Ukraine aid. I mean, this is in light of a former president's statement that saying Russia, if they haven't paid their dues to us, go get them. Come on. What are these guys doing? What are they doing?
Sir, how concerned are you about the anti-satellite capability that Russia is developing, and what is your administration planning to do in response?
First of all, there is no nuclear threat to the people of America or anywhere else in the world with what Russia is doing at the moment, number one. Number two, anything that they're doing or they will do relates to satellites and space and damaging those satellites potentially. Number three, there is no evidence that they have made a decision to go forward with doing anything in space either. So what we found out, there was a capacity to launch a system into space that could theoretically do something that was damaging. Hadn't happened yet, and my hope is it will not.
Thank you all. Thank you, Mr. President.
I'll take one more.
Thank you, Mr. President. Switching gears for a moment, have the Israelis presented a credible evacuation plan for the nearly 1.5 million displaced Palestinians sheltering in Rafah? And what would the consequences be for Israel if they move ahead with a full-scale ground invasion without clear measures to protect civilians there?
Well, first of all, I've had extensive conversations with the Prime Minister of Israel over the last several days, almost an hour each. And I've made the case, and I feel very strongly about it, that there has to be a temporary ceasefire to get the prisoners out, to get the hostages out. And that is underway. I'm still hopeful that that can be done. And in the meantime, I don't anticipate, I'm hoping that the Israelis will not make any massive land invasion in the meantime. So it's my expectation that's not going to happen. There has to be a ceasefire temporarily to get those hostages. And by the way, we're in a situation where there are American hostages. American citizens are being held hostage. It's not just Israelis, it's American hostages as well. And, my hope and expectation is that we'll get this hostage deal, we'll bring the Americans home, and the deal is being negotiated now, and we're going to see where it takes us.
An FBI informant at the center of the impeachment inquiry into you has been indicted for allegedly lying. Your reaction to that, and should the inquiry be dropped?
He is lying, and it should be dropped, and it's just been an outrageous effort from the beginning.
And
we did. No, I'm serious. See you in Ohio.
Thanks,
Mr. President.
Thanks, Paul. Thank you so much, guys.
All right, we just heard President Biden making statements. We just heard President Biden making statements about the death of Alexei Navalny, a major Russian dissident there in Russia. The prison authorities said that Navalny felt unwell after going for a walk on Friday and almost immediately lost consciousness. They tried to resuscitate him, but he died. He had survived actually 2 at least 2 previous suspected attempts to poison him. Biden was saying that Putin is responsible for Navalny's death, regardless of what these authorities in Russia say. He says, we have to provide funding to Ukraine, kind of taking this as an opportunity to rally support for Ukraine, criticizing the House of Representatives about their indecision and lack of ability to secure that funding. We did see him actually freeze for a few seconds there while he was trying to answer a question, and that kind of caught my attention. But we're focusing today on the hearing in Georgia that deals with Fulton County District Attorney Fani Willis's relationship with Special Prosecutor Nathan Wade in the Trump Georgia case. We're joined by NTD's legal correspondent Arlene Richards. Let's pick up our conversation about this. We know that they're on break right now. The court is on break, but they should be back soon. What are we expecting in the next branch of this?
Well, they're asking whether there are any more witnesses for today, and I believe, I'm not sure if it was the prosecution side, the state side, or the defense attorney side, but they said there would be a few more witnesses coming in. If it's on the defense side, then it could possibly be some county workers. They're still waiting for Terrence Bradley to show up. If he shows up, then he will probably go on the stand first. I don't know where he is because he was expected around 10:30, and we're at almost 1 o'clock. And I think they were talking about discussing this attorney-client privilege. They were going to have a conversation about that with the judge to see whether or not he can testify to certain things. And if he can, then they're going to expect him to come in and provide some information. Now, will he provide the information they're seeking? Still remains to be seen. I mean, they're trying to find out from him about the relationship, what he knows about the relationship as a friend and as a partner of Nathan Wade during that time period. He would know what the relationship was. He would have seen it. He might have even double dated with them. You never know. So we'll have to see what he says.
And there's a point that's come up a couple times already today, that disqualification of Fani Willis, and the judge apparently said earlier in the day, only has to be dependent on the appearance of a conflict of interest for Fani Willis to be disqualified from this. Is there, I mean, today it looks like the defense lawyers are making a pretty good case through their questioning, and as we've spoken about throughout this is the main testimony by the friend, Miss Urity. Is there anything that could potentially skew this and turn it all back, could save this for Fani Willis?
Wow, that's a tough one. I've never seen a case like this before, so it's, I don't think I can independently assess it. But if I find it really hard to believe that it could get turned around, but only way it would, I think, is to save the case. If the judge believes that, this case going forward is more important and more necessary than trying to oust a district attorney. I don't know if that comes into his consideration because, as he said, as one of your legal experts said, this case would have to be replaced by another DA, and that DA may then assess it and decide that it shouldn't be a RICO case, and that and they may decide that all of these defendants shouldn't be prosecuted, and that could change the whole case.
Wow. So could the case just end?
According to your legal expert, I guess it could. Like he said, if another DA assesses it and looks at it and decides that it shouldn't have been brought, then he could say, I can't prosecute it. But I don't know if they would then go look for another DA, to save the case, and maybe they think there's enough there that at least some of these individuals should be prosecuted. But it would be a totally different case, I think.
And one of the points that our last guest brought up, John Malcolm, the VP of Heritage Foundation's Institute for Constitutional Government, was that even so, if a conviction is brought in the Georgia case, it sounded to me that just no matter what happens with Fani Willis in this, just due to these revelations that are coming out now, or at least apparent revelations in these hearings, is that the aspect of the conviction or potential conviction would be tainted in the public's opinion. because of what's taking place here, and that could even lend itself towards a reversal on appeal.
Well, yeah, they're saying this goes to her credibility, right? Like this whole thing is really a big hit on her credibility and her reputation and her. I mean, she's the district attorney of Fulton County, the largest county, I believe, in the state. You know, it's a huge county. It's a significant county. That position is significant. You know, and she's presenting herself in this way, in this very unprofessional way, in the way she came into court yesterday and the way she testified. It's just not the proper, you know, way that a professional of her level should be acting. So yeah, it's going to really hurt her in terms of going forward and how she, you know, acts and presents herself throughout the trial.
But how much does public opinion weigh in on a legal cases, you know, a judge's decision on a legal case, for example, in assessing a potential appeal, if this becomes a conviction? How much could public opinion weigh in on this?
Well, it depends on how political the judges are, right? There was some commentary, I believe, about the judges getting more involved politically and making their own decisions based on politics and their own political views. I think they referred to this New York case that's coming up March 25th here in New York, the hush money case. You know, I mean, I think some of the commentary was that judge donated to Biden's administration. So, you know, these judges, you don't know what's going on behind closed doors, who they, you know, what party they're favoring, who they contribute to, things like that could factor in.
Yeah, and we've been seeing more. We have 2 or 3 judges now who've campaigned on getting Trump or major legal figures. There's probably more that don't get reported on smaller cases and smaller levels, if I had to guess.
Yeah, I mean, the legal expert did confirm that Fani Willis had campaigned on that. We have the Attorney General Letitia James campaigned on that, and also this DA Alvin Bragg, who's part of this hush money case, campaigned on getting Trump. So why people want to get Trump so much, I don't know, but they're campaigning on it. Fani Willis has only been the district attorney since 2021, according to her father, January 2021. It hasn't been very long that she's even been in this position, and within a year and a half, she's indicting former President Trump.
Yeah, and that's a major move. I mean, so early on.
Yeah, I mean, so it kind of goes to what she campaigned on, right? She said she was going to get Trump. She might have been already looking at this beforehand. And I'm kind of curious as to why she ran for district attorney in the first place.
You know, yeah. She did talk about that decision in her testimony yesterday. Mm-hmm. And from my recollection, she said that issue was tied in with her decision to run for district attorney, and that she said that people were telling her she'd be a good one for that role, and she didn't want to, but then she kind of preyed on it and decided that after that she was the right one for the role. So to me, it seemed like she did decide that she had a mission that was related to this case with Trump.
Well, I think also she has a reputation for doing RICO cases. I believe I've heard that before, that she's known for doing these RICO cases. She's got the YSL one. I don't know if that's finished or not, but she brought that one. And maybe in her career previously as a prosecutor, maybe she has prosecuted some RICO cases before, so it's kind of like her specialty.
Mm.
Yeah, and I remember, when this case first, came out in the public, the idea that it would be a RICO case was like an unusual use of RICO statute.
Well, the RICO statute in Georgia is unusual. It's not quite the same as in other states. So this kind of it's kind of a catch-all statute that allows you to bring in everybody and anybody. So, at one point, I believe, there was some commentary that, she could start bringing in people who support Trump, by the way this statute works. So yeah, it's a catch-all thing. She can bring all of these people in, but also the more people she brings in, the more that could possibly come out if they start pointing fingers at one another. Some of them have pleaded out, and now they can now turn on Trump and the rest of them and testify against them and bring out other things. So that helps her with her case ultimately. But again, like I said earlier, this is a huge case, and it's going to take a lot of time to prosecute this. I mean, it's just not going to be a couple of months like she was estimating.
And I want to come back to this issue of credibility, which it's all centering around at the moment with the hearing today and yesterday. Something interesting that one of our previous interviewees brought up, David Gelman, a criminal defense attorney who Chris spoke with, and he was also a former prosecutor. He said, he mentioned something that I also noticed, but he really honed in on this, that Willis, in her testimony yesterday, talked about moving money from her campaign, one of her previous campaigns, into her cash stash. And that he actually said that that would be counted as a campaign violation. So she's potentially exposing herself to further disintegration of her standing and possible further legal action.
Yeah, I'm surprised the attorneys that are actually questioning her haven't picked up on some of these things, but maybe because it's not relevant right now. But for people who are paying attention, it could come up at another time, because there will be a transcript of this hearing. So anybody can, order the transcript and get it and look at her testimony again to pick things out. So there's but yes, but there, I think she misspoke probably. She didn't mean to let that out, but while she's talking and explaining herself, things are coming out that maybe if she looked back on it again, she would say, I wouldn't have said that.
And I don't want to infer anything, but I did wonder how much potentially lawyers and or judges are trained to pick up on the small slips of turns of speech that witnesses give when they're on the stand, because she did say in one part of her testimony something to the effect of the words like, I'm just making that up, or I'm making it up, or something like that, and of course that wasn't very consequential for the point that she was talking about, but I just noticed that, and I wondered whether that is something that is used mentally as a mental note for a judge.
I think she was just given an example. That's all. I think when she said, "I'm making it up," like for example, and she just was given an example, but it wasn't like a real thing that happened.
No, so it doesn't apply practically. But whether these little phrases ever go towards deciding on someone's character or not, I'm not sure.
Not that specifically, I don't think so. I mean, I do recall her doing that, but my impression was that she was trying to give a scenario. Let's say this, that didn't really happen. I'm making it up, but let's just say this is the scenario.
Okay.
Kind of a thing. But I think the slip with the campaign funds, someone might pick up on that if they get the transcript and read through it, if they're looking to find something on her.
Arlene, when I was speaking to John Malcolm, the VP of the Heritage Institutes for Constitutional Government, he was saying that he felt like nothing was really coming out of this morning's testimony. What's your take on that?
Yeah, I thought it was kind of dry. I didn't really know what the purpose was of bringing on Mr. Barnes, the former governor. I didn't hear all of his testimony. It seemed to be that he was previously asked to be the prosecutor on this case, and Nathan Wade was present, and apparently Nathan Wade did very little talking, and it was mostly Fonnie Willis doing all the talking. Now, I think he said that was in October. I think he came back into the courtroom and said it was in October 2021 that meeting occurred. I don't know if either of you wrote that one down, because they had asked him to check his calendar, and he came in for a moment and stood there and gave the date. So I don't know if the date has any significance in the terms of the two of them being together and meeting with him. She did hire Nathan Wade in November of 2021, and that meeting apparently, from what I recall, was in October 2021. But I'm not sure what that meeting was about. He said it was about an hour long, that meeting.
I mean, one of the lawyers did ask, why do you think Fonnie Willis didn't elect to use an ADA or an employee of the department for that role? So I thought it could potentially relate to the validity of choosing someone such as Nathan Wade for this role, because clearly, she was looking for someone who had more experience.
Right, and they asked him whether he thought Nathan Wade had the appropriate experience to lead this case, and he said he didn't know. He didn't know Nathan Wade's experience and his practice, and he had never seen him in action before. But then the questions were asked about his own experience and what he has done. And of course, he has extensive experience, and she came to him first. So, you know, even though it's not set out clearly and directly that Nathan Wade is too inexperienced, you can tell from his testimony that that's might be the case. But I do recall the judge would not allow them to talk about this or to make an issue out of it. So I'm not sure how it came up.
You're saying she came, Fani Willis hired Nathan Wade before she turned to, or at least met with Roy Barnes?
No, she met with Roy Barnes first. But I'm saying she went to him first to ask him to be special prosecutor, but then she ended up picking Nathan Wade anyway.
What is the timeline on that? Because Nathan Wade was in the meeting with Barnes and Willis.
I believe he said it was in October 2021.
Oh, in October.
When they met, and then she hired Nathan in November, I believe.
So he was not on the team, but he was in a meeting where she was offering Barnes the job.
Sounds like
interesting.
Yeah, that's.
You know, one of the things that came up in my interview with David Gelman, I mean, he was convinced that DA Fani Willis is done with this case. I mean, he was very serious about that.
I think both of the experts that came on, even Mr. Malcolm, felt like she was done, like she would be disqualified. And as you said, there's a low bar, and we have enough here based on her testimony alone. I think they felt that she should be disqualified. Yeah, I mean, and also I found it interesting because earlier I was saying that the judge allowed her to perform like that and let it go on for a while, but one of your experts said that that was a good thing. I think Mr. Gelman said that that was a good thing the judge was letting her do that to get it on the record, her behavior, because it helps the judge in making his decision, right? He can say, this is what happened, and because of this, you know, I think I need to disqualify her.
Yeah, and we're hearing that Terrence Bradley should be testifying pretty soon, not just yet. But yeah, you know, coming back to Roy Barnes, the former governor of Georgia, it was a very brief testimony, but I'm wondering, you know, what we got out of that?
I feel like it was the state's witness. It wasn't the defense witness, so the state was probably trying to establish, well, I don't know what they were trying to establish with him. I mean, maybe they were trying to establish that Nathan Wade was qualified to take the job, and that she had gone to someone else first, and she didn't just pick her boyfriend. Maybe that was it. That she wasn't just, you know, handing the job to her boyfriend. She went to someone else first that had all of this extensive experience, and so she thought about it. Maybe you know, I'm not sure, but I'm pretty sure it was the state's witness. They called him up first, and then he was cross-examined by the defense.
There's an interesting point that's been brought up in some commentary about the fact that this is a kind of case that's centered around a community of people, professionals who really all know each other very well. And you did hear that come up twice. We heard former Georgia Governor Roy Barnes saying to one of the defense lawyers, Ashley Merchant, that you know Nathan very well. I know Nathan very well, he said, as you do. And she said yes. And also and also saying that he knows Fani Willis very well. And also considering that Willis's father was a criminal lawyer, and so on the scene. So there's an interesting aspect of these people who have all got a very intertwined kind of history together.
So it's common when you are a similar kind of attorney, you know, they're all criminal attorneys, or they're, you know, prosecutors, defense attorneys, are all in the criminal world. So you're going to run into each other, you know, quite often, because you're constantly going to be, you know, prosecuting cases against each other. I mean, Mr. Barnes said
Arlene, sorry to cut you off. We're going to tune into the testimony of Terrence Bradley in the case. We'll come back. I'm sure we'll have a lot more to say after this testimony.
As I see this line of testimony, much of it is I'm taking in response to the original, how we started off this whole hearing, that Ms. Merchant had no basis whatsoever to bring this and she should be sanctioned. And I think she's laying that out. Okay. All right. Ms. Merchant.
I recall it was in a conference room in the front. I don't know. I know you were handling a case in Judge Harris. I think I was speaking to Bert about a case, and BC was there to speak to Bert about a case. Yes, I think I do recall that happening, but I can't recall who else was there. It was a regular court date.
That conference room, that's sort of in Cobb County, there's a conference room in front of it.
Correct.
And it's not a public room, it's sort of like the jury room.
Correct.
And it was the four of us in that room talking.
I don't recall if anybody else was there. I will say that I do remember at some point it was myself, you, BC, and Bert there, but people were coming in and out of the courtroom, so I cannot sit here and accurately say that somebody else wasn't there at the time.
We talked, I mean, and people could have come and gone, but essentially
Correct.
we talked for the better half of an
No, it wasn't an hour.
hour. And that's the only time we spoke in person about anything related to this matter, correct?
Correct.
And based on that phone conversation, I told you I had been submitting open records requests and I was going to continue to submit open records requests, correct?
Based off what phone conversation?
Based upon our conversation in court then.
Oh, okay. Correct. You said that you were doing some open records requests, correct?
And based on our conversation, I told you I was going to do some additional open records requests.
Which open records request are you talking about?
Just any, just asking if we talked about that I was going to be doing some follow-up to Fulton County. I can specify that.
Okay. Because I recall open records requests being made for other things, and so I don't know which one that you're referring to.
At that time, we talked about getting, I guess it's called a county card and getting access cards and things like that for coming in and out of Fulton County for you, Mr. Wade.
Okay.
And all of the access that you all have.
Yes. And you asked me, did I have an access card?
And you are the one that told me that you and Mr. Wade, or that Mr. Wade at least had an access card.
I told you that the three of us had an access card because we had a contract with the DA's office or the county. I told you what those contracts were and that we had an access card that will allow us to pick up the documents, go into a specific office, and leave out.
So we talked about that badge access card and asking for that. I was going to ask for that, right?
Correct.
And then a couple days later, I sent you a text. And then when I say a couple days, so that was on September 12th when we had that conversation.
Do you mind if I pull out my phone? Okay.
On September 14th at 6:38 p.m.
And what day was this?
It was September 14th.
September 14th, correct.
And I sent you a screenshot of a Fulton County open records request I did.
Yes, and I said, wow.
And then let's see. And then we continued to text.
Wait. And then you sent another text about a badge, and I did not respond. You sent another text about an entrance card. I did not respond. You sent another text about some other badges and with a circle around it, and I did not respond.
Okay. All right. Mr. Bradley, if you could just respond to the question asked and only the question asked. Thank you, sir.
I have an additional.
Okay.
Thing I want to raise. Ms. Merchant provided some text messages that she let us know that she was going to refer to. The text messages are inconsistent with Mr. Bradley's exchange as he apparently is reading it off of his phone. So if I could ask Ms. Merchant, is this it is true, accurate, and complete, and perhaps we can see what's on Mr. Bradley's phone. But more importantly, I am going to object. I understand the court's leeway about Ms. Merchant
Sure.
being able to establish contact based on previous statements made. But I'm concerned about going into the content of the statements without putting things in the buckets that I've identified.
Sure, and so am I, Ms. Merchant. I'm not seeing so much the relevance of it back and forth. I'm allowing you to establish, the contact that was made and track with that. Were you planning to tender these text messages?
I'm discussing them with him. Now, if yesterday he said we didn't text about this case, so if that was his testimony again today, then yes, I would show them to him to refresh his recollection or to impeach him. But Judge, their first part of their argument is foundation, is what I'm assuming. They're saying all of these. They're not all relevant. I can give you all of my texts, but they're not all relevant. And so they asked for screenshots, and so I took screenshots. If there's a way to submit my entire text history with Mr. Bradley, then that's fine. If they want us to read every single text, that's fine. I just don't want to be in a position where people are saying that I'm not.
Well, I also want to avoid the situation where you as the counsel of record are having to lay the foundation and do that sort of thing yourself. So I don't know how much further we can go with this before we get into that. So.
Well, I'm not sure what their objection is. So I asked him about one question and he read out
Sure.
several.
Why don't we just go with your next question and we'll see where we go from there.
All right, let's see.
But so, and
Bradley, when she wait for her to ask a question.
and I understand that, Judge, and I'm not
Well,
trying to
apparently
be
you
dis-
don't, sir. Wait for her to ask a question and you'll have a chance.
So I think the last thing I asked you was about September 14th. So those texts that you're talking about, those refer to the issue that we're here today about though.
Some text did, yes.
Yes, okay. And then you called me again on September 15th, 2023, and we spoke on the phone.
I do not recall that.
Well, I texted you and said I needed to call you back, and then I later called you back.
I'm not sure. I do not recall.
You don't recall that? Okay. And do you recall the following Monday?
Your Honor, I appreciate the question as it is on the form. And if the question is what she's going to read, I object to it even being asked out loud without knowing, number one, the relevance of it. If the witness is going to answer his source of information, and I feel like it is so inflammatory as to say out loud without knowing where Mr. Bradley falls on that, then I do have an objection to the question.
Okay. All right.
With all due respect, if I might just a moment. Why is it that we're not allowed to ask questions? And then when the question is asked, there's an objection made either by the state or the lawyers for this particular witness. It appears that what the state likes to do is force us to tell you in advance every question we're going to ask before there's an objection raised. And I don't understand why
Terrence and we'll hear shortly more about Terrence Bradley and hear from him and his testimony in the Georgia misconduct hearing after this short break. Stay tuned.
Hi everyone watching at home. We're here to remind you that if you or someone you know were injured in an accident that was not your fault, listen up. We have live agents available right now to answer your questions and tell you how much your case is potentially worth. Hi, I'm Gina Bellich, here with spokesman and TV personality Tom Mustin with us in the Help Center. So Tom, phones are really busy over there. Tell us what kind of calls you're seeing.
Well, Gina, first off, thank you for having me here in the call center with you. We always enjoy talking to the viewers and getting folks the compensation that they deserve. You know, we're seeing calls about all kinds of accidents, but the most common by far has been car accidents. So if you or someone you know were injured in an accident that was not your fault, give us a call right now. You'll speak with a live person. They'll answer any questions you have and tell you if you have a case and how much your case is potentially worth.
Thanks, Tom. All right, folks at home, you heard it. Take advantage of this opportunity and call now.
Welcome back to our special coverage of the Georgia misconduct hearing. Terrence Bradley is on the stand. Let's go back to that.
Shen, as you plan to ask it, may presuppose again some information that he has that we need to determine whether it's inside or outside of privilege. Is that right?
No. Well, I don't believe so, no. I mean, if we're going to talk about the privilege, I wanted to talk about it beforehand, which is why I gave all of these. I didn't know the state had objections on these questions to privilege. If we're going to talk about the privilege, I'm happy to ask him the substance of the question, but that is what I'm getting objections for. So I'm trying very carefully to craft something to avoid that. But I'm happy to just ask outright the question.
Right. I don't see a way around that, Ms. Cross.
I understand, Your Honor. I'm going to do whatever you tell me to do. The problem in the context that Ms. Merchant is posing the questions is, this was our communication, this is what I asked you, this is what you told me, and here are these texts that are supporting it. I understand the court's ruling that based on how things have gone, if Ms. Merchant feels like she needs to establish there was contact and communication, then I don't have an objection to that. However, number one, the text message that exchange that Ms. Merchant gave me is apparently not complete. And so I don't know, without making her a witness, how the state can, we're entitled to, if you can refer to text messages, we're entitled to an accurate representation of what those are. Mr. Bradley's looking at his phone, and that's what he's got. He is under no obligation. Ms. Merchant provided this to us, and I appreciate it. But I can't tell as I'm sitting here to object to an incomplete or an inaccurate recitation if what she gave me isn't complete.
So a couple things come to mind. One would be that anything the witness is referring to on the stand, counsel at any point has the right to inspect. And so if that's what you're asking for, Ms. Cross, then I think you have a right to do that if you decided to do that. The other is as I've seen it so far, I don't think these texts are coming in as substantive evidence, but more for impeachment, in which case extrinsic evidence would never be coming in to prove them up, and he either takes her answer or he doesn't. And that's how it works. So I don't see the foundation issue or the completeness issue really playing into it as it comes to impeachment.
And Judge, they asked me for the relevance screenshots. I took them. He doesn't have an iPhone. I can't download the entire text message history. I told him they could go through my phone. Like, I'm hiding something.
All right, Ms. Merchant. I think at this point, again, I don't see anything extravagant about the next question on his face. I think we need to deal with it as it goes, so you can proceed.
I asked you where I could get an affidavit from about the affair, and you responded no, because you didn't think anybody would freely burn that bridge. Isn't that true?
If you say so. I mean, I don't.
You have your text if you need to refresh your memory. September 18th at 3:11 p.m. in Houston.
Can you repeat the question?
The question is, did I text you asking you if you knew who I could get an affidavit from about the affair? And you responded no. No one would freely burn that bridge.
Yes, I do see that.
Then I asked you if Chris Campbell knew, correct?
No, you asked me if under oath he would testify.
Your Honor, again, I'm going to object to the source of the witness's information about that, whether that's first-hand information or not. And Mr. Campbell, of course, has a privilege too.
Well, since Mr. Campbell hadn't even been brought in to this proceeding at all, I'm also wondering about just the relevance of asking questions about Mr. Campbell.
It's been objected that I'm not asking about all the texts, and I'm selectively asking, so I'm trying to go through all of them. I would much rather just ask the very relevant ones.
Well, I have an objection to her asking. I can't tell if the statements or the testimony provided is consistent or inconsistent without a complete set of this text exchange. And it's not clear in the text exchange what the source of Mr. Bradley's information that he's providing is. And so that is, I'm struggling,
Sure.
And I know everybody else.
And again, I think you're focusing more on the merits than the impeachment value, right? If the sole purpose this is coming in is under those grounds, then you being able to match them up word for word, I don't see that as being the necessary prerequisite. But as it relates to Mr. Campbell, he's not a witness yet. He hasn't come in. I don't think he's come up really at all other than passing and maybe the firm. So why don't we skip ahead to the next questions, and you could always come back to that if somehow he is made an issue in this case.
That's great, Judge. I needed some clarity because the state is objecting that it's not full and accurate. I'm keeping things out, and then they're objecting that I'm putting too much in. So I'm just trying to avoid every question having an objection, Judge. So on January 5th, 2024, we had a text exchange where we talked about that I had discovered that Nathan took Fani on a cruise and a trip and paid for it with the business card. You told me you were on a plane home from Dubai, but you would call me as soon as you got home. Do you remember that?
So what I have is a text message from you saying, "Oh my God, Nathan took Funny on a trip to Napa and paid for it with his firm."
Okay, continue reading.
And you said, "Is he that dumb?"
Mm-hmm.
And I said, "Wow, I'm on a plane from Dubai, land at 3. We'll call you as soon as I land."
So that is accurate. That's what you told me.
That I will call you as soon as I land in Wow?
Yes.
Yes, that is accurate.
And then you told me that you weren't surprised because they took many trips to Florida, Texas, and California.
Okay, so I don't have that, and I can show my phone, but I don't have that in my phone.
So the question is just, do you recall?
I do not recall.
Communicating that to me?
I do not recall.
All right.
Do you recall telling me that it was when she had to move her daughter, a trip to California?
I do not recall that.
And Judge, may I approach the witness?
You may.
Thank you.
Oh, I see it.
See if that refreshes your memory.
Yes, I see this.
Okay. Does that look like, does it refresh your memory?
It does not. I mean, I see what's on the text chain, but you said this happened January 5th?
I can tell you exactly when it happened. Because there's no date and time stamp on that. Let's see. It was, let's see, it was if it was January 5th, but just give me one.
Judge, I just want to, on behalf of Mr. Wade, just to review the exception again. We still don't.
To which question?
To the current question, we still don't know the source of this information, whether it was privileged or how he obtained it.
I'm wondering now if there's a timeliness issue on your objection, since he already, well, he said he doesn't recall.
Right.
So there's.
He just gave the date. He didn't.
Sure. Well, his question or his answer was he doesn't recall, and his memory has not been refreshed. So I think it's time for the next question.
May I approach the witness, Judge?
Okay.
Can I see what you're approaching the witness with? So is this the complete text chain?
Yeah, it's the complete text. While they're looking at that, can I just ask you, did you delete any text messages?
I have several messages in the phone with you. I've never deleted. I mean, there are messages about family and my health and things like that. You asked me to be on some panel.
Yes.
And so I think it's complete, but.
Well, no, my question was, did you delete
No,
anything?
I haven't deleted anything. No,
Okay.
I have not.
And I offered them to look through my phone earlier if they are welcome to.
You never provided it to us.
I said you
The physical phone, you never provided it to us.
It's the only phone I have, Judge.
Yeah. I understand, and I don't want to keep popping up, but my concern, of course, is that these exchanges are just two lawyers gossiping about information. And I'm concerned about it coming into the record in this way. I understand impeachment is a thing, but if we could do it in a way that the substance of this gossip is not, that part is not impeaching, the contact is impeaching. So
I don't think we've gotten to that point quite yet, Ms. Cross, but you can renew your objection if you think we have. So right now, the sole thing that Ms. Merchant is trying to do is hand him an object to refresh his recollection again. So we'll see where we get with that.
And I don't have any way to download it.
May I?
Mr. Sato.
The court is a trier of fact. You're going to be able to determine whether something that has come in, if you choose to, is hearsay, whether it's admissible, whether it's relevant, whether it's impeachment. You're in a position that if it all comes in, but you reserve the right, or all parties reserve the right to object, we can deal with it. This is not a jury. We don't have to worry about the jury hearing something that it will no longer consider. All we're doing now, with all due respect, and I understand there's a process, the state doesn't want something to be heard.
I object to that.
They've repeatedly attempted to stop questioning. Your Honor can hear it all and then decide what is and is not relevant or admissible. We don't have to go through every single one of these. The only time you have to go through this is if it is in fact a communication, and it's a privileged communication, and an argument has to be made at that point as to whether or not it should be elicited or it is subject to being stated in open court. Otherwise, all of this could come to the court, and the court can then decide how it wants to treat it. That's
all right. I appreciate that, Mr. Sato, and I think it's certainly accurate that we could have an approach where if it's a close toss-up on an evidentiary question, we can have it all come in and sort it out later on the record. I don't think we've quite reached the point where I need to do that. I think we still have time to get into these, and it'd be my preference to keep the record as clean as possible and without questionable evidentiary issues. But we may get to that point. So the question from Ms. Merchant was to approach the witness and with an object to see if that would refresh his recollection to the last question asked.
Yes. Now, I'm sorry, the state scrolled through it, so not right there again. No, I mean like it was on the screen. Now I can't find it. So I'm going to move on to the next question that I actually can find, and then I'll find that and come back to it. I sent you a statement and said, upon information and belief, Willis and Wade met while both were serving as a magistrate judge and began a romantic relationship at that time. And you corrected me and say, no, it was in municipal court. Is that correct?
I think that's pretty accurate.
And is that based on your personal knowledge?
But what question, was it municipal court or when they first met, or?
My question was, is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And you wrote, no, that it was municipal court.
Okay.
So I answered.
Bradley, just a second. Mr. Chopra has Risen.
Sorry. Your Honor, I do have one purpose here, and that purpose has now been met. Any information that Mr. Bradley may possess would in fact have come from his representation of Mr. Wade. This falls within the purview of his divorce proceedings, which, as we testified earlier, commenced in December of 2018. There is no pierce or shield associated with it, and so we would say that under Rule 1.6, we should not be compelled to give any further information.
Okay, and as we discussed about before the break, Mr. Chopra, if I ruled earlier this morning that this witness is going to be directed to respond to any question to the extent it falls outside of attorney-client privilege and only attorney-client privilege, meaning 1.6 is not going to bar his testimony in this case, what would be your response then?
Then Mr. Bradley would have to consistently assess on his own, unless I'm jumping up and objecting for him, whether or not this came within his knowledge based on his representation. Now, I can say based on the phrasing of the question from Ms. Merchant, it would in fact come within information obtained from his partner client at the time associated with the activity in question.
All right, Mr. Evans, same issue?
I just want to reiterate that it's a compound question anyways, so it needs to be separated out, but it's still based, we just review the objection that it's still based on gossip, either gossip or privileged communication. He doesn't ever cite the source of where any of this information is coming from, so I just wanted to retain that up there.
Okay.
Judge, as far as privilege, any privilege objection, it's been waived, particularly for this issue because Mr. Wade
You did testify on this subject.
testified on this subject.
Well, he didn't testify as a communication with his attorney about any subject. He testified factually about what trips he took and events that occurred. He didn't testify, to my recollection, about any communication with his attorney.
But he testified about the subject matter of the question that was just asked, which was when apparently they first met.
Furthermore, Judge, my client wasn't privy to that testimony. We have been under subpoena and therefore under the rules, so we do not know what was or was not testified to. Everything he says would be a violation of that privilege unless we know specifically what all has been waived.
Sure, unless I make a finding that there was an express waiver on behalf of the client.
Yes.
Per question.
Right? Okay. Sure, got it.
So
All
for
right.
this question particularly, Judge, we would ask that you find that there has been a waiver of the attorney-client privilege because Mr. Wade testified to something directly different than what this witness, we believe, has knowledge of.
Ms. Cross?
Yeah, so Mr. Wade testified as to when they met. That is not the entire substance of the text message that
And began a romantic relationship.
Yes. He did not testify that they
Okay.
were serving as magistrate judges when they began a romantic relationship.
All right.
He testified differently.
Okay, Ms. Merchant, I think you're going to need to establish whether this witness ever gained that knowledge independently or during the course of a attorney-client relationship.
Did you have any, thinking back to the source of your knowledge, and let me just, before I do that, let me remind you of what is covered by attorney-client privilege. It's communications that relate to matters in which legal advice is sought, and communications that have been maintained in confidence, and no exceptions to the privilege. So it's communications that are in furtherance of legal advice. Your knowledge that their affair began, that their romantic relationship, began while they were both serving as municipal court judges. Is that from your personal information, your personal knowledge, or is that from?
I'm going to overrule that objection, Mr. Chopra. He can answer that question.
State that question again.
Your knowledge?
Is any knowledge, if any,
knowledge of Nathan Wade and Fonnie Willis's relationship, romantic relationship beginning while they were both serving as judges, is any knowledge that you have from your own personal knowledge or something that was told to you in furtherance of legal advice?
I have no personal knowledge of when it actually happened. I was not there. I do not have any personal knowledge, so I would choose not to answer that question under 1.6.
Mr. Bradley, we made a distinction earlier.
Yes, sir.
That it's a bit narrower than that.
Okay.
1.6 is
I have no personal knowledge, Judge. I apologize.
Okay.
If you were,
that's not a problem. The issue is attorney-client privilege, and so whether what you learned, if anything, was during communications with a client.
It was.
Okay, Ms. Merchant.
and was it that any knowledge that you had as to the truth of that statement, was it told to you in furtherance of legal advice?
I'm going to object to it. If that statement is true.
That's how I
am. And the witness has already testified he has no personal knowledge about that. So whether he represented at one point it was true or not true, he has no personal knowledge about that, so could not testify.
Prior inconsistent statement, Judge. Do it all the time. That is what the state does regularly. They bring in, if it's a prior inconsistent statement of another witness, Judge. Mr. Wade
which
testified.
other witness?
I'm sorry.
Okay, Mr. Wade testified.
That their relationship did not start.
But you can't impeach him with a prior inconsistent statement that's privileged. And so we haven't gotten over the privilege hurdle.
The privilege hurdle we've gotten over with fraud on this instance.
Well, that's the first time you use that word. So if you want to make the argument of why that applies, you can do that now.
Yes, Judge. The crime fraud exception. It applies because of the crime fraud exception.
Which crime and or fraud was committed here?
So there's a couple different things, and I want to just address them both because he's raised 1.6 and also raised attorney-client privilege. For the crime fraud exception says the privilege doesn't apply if the existence of it, essentially if he has to keep something secret to allow a fraud upon the court to continue. So we've got that. We've also got...
No, it has to, the legal communications have to have done in furtherance of a crime or fraud. How has that been established? And what crime or fraud are we talking about?
We're talking about perjury, lying to the court.
In the affidavit filed last month?
Yes.
And so what have you done to link the communications that he made maybe, I don't know, years ago to the affidavit filed last month?
The communications he made years ago, it's proof of the affidavit being incorrect, being false. He's given a prior inconsistent statement.
But the legal communication has to be in furtherance of a crime or fraud.
Right, but he also can't protect. So, and I think it's more under.
So if he had no idea, an affidavit wasn't even going to need to be filed until a month ago.
Right.
And these communications and everything happened well before that. How is anything that they communicated in furtherance of that affidavit that they didn't even know would have to be filed one day?
It's been waived. That part's been waived because he filed the affidavit. So you can't file something that's false and then your lawyer know that it's false and then say, oh well, privilege, my lawyer can't correct that. When he waives the privilege, and he waived the privilege, he testified about this yesterday.
Okay, Ms. Cross.
I don't think that's even close to an accurate representation of what the law in this area is. And beyond the real kind of throwing out fraud and this and crimes, which what you have, Your Honor, is a conflict in the evidence at this point. I know which way the weight of the evidence appears to me that that's going to be for the court to judge. But a conflict in the evidence, that is not a crime. That is not a fraud. That is not perjury. That's a conflict in the evidence for the court to decide.
So I agree with you there that you would have to first establish a crime or fraud occurred by a preponderance. Got it. And anything else?
Just that she can't, under the guise of impeachment of this witness, number one, establish that. Number two, the witness has already said he doesn't have any personal knowledge of that. And there is the kind of specificity that is required to lay the predicate for a crime fraud exception to the attorney-client privilege is nowhere close to being met here.
Okay. Anyone else want to be heard? Mr. Sadow.
Yes, Your Honor. This is what I said to the court earlier. This is not crime fraud. The scenario in the case, I said, do you want me to cite it for the record?
Go for it.
It's Owens Corning Fiberglass Corporation versus American Centennial Insurance Company et al. And it is 660 Northeast 2nd, 812, out of the state of Ohio, Lucas County, Court of Common Pleas of Ohio. And it references, I'll make sure I get the right page here. I think it's page 256. The point in the case, or the holding in the case, if to be a party or a witness chooses to testify falsely, and our position is that Mr. Wade testified falsely when he claimed the relationship did not begin until 2022. That if there are attorney-client communications in which the same individual witness has told his attorney something contrary to that, inconsistent with that, here that the relationship, the personal romantic relationship between Mr. Wade and Ms. Willis began prior to November 1st of 2021, which would be the day that he was hired. That if that communication took place, that is the attorney communication, that the fraud upon the court is Mr. Wade lying under oath about the starting date, and the attorney-client privilege under those circumstances, where that material fact is pierced, and the attorney may be forced to testify to the contrary or inconsistent statement so that the fraud on the court no longer holds. In our situation, that is precisely what we are trying to do. If this witness's testimony, again, and the court may have to hear some of this ex parte in camera to determine, but if this witness is able to testify that Mr. Wade told him, under whatever the circumstances may be, that the relationship with Bonnie Willis began before November 1st of 2021, then we know from what the witnesses testified to Mr. Wade that he lied under oath to the court, and that's a fraud upon the court, and the attorney-client communication that specific matter is pierced and needs to go into the record. Now, how best to do that? The only way to do that, if it's not in writing, and apparently it's not, is for the court to hear in camera, ex parte, what the communications were that are sought to be kept privileged. If the court deems that it is not inconsistent or contrary to what's testified, then you wouldn't pierce the privilege. If, on the other hand, this witness honestly, that is, now we're talking about Mr. Bradley, actually testifies to what he has told in text messages to Ms. Merchant on behalf of Mr. Roney, that he absolutely knows that the relationship started before November 1st of 2021, then he's testifying that his client took the stand and lied under oath and therefore did a fraud upon the court. So my request is, in this regard, the court's going to have to hear from counsel, and from counsel to Mr. Bradley, and from Mr. Bradley to determine whether or not he actually said what he said to Ms. Merchant, and whether or not it was based on communications, whenever it took place, with Mr. Wood.
All right, Mr. Sadow, I understand. Thank you for clarifying your argument there. So I understand this fraud upon the cart theory, and what I'd been going back and forth with Ms. Merchant on earlier was that, as I understood, crime fraud applied in Georgia was that the communications had to have been in furtherance of a crime. And to me, that presupposes the existence of a crime at the time, or the forming of one at the time of the communications. The theory you're putting forward is one where we go back in time and can reopen that box because it's now become relevant for something completely, potentially unconnected to the communications whatsoever. Is that fair?
That falsity has occurred now by the very person who is attempting to use the communications as a shield to protect his lives.
Okay.
And when I say crime fraud, it's a fraud waiver. That's what Milich calls it. Is essentially. Milich says that it doesn't offend the privilege to ask an attorney to testify to matters already freely discussed by the attorney and a client at another hearing or proceeding. Allowing a client to selectively waive and reassert the privilege as tactics dictates. Suggests that the client is using the privilege as a sword and not merely a shield.
Sure. So I think it was quite explicit that Mr. Wade never waived anything regarding to communications between him and Mr. Bradley. He was willing to discuss the subject matter, but he was never willing to get into communications that occurred between him and Mr. Bradley. So as to Mr. Sadow's point of this fraud upon the court theory, my question is going to be, has it ever been applied in Georgia?
And the answer to that is, it's not appears to have been applied in Georgia. I cannot find a case in which it has been applied. The cases that I have, the case that I gave you plus the cases cited in there, are the only thing I've been able to locate. Although I think that the bar rules, if we want to go back to those, and I'm not going to tell you, that a lawyer should not allow his client to commit a fraud upon the court.
Okay.
And I think that, along with this, gives the court the discretion to do that. And the only way to make the record, even if the court suggests that this is the law that the court should apply, But even if the court disagrees, there's no way for there to be a record about it unless Your Honor does it ex parte in camera to determine the nature of the privilege, which of course Your Honor knows from earlier days is how judges can do it with the Fifth Amendment privilege. They can do it with any privilege as long as it's ex parte in camera. So what I'm asking the court to do, because when I get up, I'm going to ask you directly. I'm not going to go through this that's going on now. To find out whether or not Mr. Wade has ever told Mr. Bradley in his capacity as his attorney or otherwise that the relationship started earlier than what Mr. Wade testified to.
All right, understood. So the big takeaway I'm hearing from that, Mr. Sadow, is that once again, we're hearing the words a matter of first impression here, and noted. Mr. Gillen.
Yeah, very quickly, Your Honor. Number one, he apparently, now he's claiming a privilege, which he certainly did not assert when he was communicating in a text with this version.
Sure, but do we have any indication Mr. Wade waived it and allowed him to communicate by that text?
We know what he did. We know what he did.
So how is that an implied waiver?
And I would assume that as the attorney, that he would know whether or not he should protect a communication.
That's a pretty big assumption, right?
Not all communications are protected, number one. Number two, let's not forget how we started on this journey with the state getting up and making very serious allegations against Ms. Virgin, asking for sanctions, saying all of her representations were inaccurate. And now they are doing whatever they can to block access to that information, which shows exactly what she said was exactly the truth. What they're trying to do is they're trying to say to the court the 100% accuracy of Mr. Wade's declaration and of his testimony. And by the way, please, Judge, don't let Mr. Bradley tell you what he knows, because what he knows is that this relationship, based upon what we see from the text and what we've seen in the context, we show that the relationship started before November 2021. So I think we have a waiver issue, and parenthetically on the issue of crime fraud, Your Honor, the issue about crime fraud is whether or not in any context the communication would be not in furtherance of a crime at that time, but it could be for any particular crime committed by the client in the future as well. It doesn't have to be something that's being committed at the time. I will also note that when you look at the attorney-client privilege, the law basically says, look, this is a privilege which blocks evidence from coming in. And so in order to have that, they have the crime fraud exception, which is a very low standard once a prima facie showing has been made, which I believe has been done by Ms. Virgin.
All right, let me clarify one thing, Mr. Bradley. When you testify to personal knowledge, does that include anything you may have seen, heard, outside of communications with a client? When you say you lack personal knowledge, does that include anything you may have seen or heard outside of communications with a client? And you can tell me if that question is horribly phrased. Try again.
You try to rephrase it for me, Judge? I'm sorry.
Okay. When you say you lack any personal knowledge,
yes, sir.
Does that also mean that and include anything you may have seen or heard outside of communications?
Outside of communications with my client.
Mm-hmm.
That's correct.
Okay. And communications that were made, if any, that relate to the subject that you were asked to, were there any other third parties present that may have resulted in a waiver of privilege?
Including texts.
Am I answering your question or her question? Okay.
Are there any other third parties ever present with you and a client that would have resulted in a waiver of these privileges?
No, Judge. I can't recall anybody being present. I mean, we ran an office. We had people around our office, but no, I can't say that there were other people present.
All right. And did you ever receive any kind of a waiver from your client at any point?
I have not received a waiver.
And anything that you learned regarding the subject matter at all, if anything, was it in the course of legal advice, of receiving or giving legal advice?
That's a broad question, Judge, to answer, because the advice was given, and then you have interaction. I mean, it wasn't, hey, this is for, to say specifically, this was for that, or, I can't sit here and say that. So I don't know how to answer that question, Judge.
Okay. All right. So
I was given a case that may reflect the same proposition that was argued from it's older case. It's Atlanta Coca-Cola Bottling Company versus Goss, G-O-S-S. 50 Georgia Appeal 637 appears to be a 1935 decision. Has not had the benefit of separating it. So I can't say that certainly hasn't been limited or overruled. And looks like it's in reference to maybe head note number 2, at least the one I'm looking at on the computer. And language that is in the case, okay, is as to violations of law or commission of fraud, the protection extends only to communications after the act or transaction is finished. It does not cover communications respecting proposed infractions of the law in the commission of the crime or the perpetration of the fraud. And then it cites some cases. And then it goes, the privileged communication may be a shield of defense as to crimes already committed, but it cannot be used as a sword or weapon of offense to enable persons to carry out contemplated crimes against societies, frauds, or perjuries. So our position, as I indicated before, is the witness, Mr. Wade, has committed perjury on the witness stand and called into question the statement.
All right, understood, Mr. State. Mr. McDougall.
Your Honor, this is adjacent Georgia law, perhaps not controlling it. I'll explain that in just a second. And that's Rule of Professional Conduct 3.3 A2. A lawyer shall not knowingly fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client. A4. Now, the reason I would qualify that, since we're talking about candid report, I need to do that. I believe this rule is regarding the conduct of advocates representing clients in court. It might not govern or control the situation where the lawyer has been put on the stand, but it's adjacent to the point Mr. Sayal made earlier.
All right, fair point. Okay, Ms. Trooper, anything you want to address on that?
Briefly, Judge, and clearly there's a lot of smarts in this room, but this whole thing is a deductive fallacy. It is suggested that the truth of the conclusion of the argument necessarily follows from the truth of the premises given, when in fact the conclusion does not necessarily follow the premises. They're, called him a perjurist. He has officially succeeded in saying the thing itself is true. Therefore, we must ask these other questions. And Judge, it's a fallacy. It does not exist as such, and the privilege should still apply.
All right. Thank you all. So I think here is what we need to do, as I understand the law. As I find it, the crime fraud exception only applies when by preponderance we found that communications made in the existence of a relationship were in furtherance of a crime, or the client at the time knew or reasonably should have known that a crime, the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards, and that's something that can be argued during closings, essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some uncertainty on that point, and so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were, if any were relevant. Or excuse me, not relevant, but just what they were, and those would remain sealed until some time if we're ever directed otherwise. However, at this point, the question, getting back to the question asked by Ms. Merchant, as asked, would be sustained on the issue of privilege, the premise. He may have told you something, but it does not appear that there's any evidence that the client ever waived and allowed that information to be conveyed to you. Next question.
Thank you, Judge. All right, let's see. So we talked about Ms. Willis and Mr. Wade coming to and from your office and security details following them. Do you recall that?
Do I need to look at my phone?
No.
Just asking if you recall.
Oh, do I recall? I think I did, yes.
Do you recall security taking Ms. Willis to your office?
I'm going to check to that.
Does he recall
Actually, I
Ms.
take
Willis
that back.
taking?
I don't do that.
But you can answer the question, sir.
I do recall security detail bringing Ms. Willis to my office.
Okay. Do you recall approximately when that was?
I do not.
And was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
So I don't know if she had security detail before she became DA. So, I mean, if she was sworn in, or I don't remember the dates, but I do remember. I think she was DA.
Maybe during her transition team period? Was that?
No, it wasn't. Trying to remember. She would have had to have been the DA.
All right, joining us now is Clinton impeachment manager and attorney Bob Barr. Bob, thank you so much for joining us today. You were one of the leaders of the Bill Clinton impeachment inquiry back in the late 90s. Compare and contrast what you're seeing now with Fulton County DA Fani Willis and what you saw in the 90s with former President Bill Clinton.
What we had in the impeachment of Bill Clinton, both in the House hearings on the impeachment and in the Senate with the trial of Mr. Clinton, was a very clear and firm presentation of evidence that Mr. Clinton had violated federal criminal laws and therefore was subject to impeachment. What we are witnessing in Fulton County, Georgia, right now is not a case on the merits with regard to Mr. Trump and the other co-defendants who are charged under Georgia criminal law by District Attorney Fani Willis, but a major mistake by Ms. Willis in how she proceeded with this case and allowed the case itself to overlap with her personal relationship with the man that she assigned as a special prosecutor in this case. And what is happening now is the credibility that she needs to underlie her case if she wants to succeed is being demolished because of the personal relationship that she had with the man that she appointed as a special prosecutor and caused hundreds of thousands of dollars to be paid to him.
And former Congressman Barr, tell us what kind of picture of this relationship between Fulton County DA Fani Willis and Nathan Wade has been painted in the past day or two here?
Well, Ms. Willis and Mr. Wade maintained before Ms. Merchant, who represents one of the defendants, before she filed a motion to disqualify Ms. Willis and Mr. Wade because of their improper relationship, the case was proceeding in due course. However, what has emerged is a picture of utter dysfunction between the district attorney's work and her professional career and her personal relationship with Mr. Wade. And this has drawn into question whether or not Ms. Willis and Mr. Wade have lied under oath in various proceedings relating to this case. The judge has to decide basically whether there is sufficient evidence to raise a conflict of interest or at least appears to present a conflict of interest with the district attorney and Mr. Wade, such as should require the case to be taken away from the district attorney and assigned to another district attorney's office.
And what do you think is going to happen here with this? Is that going to happen? Will she be disqualified here?
I think that the judge will have to find that even without getting into deciding every single element of when Mr. Wade or Ms. Willis might have been untruthful to the court, that there clearly is sufficient evidence already that brings into serious question the confidence and the propriety of the relationship and presents what is by every appearance a conflict of interest, and that he probably will in fact remove it from Fulton County and have it or cause it to be reassigned to another district attorney's office, which could very well represent either eventual dismissal or certainly a very lengthy delay in the trial itself.
And what kind of impact could any disqualification of DA Fani Willis have on the defendants who've already pled guilty here?
That's going to be a problem for those defendants who have already pled guilty. If, in fact, the case is taken away from Ms. Willis's office and the state is forced to find another venue, another district attorney, then the case may very well proceed forward. However, if, in fact, the case is assigned and that district attorney decides not to prosecute the case, then those defendants who have already pled guilty may be out of luck. Because once you plead guilty, once the court has accepted that plea, and once you have been sentenced, there is finality. So they will have a fairly difficult time reopening their case under those circumstances.
And yeah, Fulton County prosecutors will not call Fani Willis back to the witness stand. What does that say, if anything, about the testimony she gave yesterday afternoon?
Her appearance yesterday afternoon was one of the most bizarre that I have ever seen by a witness, particularly a public official who is a witness. Her behavior, I think, was very, very untoward. It was unprofessional. I think that she really wound up hurting her case and her office by her antics in the courtroom. The judge allowed her to go on, which surprised me, but perhaps he was simply giving her enough rope to hang herself. But I think her appearance yesterday was very harmful to the prosecution.
Yeah, and say a bit more about that. How does it reflect on this case, on the court there?
I'm sorry?
Can you say a bit more about that? How does her conduct reflect on this case and on the court?
Well, one of the key issues that the judge is deciding here, is being asked to decide, is whether or not there is a conflict of interest or the appearance of a conflict of interest. And if in fact he finds either of those, then he will have to take certain measures, and that would likely include having Ms. Willis removed from the case. Whether or not that would allow for another district attorney in the Fulton County's office to take over, or whether it would have to be assigned to another district attorney would remain to be seen. But if in fact there is found to be an appearance of a conflict with regard to discrepancies in what Ms. Willis and or Mr. Wade have testified to, either in writing or in court, and I think there is clear evidence of that because so much has been disputed here, I think the judge would have to have the case removed from Ms. Willis's purview.
And speaking of the contradictions between their testimonies, we heard from Miss Yearty, Robin Yearty, a friend of Fonnie Willis. Who they've known each other on and off for almost 30 years. Yearty said that Willis has had a romantic relationship with Nathan Wade as far back as 2019, in direct contradiction to what both Willis and Wade say about their relationship starting in their romantic relationship starting in 2022. Can you talk a bit about that contradiction and what Yearty's testimony could mean in this case?
The importance here is whether or not there was a romantic relationship between Mr. Wade and Ms. Willis before he was given the responsibility and paid to be a special prosecutor. If that relationship existed prior to him coming on board, then that would be highly improper. If, on the other hand, the relationship developed after he was brought on board and did not influence bringing him on board and allowing him to be paid, then that's another matter. That may present a personal issue that does not look good for the district attorney's office, but that would be far less important and less serious than if, in fact, the judge believes the testimony that you referenced, that the relationship between Mr. Wade and Ms. Willis existed before he was offered this opportunity and the pecuniary interest that came with it.
Talk about these cash reimbursements that Willis mentioned. We know that Wade paid for trips for both he and Willis, and then Willis says that she paid him back, but in cash. And she's saying it's not traceable because she had the cash in her house. Talk about this.
It would be hard for, I think, the average person to listen to either Mr. Wade's testimony about being paid in cash and using his business account to pay for personal trips, and it would also be very difficult for the average person to believe what Ms. Willis is saying, and that is that she would, as a matter of course, keep thousands of dollars, up to $10,000 or $15,000 in cash in her house all the time, and dole out that whenever she needed it for a date or a trip. People normally don't use large amounts of cash or keep large amounts of cash lying around all the time for those purposes. Now, if it was true, it certainly raises some serious questions about her judgment. If it's not true, then it clearly would provide grounds for the judge to find that there has been improper testimony and that the credibility of the district attorney has been seriously undermined, and would find the appearance, certainly, of a conflict of interest.
What about the fact that she went on these trips with Wade and even with Wade's mother, but she didn't tell her father about it? In fact, her father didn't know at all about Willis, their relationship. She said that she was going on trips with Wade. She said she was going on trips, but she didn't say she didn't say who it was with. What about that?
Well, it's probably an effort to try and keep the whole thing secret. They said, well, we weren't trying to keep it secret, we were trying to keep it private. But I think that's sort of testimony, not telling parents at certain times, not telling other people. And then with the district attorney fighting so hard against what Ms. Yurton was testifying to, I think here again goes to the credibility of Ms. Willis in this matter.
And let's look at some of Trump's other cases. His New York civil fraud trial is we're expected to hear a verdict today. Where are we with that?
Well, the judge in the case, I believe you're referring to the case in which Mr. Trump's financial statements are at issue. The judge apparently is near to reaching a decision, which pretty much is preordained based on what the judge has found earlier, and that is to find that Mr. Trump seriously and deliberately and consistently undervalued his properties or overvalued them in certain circumstances, undervalued debts and so forth, in order to get more loans or better terms on loans. And that could certainly, if the judge does find that he did that over a course of time, severely impact the Trump organizations and the Trump's family from engaging in certain business activities in the future, at least in New York State.
And are we expecting a Trump appeal?
Oh, I certainly would believe Trump would appeal that. I would be very surprised if he didn't.
And what could that look like? What could that path look like?
Well, of course, in New York, you would go up from the Supreme Court, which is what the basic trial court level in New York is called, to their appellate division, I believe it is, and Mr. Trump might call into question the prejudices on the part of the judge, that the judge had made up his mind before even hearing the evidence. Mr. Trump might also take issue with not having these issues presented to a jury as opposed to just a bench trial, so to speak. So I think there will be many grounds for appeal, and that could take some period of time.
Okay, Bill Clinton impeachment manager and former Congressman Bob Barr, thank you so much for your time today.
My pleasure.
And we're going to turn back now to the hearing in Fulton County, Georgia, focusing on the relationship between DA Fani Willis and the special prosecutor in the Trump Georgia case, Nathan Wade. Let's tune back in.
Okay, I see.
So on, now that you've reviewed those, is it true that on January 25th, 2021, you got your first contract as a taint lawyer?
As a taint lawyer, yes, I see the date on that as a taint lawyer, but I'm also looking at this contract here for first appearance, and there must have been, I don't have it before me, but there must have been a contract before this.
Okay, so you think there's a fourth contract?
I can't say that there is or isn't. What I do know is that we did first appearance during COVID, and it was before 2021. So I don't know, if I had a written contract at that particular time or anything, but I do know, I think that you could look at the recordings because everything was recorded at that time as to when the first appearance contract started and the taint contract started.
So when the three of you were partners, you had at least two contracts to do taint work, which is filter work. and then at least 2 contracts to do first appearance work, pretty much throughout that entire 2 years, right?
Well, it renewed. So, I mean, it just renewed. So yes, I mean, if it was the same contract, but it was a renewal of the contract.
So how did you, and you said you got these contracts through, Ms. Willis gave them to you, but it was through her knowing Mr. Wade, correct?
Yes, I didn't have a meeting with Ms. Willis or anything. It was brought to the attention that a contract was going to be needed or awarded, and if I was interested, because this was off of mine, and I said yes, and so
Mr. Wade brought that to your attention?
He asked if I was interested in doing the contract, correct. And then after that is when Ms. Willis, would come in, or I think we actually came down here or something, and signed the contract.
Okay. And so that is how you were paid from Fulton County, these contracts?
From Fulton County government? Yes, ma'am.
And you shared, your partnership, you shared 1/3 of all your profits with Mr. Wade?
At that time, yes.
And so his contracts, he got a contract that same year, 2021, and he shared 1/3 of all his profits with you, correct?
Yes, that should be fairly accurate.
Okay. So during 2021, 2022, you all had 2 filter taint contracts. You had 2 first appearance contracts, and you had Mr. Wade's special counsel contracts, correct?
My firm had what I have here,
Okay.
correct?
But Mr. Campbell and Mr. Wade were part of your firm, correct?
So I don't think at this time we had established WBC.
Okay.
At this time, I think I had mine, Chris had his, Nathan had his, and we operated in the same building. But if you ask me, did we fee share, or, without everything that came in, yes, that is correct.
So you weren't actually partners, you just fee shared?
At this time, well, yes, at this time, we were not. At this time, I had Law Officer Terrence Bradley, Chris Campbell, PC, and whatever Nathan's was, if I'm not mistaken.
And all these the taint contracts and then Nathan's special counsel contracts, all of those were under the anti-corruption unit, correct? You can look.
First appearance was not under that. The taint contract, if I recall, was under the. I don't think they called it. What are you calling it?
You can take a look at your contract if you need.
Okay.
And I'm not asking about the first appearance. I'm asking about the taint contracts
Mm-hmm.
and then Mr. Wade's contract, which has already been admitted in evidence. If you need to look at that. Let me know when you're done reviewing.
Well, I see on the first page where it says taint attorney, and I'm trying to go through and I see where it continues says taint attorney, but it always says Fulton County District Attorney's Office. Your question was specific as to the anti-corruption unit, and I'm looking for the verbiage of anti-corruption unit, so I apologize.
No, take your time.
And see, on both pages, I mean, it starts out Fulton County District Attorney's Office, and then it just goes to initials FCDA, unless I'm overlooking where it says the anti-corruption unit, then the contract was with the FCDA. I mean, unless you want to show me something.
I'm just asking you, and I didn't know if that would refresh your memory. Those contracts were for the anti-corruption unit, right?
Well, they were for the district. I worked for the DA.
Okay.
I worked for the DA.
Okay. So just in general, the DA.
Correct. I worked for Fulton County District Attorney's Office in as a contract person, as it says here.
And when you did the taint work, you had to report to Sonia Allen?
I did not.
You did not. Who did you report to then?
I can't remember his name. His first name was Brian.
Okay. And let's see. So I know you said you met with Miss Willis when you signed those contracts, right?
Yes, I know I met at least one time to sign these contracts, or to sign when I signed the contracts, yes.
Did you meet with her any other times?
I did not personally meet with Ms. Willis any other time. When you say meet with, what do you mean meet with?
Talk with her, meet with her.
I mean, I would see Ms. Willis in passing if I'm walking through the office and something like that. But no, I didn't have any meetings with Ms. Willis.
Okay, so the only times you met with her were when you signed those contracts.
Clarify meet with. I mean, not.
Sat down and had a conversation with her.
I signed these contracts, so when I signed these, I met with her to say that I sat down and spoke with Ms. Willis. Are you saying in life, and you saying during this time? What are you asking me?
I mean, if it's voluminous, I can narrow down the times, but I wasn't in.
Ms. Merchant, I haven't really heard a point in a while. Can we get along to something, or we're going to have to wrap it up?
So I had one more question about your text. Have you ever been in any group text with anybody other than, with me, and somebody other than Mr. Chopra and Mr. Merchant?
You got to narrow that down. I'm sure you sent many texts.
I can look at my phone.
No, with him, if there had been any other texts. And I think that the state had some things in rebuttal they mentioned, so I was just trying to clean that up before it got there.
Can you try the question one more time for me?
Yeah. Isn't it true that the only texts that you and I have ever had have been between me, you and Mr. Chopra, or me, you and John Merchant, correct?
Can I look at my phone?
Sure.
And what's the relevance of that, Ms. Merchant?
They've said multiple times that there's this third party that we've talked to, and I'm trying to establish there's no third party. And I don't know why it was relevant, but the state's argued it, so.
Well, if Ms. Merchant doesn't know why it's relevant, then maybe it might become relevant later, but right now.
Ms. Merchant, I think you've been able to show what maybe launched this and answer the state's initial claims, and so let's get back to the core of what we were here for this hearing. Do you have anything else relevant to ask this witness?
Yes, just a few more questions. After it became known that you were placed under subpoena, did you get a call from Gabe Banks?
I did.
And was he trying to determine if you were going to be giving information in this case?
I don't know what he was trying to determine. He stated that it was an odd. I had not spoken to Gabe in a while. We are colleagues. We are friends. We are in the same fraternity, Gabe and I. And when he called, it was out of the blue. But he did call, yes, ma'am.
Okay. And you relayed that to me as well, correct?
I did.
And then you also got a call from your best friend who was relaying a message to you from Mr. Wade, correct?
No, I got a call saying that he got a call, not that a message that was supposed to be relayed to me. The call was,
I'm going to check if there's a hearsay, the responsible call for hearsay. Thus far, it hasn't, but
Sure. So hearsay objection as to the contents of the call, Ms. Merchant.
I believe the contents of the call were to remember your privilege. I took that as a threat. I think Mr. Bradley took it as a threat, and I think he would testify to that.
And
hasn't testified to it. He also said there wasn't any message relayed by Mr. Wade or any other party.
well, no, he didn't say it was by any party.
Mr. Wade.
So assuming he did hear something from a party, what's the hearsay exception for that, Ms. Merchant?
I believe that it was a threat, so it's a statement against interest. I'm sorry, it's a, if he took it as a threat to influence his testimony, then it's not hearsay, then it would be admissible.
All right, so.
I did not take it as a threat.
If you're saying it's to the effect on the listener, perhaps?
Yes.
Then we'll go from there.
Were you told to remember your privilege?
Your Honor, the witness just testified he didn't take it as a threat.
Understood. I'll overrule the objection and the testimony given the weight it deserves.
Can you repeat the question?
Were you told to remember your privilege?
Your Honor,
I was not.
The witness, there may be a potential witness now in the courtroom because the person that Ms. Merchant is referring to is sitting in the courtroom.
Well, if that witness hasn't been told to testify, then I don't see any sequestration issues.
I don't know who it is. I don't know his name.
Okay, and so were you told anything to that effect, Mr. Bradley?
Repeat the question one more time, but so I was not told, remember my privilege.
Something about privilege, remembering that.
I do recall privilege being mentioned, but it wasn't remember your privilege or, a threat of any sort.
But you immediately called me after.
No, I called someone else after.
You called me quickly thereafter then.
I talked to you that day, yes, ma'am.
Okay, thank you.
Mr. Sadell.
Your Honor, because this is a defense witness, is it the state's first cross? I think that's how we had been doing it yesterday.
No, actually, we're doing it just this way.
Yeah, I've been.
Okay.
This is the first time he's gone, and then we go through all the defense, and then you'll have your chance.
Some foundation questions to begin with, please. Your testimony as you began representing Mr. Wade as his attorney on what date or what approximate date?
I didn't have an approximate date.
And give me an approximate date when you began acting as Mr. Wade's attorney.
I would say it was, if I'm speculating.
I really don't want you to speculate. I mean, you're the one that was the attorney and Mr. Wade was the client.
Correct.
So give us the ballpark figure of when it was that you began acting as his attorney.
Maybe 2017, 2018, I think, maybe.
And the purpose for which you were retained?
His divorce.
So, according to you, from that time period, your communications with Mr. Wade with regard to the divorce or any matters related to the divorce, it's your position are confidential, are privileged, correct?
Yes. Yes.
Okay, good. Now, did you ever meet with Ms. Willis and Mr. Wade prior to, and everything I'm asking you is prior to November of 2021, okay?
Okay.
Keep that in mind. That's.
Why are you yelling?
I don't think he's yelling, Mr. Bradley. He's just speaking up. All right, Mr. Sadell, let's go.
Okay, thank you. Prior to Mr. Wade getting his contract with Fulton County, which was November 1st of 2021, okay? Just please keep that in mind.
November 1st of 2021.
Right. Did you ever socialize with Mr. Wade and Miss Willis prior to November 1st of 2021?
I've never socialized with Mr. Wade or Miss Willis in any setting. If you're asking, have I ever met with them, then I would say yes. But when you say socialize, what do you mean socialize?
Have you ever gone out to eat with both of them?
Before 2021, I do not
Or
think.
November 1st of 2021?
Out to eat with both of them before. When was she sworn in? I'm sorry. When was she sworn in? There was a dinner. There was a dinner before. When she was sworn in, that I attended. Shaquille O'Neal was there, so it was like her inauguration dinner. So I'm thinking that's before 2021. So I would say yes.
Let's assume for purposes of my question that
Yes,
that's
sir.
in early January of 2021.
Oh, that is early January 2021. So yes, it would be before November. So if it was January, yes, that dinner would have been in, I'm assuming, January.
Okay. And any other time that you socialized, went out to eat, went to anyone's home, you know what socialized is.
Exactly. So no, I did not socialize with Mr. Willis. With Miss Willis and Mr. Wade.
So prior to November 1st of 2021, did Miss Willis come to your offices? Your offices, the offices that you shared with Mr. Wade.
I think she came once or twice to our office, correct?
And the purpose for which she came?
I don't know. We had separate offices. I do recall. I do recall some type of meeting happening at our office, and I don't know what that was about. I wasn't a part of those meetings. There was a meeting. There were other people there. There were other people from the, I want to say DA's office there, maybe.
Okay, let's go back to the basics. Ms. Willis came to your offices, together offices, on a couple different occasions.
I recall Ms. Willis coming to my office at least twice.
And on at least one of those occasions, or you tell us, did Ms. Willis meet privately with Mr. Wade in his office that you observed or heard?
I can't recall.
You can't recall?
No.
Did she ever meet with you in your office? Ms. Willis now.
Privately in my office? No. I've never met privately in any office with her outside of signing this contract.
Did Mr. Wade, prior to November 1st of 2021, ever talk to you about socializing with Ms. Willis?
I can't recall.
You can't recall?
You're asking me if he ever mentioned to me that he socialized
with Ms. Willis, correct?
And I'm saying I cannot recall if he socialized with Ms. Willis, if he ever mentioned to me that he socialized.
Did he ever mention to you that he ate or went out to dinner with Ms. Willis? Again, time period before November 1st of 2021.
Did he, repeat your question?
Mr. Wade ever tell you prior to November 1st of 2021 that he had socialized, gone out to eat, visited Miss Willis in anything other than a professional setting?
I'm sure he did, maybe. I don't recall any specifics of any dinners, any specific places. I mean, it's been 3 years ago, the time frame, but I do not recall at this time whether or not he ever mentioned any dinners or socializing.
Did Mr. Wade mention to you that he visited Miss Willis at Miss Willis's then current abode, which would have been a place, not her original house, but a place she was staying in the period of 2021 before November 1 of 2021? And his question is, did Mr. Wade ever tell you that he visited Miss Willis at her house?
I don't think I can answer that.
Yeah, privilege based on communication with my client.
All right. Mr. State, if you want to try and rephrase the question, you can, but otherwise that would be sustained.
On both grounds or just on the privilege ground?
Just, I didn't hear a second ground.
It was a hearsay ground.
Oh, that would be on privilege alone.
Did you talk to Mr. Wade at all about his relationship with Miss Willis prior to November 1st of 2021?
I think he's just laying a record, Mr. Wade. It's okay. And so on those same grounds, Mr. State Allen, all subsequent grounds, apparently the relationship with Miss Willis in any way is covered by privilege according to this witness.
Well, I think the key words, respectfully, Your Honor, are according to this witness. So I'm trying to drill down to see if there are communications that are not within the privilege.
Sure.
I can.
So then we need to acknowledge the privilege in the form of your question, right?
You're asking me to ask it as in a way saying, are there any non-privileged?
Essentially.
Okay. Did you ever communicate with Mr. Wade prior to November 1st of 2021 about Miss Willis that was not privileged?
I mean, we discussed this contract, but
This contract doesn't help. You have to give me a exhibit number, please.
you said before November 2021?
Yeah, November 1st of 2021.
Before November, this contract for 1/25/21 is before that. So I mean, we discussed this contract.
Okay. And if I remember correctly, again, just give me that exhibit number so we can reference it.
Exhibit 23.
Okay, hold on 1 second. 1 second. On Exhibit 23, did I understand you to say that it was Mr. Wade that effect brought to you and Miss Willis together for the contract?
That would be accurate, yes.
Okay. And what did you understand was a relationship at that point between Miss Willis and Mr. Wade, for Mr. Wade to be able to bring you to Miss Willis for the contract? It's not a hard question.
No, I'm just, state that again.
Mr. Wade is the one that basically says to you, go see Miss Willis about this contract, right?
Mm-hmm.
That's a yes, correct?
Yeah, yes.
So Mr. Wade had to have some knowledge, you would assume.
Yes.
Right? That you going to Miss Willis might bring you the contract.
I never went to Miss Willis. So I stated I never went to Miss Willis. I was told about that there was a potential contract, and that I was asked by Mr. Wade if I would be interested in doing that contract.
Okay, my question to you is, what was the basis that you understood Mr. Wade being able to potentially offer you that contract on Miss Willis's behalf?
I'm going to object to that. That's a mischaracterization. Mr. Wade offered it to him. I think he said he expressed interest. And also, I don't see the relevance of this at all.
So just in terms of relevance or phrasing, I'll overrule on those grounds. So the question that's standing unobjected to, Mr. Bradley?
Can you repeat the question?
You've explained to us how the contract came to you, correct? Yes. My question is, what was your understanding of the relationship of Mr. Wade and Miss Willis for it to have been offered, or whatever word you want to use, for him to have said, expressed to you whether you had an interest in the contract?
privilege.
All right, Mr. Evans has invoked privilege on that question, so Mr. Sadao, I think you need to clarify whether...
Was it a privileged conversation that you had with Mr. Wade that let you know about the contract?
Or, you know, it was the relationship was the question you're focused on.
Is the nature... No. I'm trying to do it in such a way, and I understand what the court said. Was the relationship that I asked you about just now between Mr. Wade and Ms. Willis that gave rise to the contract? Did you know about that relationship as a result of an attorney-client communication?
No, I knew of that through whatever work they did together as municipal court judges.
And how did you know that? Who told you about the work that they did together as municipal court judges?
Mr. Wade told me that they did work at some conference.
Okay, now this would have been something that Mr. Wade said, according to your time period, at the time that you were representing Mr. Wade, correct?
Say that again? Ask that again?
Mr. Wade would have told you what you just told the court after you had established an attorney-client relationship with Mr. Wade, correct?
Yes, but when he told me of them being at a conference, I mean, I'm not understanding how relate. I'm trying to understand your question.
Well, my question is basically, you had communications with Mr. Wade directly that
Yes.
were not attorney-client privilege, right?
I've had conversations with Mr. Wade that were not attorney-client privileged, yes.
That involved Ms. Willis, correct?
I just stated that they were at a conference. I don't know whether or not that involved her or not.
Well, if he's talking about her, that is, if Mr. Wade is telling you about Ms. Willis and Mr. Wade having met at a conference, right, then he's talking about Ms. Willis, correct?
Yes, but he also told me about other people that he met at the conference.
But he told you about Ms. Willis as well, correct?
I think so, yes.
So there were communications in which Ms. Willis was at least a topic that was not covered by attorney-client privilege, correct?
This particular instance, I was told about a conference. And
when were you told this?
I can't remember the dates of the conference, but it was after. It would have been after the conference.
Okay, I'm trying to get just the time period here. After the conference, I want you to understand from the record, I believe we've shown that the conference was sometime in October of 2019.
Okay.
So could you give us an idea, that being a fact, when you would have had this communication about meeting with Ms. Willis at the conference, that is, Mr. Wade meeting Ms. Willis at the conference?
If that's the conference that they were at, yes, then, I don't know how many municipal court conferences there are. I do know that at the time that I was in the firm, Mr. Wade was, he had some position with the municipal court.
Yeah, right now my only question is time-wise, assuming it's October of 2019, when do you tend to remember? What's your best recollection of when Mr. Wade told you about?
I can't remember because I didn't even remember that it was October 2019 until you said that.
Okay. So you don't have a present recollection?
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Ms. Willis meeting at the conference had to be before.
Oh, yes, it would have been before that, yes.
So what other communications did you have with Mr. Wade about Ms. Willis that are not privileged? We know of one, about the meeting at the conference. Are you suggesting that that's the only one you ever had about Ms. Willis that isn't?
I cannot recall any. I cannot recall.
You cannot recall whether there were any other communications that weren't privileged?
No.
I'll be specific, and I understand there's probably going to be objections, but I want the record to reflect. Did you have a conversation with Mr. Wade prior to November 1st of 2021 about Mr. Wade dating Ms. Willis?
Mr. Wade has risen. An objection is sustained for the record. Excuse me, Mr. Evans.
Say that again.
You don't have to answer the question, Mr. Bradley. Next question, Mr. Sadon.
Well, I understand it's been objected to and the court has sustained the objection. Can you tell us the circumstances in which, that is, under which Mr. Wade may have told you about dating? What I want to do is try to figure out if we can, you tell me if you want me, if I can do this. I'd like to know how the communications themselves took place, where they took place, how they took place, under what circumstance, whether he was at the time providing advice or seeking advice.
Mm-hmm.
So those are the basics. If I can ask as to all those, but if the court's going to sustain the objection to those, then I don't want to waste your time.
And that's something I'll cover in camera. So I'll note the question and your question for the record, and I'll sustain the privilege objection to that.
Okay. All of this prior to November 1st, 2021. Okay? I'm going to show you two text messages. I don't have a hard copy.
Text message? That one. You want to get into the content?
I'm going to set up a question.
Okay. So I'm going to have objections.
Of course you're going to have objections. I realize that. I want to be able to show it to him, and then I'm going to frame the appropriate question, and then you're going to object. We'll see where we are. Yeah, Coach.
You may, sir.
Look at this text message.
Go ahead. Can I read it first?
Of course, of course.
Okay. That's it.
Okay. Kind of hard to object to that, and that's the question. I know it's coming. Okay. Then you must be a soothsayer. Mr. Bradley, I showed you two text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think so, yes.
Okay. And the text messages would have been between you and Miss Merchant, correct?
I didn't see it. Yes, it should be.
Okay. And I've shown the same two to prosecution, so we're talking about the same two. In the text message to Miss Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct? I haven't asked him anything about what the...
Flag for the court that this is a topic and a specific exchange that Ms. Merchant went into, and there were objections that were sustained.
All right. Understood.
Yes.
And it's your testimony that the information that you imparted to Ms. Merchant in these two text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which is regarding establishment.
Well, no, the question, he didn't get into anything. He just said, are these two text messages about privileged communications? We haven't actually, I don't see an issue there.
Yes.
And is it your testimony that the knowledge that you have, which you imparted in these two text messages, came from Mr. Wade and Mr. Wade alone?
Yes.
Is that correct?
Yes.
Can you tell us when it was that Mr. Wade imparted this information to you?
Objection.
All right. And I think
that's what you're going to do.
Sure. So I'll sustain that on privilege.
And I'm going to introduce for the record when we finish these two text messages so that Your Honor has those back there so that you can.
Sure. What would they be marked as?
What do you have?
I have a whole set. Okay.
I'm going to go ahead and.
The contract.
I think you the new one will be 26.
Once I put a staple in it, I think it'll be Defense Exhibit 26. All right. You have to give me a real pen.
All right, so this is marked and made part of the record as Defense Exhibit 26, but not necessarily for its
This is not
evidentiary
admitted 26.
value.
This is for purposes of the court conducting the in-camera review.
Right.
And put a staple in it here to make sure that you see.
No charge? Nope, it's free.
All right, Ms. Seda, what else?
All right, so there was also reference, if I remember correctly, to some email correspondence in which Ms. Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
Okay. And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her in an email.
Ashley, do we know? You responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but.
Okay, I'm going to get it for you because
Okay.
I don't want there to be any assumption. As soon as we have it. Let me show you. This is the email.
Is that what you're...
I'm going to show you if I might approach. I made reference to an email that Ms. Merchant would have sent you about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024 at 10:25 a.m.
Yeah, I see it, the email, yes.
That's the email that you received. Along with, obviously, the attachment, which is referenced.
Yes.
Okay. And then, did you respond to that email within the text message that I've just placed before you?
Yes, I said looks good.
So the answer is yes.
Oh, yes, I did.
Okay. Okay, we'll mark this as another exhibit for Your Honor to look at. Since you love my tongue, can I have a seat? Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected, let me hand it to you. Yeah. What's the court's rule, to ask or not to ask?
We'll take it case by case. I think he's doing all right, so we'll need to ask for this witness.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on a confidential or confidential communications that you had with Mr. Wade?
Do you want me to read the response?
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communications that you had with Mr. Wade?
It was such a good rendition. I thought I was
all right,
hearing
so now
myself.
we're talking about the email, essentially referencing the motion as a whole.
The
He hasn't
federal
been asked
penitentiary.
to actually confirm or deny any specifics, just to say whether his response is privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
No. Was your response to the email of Ms. Merchant, which is on page 1, is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communications?
Yes.
Have you discussed with the district attorney's office this case, your purported testimony?
Of my testimony?
Yes.
No.
At all?
No.
No prep, no conversations, no nothing?
No.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely, this is
Okay, sustained. Stay down. Next question.
Do you know whether or not your attorneys shared privileged information with the district attorney's office?
No, I don't know what my attorneys shared or didn't share. I don't know if they even met.
Have you, last question, have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee sharing partnership, pseudo partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason?
I wanted to leave and go out on my own, yes.
I understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
I don't want to try not to get into the specifics. Was there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
We had a disagreement, yes.
And had that disagreement have anything to do with Miss Willis?
Oh, no.
Okay. Did it have anything to do with your conduct?
No.
Did it have anything to do with his conduct?
Hold on, wait. So we had a disagreement. Whether the disagreement was, we disagreed, and so we dissolved. Well, I left the firm.
And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
I don't, if you define misconduct, I'm telling you we had a disagreement and we...
Just tell me what the disagreement was then.
The disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged. Why is that privileged?
Because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Ms. Willis.
As it a connection to Ms. Willis, that's correct.
It's connected to the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So will it apply as to whether I was hired during the divorce? Yes, that's correct.
I'm not sure what this correct means under that. We kind of got lost on it.
We asked the question.
It did not relate to your representation.
It did relate to my representation.
In the marriage case.
It does.
And this was whose decision was it? At that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I would have to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I would have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was, I don't know.
Continued representing him in connection with the divorce case after you had the separation that you've made reference to.
And he continued to, yes, and he continued to represent me on a construction case.
But the separation, at least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the divorce case.
That is correct.
Okay. Now, Mr. Wade has testified that he did not have a relationship, a personal relationship, a romantic relationship with Ms. Willis until sometime early 2022. Okay? I'm leaving that as the premise for what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, Mr. Sato, I think we've...
Would such information be privileged in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. I'll sustain that.
So, I can't get an answer to whether he possesses information which is inconsistent without getting into the information itself.
I think the issue would be that we've already gotten an answer on that, and now we're asking the same question again. Ms. Merchant asked in variation of that, and he already answered.
I think the variation, Your Honor, is referencing whether or not he had what would be personal information, independent source information. Mine is not so limited. Mine is, I'm asking him point blank whether or not he has information from whatever source, including Mr. Wade, that is inconsistent with Mr. Wade's testimony.
Because if it includes Mr. Wade, it is privileged communication. So therefore, the answer is it's privileged. If it excluded Mr. Wade, that would be a different appropriate question.
And I just want to say, the answer is either it came from privileged information or it's hearsay. That's it. He's already testified that he has no personal knowledge.
Unless it's for impeachment at this point. But, Mr. Seda, I think that might be too fine a distinction for me to see the need for the question. I think I'm failing to see the difference.
Well, I'm not asking, respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to do. And if Your Honor says I can't, then I'm finished.
And I think that this was another aspect of what came up before, which is, in my mind, even confirming the existence of the information goes into privileged communications, whether he does or does not possess information. If it came from that relationship, that's part of the privilege as well. So if I make that clear, then
so you're sustaining what the objection would be.
That's right. It'd be sustained on privilege.
And of course, all the questions that we're talking about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we've talked about.
That's right. My intent would be to make a record of the knowledge of when it was obtained and the extent of it and the different sources, and that'll be sealed.
And what was actually said?
That's right.
So I guess my question to the court before I sit down is, if hypothetically you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination of whether it can be used here or whether it just remains in the record sealed.
So my intent would be to make the distinction of, from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credibility determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So again, just to follow through to make sure. So if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law he provided to see if that is actually a variation of the crime fraud exception, and I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified to.
And to that end, Mr. Sadout, that is something that you can, I mean, I've got this case from Ohio, but if you can find something more on point in Georgia before we schedule
Other
this for
than the one
argument.
I gave you,
the Coca-Cola one,
the 1935 case,
the Atlanta Bottling Company. I don't think I went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say that there's this alternative theory about fraud upon the court. But we can flush that out in our research.
I appreciate it. Thank you.
Okay, Mr. Stockton.
No question, Judge.
Mr. Durham.
No question, John.
Mr. McDougald.
No question, Your Honor.
Mr. Rice.
No question, Your Honor.
Mr. Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel for him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on it?
Say that again?
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well?
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Okay. Judge, I would ask the court to take judicial notice of that.
For what relevance?
Judge, I think it does go directly to the crime fraud exception. Because if, before we draw objection, because if Mr. Wade was providing information to him, to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
let me pause you there. Isn't adultery, as a statute, just on its face, been found unconstitutional? You can't actually charge anyone with adultery anymore.
It is still current in the
Then it can't be a crime.
It is still a current charge.
Let's move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information. We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information, both with the original interrogatories that were filed in December of 2021, and frankly with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense, and therefore the crime fraud exception would apply as well.
Okay. Understood.
No further questions.
Okay, Mr. Gillen.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long day. When did you sign your engagement letter with Mr. Wade to represent him in divorce proceedings?
It would have to be 2017, 2018. Same time frame, 2017, 2018.
So did you sign or have signed an engagement letter to represent him, or are you just speculating?
I can't recall. I mean, we were in a, we shared space. I can't recall if there was a contract or if there is a contract. I think there is a contract, but right now it would be speculation.
Right now, sitting here, you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I mean, I can't say. I don't have my files or anything with me.
Well, sitting here, you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? Did you open when you represent someone, you open a file in your office? And when did you open the file on Mr. Wade?
I am going to object to the relevance of this line of questioning. There has been no dispute by the attorney or the client that there was an attorney-client relationship. And so I object to the relevance of the circumstances under which that engagement began, because as Mr. Gillen knows, that's not a factor in determining whether there was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we can spend too much time on this.
No,
so
okay,
we'll see.
Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it, yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law.
And this just in, a New York judge has just ruled against former President Donald Trump. He ordered a $364 million penalty, saying the former president engaged in a years-long scheme to dupe banks and others with financial statements that inflated the former president's wealth. Judge Arthur Engoron issued his decision after a 2.5-month trial. Trump's lawyers had said even before the verdict that they would appeal. And now we're bringing in our guest, Hans von Spakovsky, Senior Legal Fellow at the Heritage Foundation. Welcome, Hans. Great to have you with us. What is your take on this ruling? You know, many people expected it, but now it's happened. How do you see it?
Well, it's no surprise since this judge had said that he found Trump guilty before the trial even started, that the only purpose of the trial was to determine the amount of damages or penalties that the state was going to impose on Trump. Look, the problem here is not only a biased judge and a political attorney general who said she was going to get Trump before she even was in office. Look, the problem is a statute that doesn't actually require you to show that anyone in a particular business deal was defrauded and lost money. Right. The banks that lent money all said they were paid back, they made a profit, but this statute is so open-ended. Frankly, it gives the government way too much authority to intervene and to, frankly, confiscate the wealth of individuals and companies. This is the kind of statute you'd have in a place like Venezuela, and frankly, the Trump team should appeal it because I think it's quite an abuse of the legal system in the state of New York.
Yeah, critics of this particular thing that we're looking at here have said that there's no victim and no crime. So this speaks right to what you're speaking about. How rife are laws like this or statutes like this? How worried should we be?
We should be very worried. I mean, this is an unusual statute. You won't find this kind of statute in almost any other state, but this gives such wide latitude to the government, and particularly to abusive, politically motivated prosecutors like the Attorney General, that if I was the CEO of a large company, frankly, I wouldn't do business in New York. I wouldn't have any offices or my headquarters there, because if I upset politically the legal establishment there, I could have my entire company and its assets wiped out. That's how dangerous this kind of a law is.
And how likely is it that something like that could be challenged, that this statute could be overturned, or is it just here to stay?
Well, unfortunately, I think it's there to stay. There certainly is no incentive for the New York legislature to get rid of this statute. I think the Trump organization, in their appeals, is going to have problems because I think they're going to find that the upper reaches of the court system, the courts of appeal, et cetera, have the same kind of biased, politically biased judges as the judge who was overlooking this particular case, who, by the way, also expressed his hatred for Trump before he even got the case and said that Trump should be brought up on charges. That alone should have led to him being recused from the case, but of course, he paid no attention to that.
And what arguments will be used in an appeal, and how do you think that will pan out?
Yes. Well, like I said, I don't have a lot of faith in the New York legal system. We have this case going forward. We have a really frivolous criminal prosecution about to also start in Manhattan by Alvin case that also should not have been filed, as there was no crime committed in that case. And Alvin Bragg, who says, oh, there was a violation of federal campaign finance law, and that's why Trump is being prosecuted, doesn't have authority over that particular law. That's a matter for the Federal Election Commission, where I once was a commissioner, or the U.S. Justice Department, neither of which believe that the so-called violation of the law is actually a violation of federal law.
And as we just heard earlier, it sounds like President Trump will need to pay, and his companies will need to pay, around $360 million as a result of this ruling. How could that potentially impact Trump?
Well, keep in mind, the whole purpose of this by authorities in New York is, look, they're targeting Trump because they believe if they can confiscate his wealth, as much of his wealth as possible, that will take him out of the political arena. That is the reason that these lawsuits have been filed against him. And that is what's going on. I don't know how much this is going to hurt him financially, but I have no doubt this is going to be very hard on Donald Trump and his family, particularly since he's also already paying millions of dollars in attorney's fees to defend him in other criminal prosecutions, like the one down in Georgia, the one by Jack Smith in the District of Columbia. So, they believe they can siphon off his wealth, then he can no longer defend himself.
Yeah, Hans, we just saw on screen showing our viewers the judge's decision. Were there any wording or anything that came out in the particulars of his decision that stood out to you, or that you are expecting may be there?
Well, like I said, no, there was no surprise about any of this. The only surprise was that, as you know, the Attorney General, Letitia James, had actually recently changed the amount that she wanted the judge to impose in penalties. She wanted twice that amount. So I guess there's a little bit of relief here that he didn't agree to that and only asked for the amount that he's asking for, even though that's an enormous amount of money. But again, as I say, this is an open-ended statute, and one, there were no victims. And remember, there was expert testimony in this case saying that the judge's evaluation that these financial statements were wrong, that the judge was in fact wrong, that the financial statements were not in error, and in fact, they did not affect the deal making or the fact that all of these organizations that lent money all got paid back, all made a profit.
Yeah, now we've spoken about the potential hit to his finances. It does look like, in terms of voter support, that those that do support him tend to rally behind him, or so far they have, regardless of the decision that each of the judges has made. What do you expect in terms of that side of things, and what people's responses will be to this?
Well, look, that is a really interesting point about how all of these prosecutions and even these civil cases, and this was a civil case, have actually increased his support, Trump's support. And that's because people are seeing a double justice system. You know, the best example of that has just enforced that belief is the report just last week by the special counsel on Joe Biden. That special report says that Joe Biden engaged in exactly the same kind of behavior that Donald Trump is being criminally prosecuted for with regard to the retention of classified documents. That special report said that Joe Biden had willfully retained classified documents, and yet, what's the recommendation? No criminal prosecution. That's the kind of selective prosecution that this Justice Department is engaging in, and frankly, these other state prosecutors in places like New York and Georgia.
Yeah, even the state prosecutors, some critics have argued, are driven by perhaps the Biden administration in some way. How can we draw some links between that? Are there links? I believe earlier in the day, one of our interviewees, one of our guests mentioned Judge Engoron had donated to the Biden campaign. I'm not sure if there's more that we can look at here in this sense.
Well, in particular, look, in the case in Georgia, Nathan Wade, who testified yesterday in that case and is the special prosecutor who had an adulterous relationship with Fani Willis. Look, he billed Fulton County for meetings with the White House, multiple meetings with the White House, including the White House General Counsel. Why in the world would a local prosecutor in Georgia have a meeting with the White House over state criminal charges? There is no reason for that whatsoever. And that brings up the real suspicion that the Biden White House was helping, coordinating, and pushing this local prosecutor in Georgia to go after Donald Trump, the probable opposition candidate for the man in the White House, Joe Biden. That's, again, the kind of thing that happens in third world countries. It's not supposed to happen here.
And time is of the essence at the moment as we ramp up and gear up towards November election. This particular case only took 2.5 months for the judge to make a ruling on, and he had hoped to decide by the end of January, he said previously. What do you make of the particular timing of this decision?
Well, he's releasing it right in the midst of the start of the primaries, which as a presidential candidate, obviously Donald Trump needs to be out in campaigning. And so again, releasing this decision now, I think, is a clear attempt to interfere in the election process, something that for years now, Democrats have been accusing conservatives and others from doing. But this is outright election interference, I think, and it's hard to really deny that.
Hans, it has been great speaking with you. Thank you so much, Hans von Spakovsky, Senior Legal Fellow at the Heritage Foundation. We will be tuning in now back to the Georgia hearing, and we'll be back soon with more of this breaking news from New York. But first...
I don't have it in front of me. I don't have the file.
Was it sometime in 2023?
No, it would have probably been, 2023. See, I left in 2022. It could have been anywhere between July of 2022 and maybe December of, it wasn't, I don't have the accurate date, but it wasn't when I left, and it wasn't.
Make it easier for you.
Okay, all right.
You were not his divorce lawyer at the time the interrogatory responses were filed in May of 2023. Is that correct?
Oh, no, I was not. Okay, yes.
And as of today's date, Mr. Wade is still a married man. Would you agree?
I haven't kept up with the divorce proceedings, but I think they're still open.
Okay. So, and if they're still open, that means he's still a married man.
Yes, that's correct.
So if the fact that in a pleading there is a reference to the marriage is irretrievably broken, that doesn't mean the marriage ends, does it?
I guess you have to ask the judge that's handling the case.
Well, it doesn't end until there's actually a divorce decree signed by a judge. Would you agree?
I would agree.
All right. Thank you.
Okay, Ms. Cross, were you taking?
I am, Your Honor, and I'm going to have a minute. My cross-examination might be a long one, so we can go for about an hour and a half. Can I have just a 5-minute break?
Sure. All right, we'll be back in 5.
Okay. Yeah.
Stay tuned to get 2 rolls of alien tape free. You wouldn't stick your mother-in-law on the wall, but you could with alien tape. It just sticks. Just peel and stick to make anything stay in place quick. Brick, pavers, marble, tile, plastic, even leather. Nothing works better than alien tape. You wouldn't stick your fishbowl on a moving car, but you could with alien tape. The secret is nano-stick technology that grabs and locks on to secure one side of the surface to the other. Alien tape secures in seconds, then twist, pull, and rinse to reuse. Call or go online to get your first roll of alien tape for just $19.99, plus shipping and processing. But to make this deal really stick, we'll give you 2 more rolls absolutely free. You get 3 rolls of alien tape for one low price. Order now.
To order, call 1-800-490-1364 or go to tryalientape.com. So call 1-800-490-1364 or order online at tryalientape.com.
Hello, I'm Mike Lindell, and I'm here to tell you about my new product from MyPillow, towels that actually work. Watch this absorbency test. Here's another towel that we randomly went out and bought. Here's one of my towels with the nice design. I don't know if you can see this, but you could line a swimming pool with this. I mean, this is crazy. Get rid of it. Towels that actually work. What a concept. I'm interrupting this commercial to let you know you can get our 6-piece My Towels, regular $69.98, now only $29.98. Or you can save 25% on our brand new kitchen towels. Order ships absolutely free. So go to mypillow.com or call the number on your screen. Use that promo code to get deep discounts on all My Towels. And for a limited time, your order ships absolutely free.
Art is
Experience art with 5,000 years of history. Inspired by the divine. Experience Shen Yun.
Breaking news just now from the former President Trump and his New York fraud trial. A New York judge has just ruled against former President Donald Trump. He ordered a $364 million penalty for the former president, saying that he engaged in a years-long scheme to dupe banks and others with financial statements that inflated the former president's wealth. Trump also was barred from serving as an officer or director of any New York corporation for 3 years. Judge Arthur Engoron issued his decision after a 2.5-month-long trial. Trump's lawyers had said even before the verdict that they would appeal. And you can see the former president here. He did appear at the courthouse yesterday, and he spoke twice, obviously saying that he called it a disgrace, saying that he calling it basically election interference, and saying that he would be needing to campaign at night. And oh, that was a totally different hearing. But the judge's decision today is impactful. That's a lot of money, and the deal is that he will need to not do business in New York City for 3 years.
That's right. He's expected to appeal the decision and seek a stay to halt the enforcement of this law. His sons have also been fined $4 million in this case.
Yeah, I mean, it seems that he has Trump himself individually out of this $364 million from what I could find out. I don't have the actual decision, but I did get some notes from some reports. It says that he has to pay $354.9 million personally. So that comes just straight from former President Trump. And then the two sons will have to pay $4 million each. And then the former CFO, Alan Weisselberg, will pay $1 million. So I guess that totals up to the roughly $364 million, as well as Trump being barred. Now, it doesn't, in the reports, it didn't say whether or not the two sons would also be barred from holding any corporate offices, you know, either on the board of a corporation or anything like that. So I'm not sure if that was ruled against them, those two as well, because I'm wondering like what will happen to his businesses now if his sons can't take it over. Now there was some commentary previously that if they take the licenses away, which I'm not sure that's what happened, but if they take his license away, then he would have to maybe sell the property and be compensated for it. And I recall someone saying if the Trump name comes off of the property as part of the sale, that would reduce the value of it. And that just goes to show that what he was arguing about in this case, about the fact that, you know, he was putting his branding on it. He was inflating the value of it based on his branding. And it seems like that's something that a lot of people do and you're allowed to do, you know, but in this case, they said it was fraud.
Right, I mean, Trump built a huge name for himself. I remember growing up just watching The Apprentice. You know, the Donald Trump name just had so much weight behind it. And I think if you think about the value of a brand, think about the value of Coca-Cola, or Pepsi, or Facebook. I mean, just building up the meaning of the significance of that logo in people's mind. There's just so much value behind that.
Yeah, I mean, I would be interested to see the decision in terms of his license and whether or not he wants him to, you know, revoke them. I know there was an appeal during this trial to stop that from happening because the judge previously had ordered that he start canceling all of his licenses. So now it looks like he's saying he can't serve as an officer or director for 3 years, which I think Letitia James wanted 5 years or permanently. So that's a little bit better than what she was asking for. But I'm not clear on whether or not his sons can go ahead and operate those businesses. But then you have employees, right? There's potentially employees that could lose their jobs if he has to shut down everything. And what if nobody buys those properties, And then who would want to buy the properties without the Trump name on them? That's another thing. So a lot of variables here. He will appeal, so that will be on hold, I suppose, pending the appeal.
Yeah, the impact on New York City is an interesting question. Just yesterday, when Trump was at the courthouse, he mentioned many times how he felt that the city had really started going to pieces, that the rises in crime, and that it was a lot dirtier than he recalled. But now, as you mentioned, this could impact employment, business prospects there, the prosperity of the city itself, potentially.
Yeah, I mean, he has said that also at many different times, that, taking him away from the city with all the money that he's brought to this city and continues to bring to this city, and he even because he's present and someone else is right next door to him, that helps that person who's right next door to him, right, with their business, because he's there. So if he leaves and the name gets taken off of his buildings, what's that, I don't know, what's the mayor going to do, because the mayor now is struggling with immigration, right, and with the immigrants coming in and trying to house them and take care of them. And if he's losing money, because that's also a lot of tax dollars, businesses pay a lot of taxes. So it'll be interesting to see.
Yeah, in one sense, the value of New York City real estate goes down in general.
Yeah, like I say, if he's gone and he used to be next door to some other businesses and they're getting a lot of business just because he's there, that's going to hurt them as well. But I'm also wondering if Letitia James will go after other big name businesses in the city in the same way, because I got the feeling from the testimony in this case that it's pretty normal. Like, this is normal practice to weigh your properties and estimate values based on your brand, and negotiate with the banks and the insurance companies, because as we here, the banks and the insurance companies are not complaining. They're not the victims. Like, they say they're fine, they made money off of the deal. So they're not the victims here. It's just Letitia James. So, Trump has said many times, we have a victimless case. Like, there's no fraud.
Yeah, and I think one of the big issues here is that Letitia James didn't campaign on, resolving fraud in the real estate industry in New York City. She campaigned on getting Donald Trump. And so now we have this case where it looks like, she's saying that this is, we can't let anything illegal go unpunished. But underneath that, we know her true motivations are to get Donald Trump, as she said numerous times on camera, campaigning, not in a very sort of vigorous fashion.
But I mean, there is the conversation out there about how could this affect other businesses? If she did this to Donald Trump, will she now look at other businesses and at their practices and see what they're doing? Because I think if she scrutinized every business in the city, she would probably find a similar pattern. And I think other big name corporate owners probably do the same thing, for their companies.
And of course, we have been watching the Georgia hearing most of the day, and there was quite a lengthy testimony, and it's probably still going on, by Nathan Wade's former divorce lawyer and former colleague. It's been an interesting hearing, because he as I understand it, and also by his demeanor, seemed to not want to be there, and yet he has provided some insight into their relationship, even with his measured and reticent answers. What have you observed from that hearing? Part of the hearing?
It's been a struggle for the defense attorneys to get information out of this witness. He was willing at one time, at least according to Ashley Merchant, the defense attorney Ashley Merchant had text message going back and forth with him, where he seemed to be willing to speak about the relationship and the timing of it. But then afterwards, some of his colleagues, his former partners and friends, started calling him and trying to convince him to not speak about it. So by the time he got to the court yesterday morning, he said he was unwilling. He was an unwilling witness, and then he invoked this attorney-client privilege. So today was kind of more of that. There was more discussion before he came in about the attorney-client privilege. What can we ask? What can't we ask? How do we get around it? And then they let him say what he thinks he can tell and what he can't tell. So it's been a struggle. I see the attorneys using all kinds of ways to get around it and get some answers, and they were making a little bit of headway when I stopped watching it. Actually, former President Trump's attorney was up asking the questions, and he got him to say that Wade told him he met her or at the conference, at the municipal conference. He said that much, but when he was pressed on it, like, okay, so you can tell me that, you can tell me about this meeting at the municipal conference, what else can you tell me? Because before he was saying anything about Ms. Willis was privileged.
Yeah, and he did, as you say, called on his attorney-client privilege a lot of the time. He also said that he doesn't recall for quite a few of his answers, and that he did say that he acknowledged that Willis and Wade had socialized before 2021. But, you know, one of our guests earlier, David Gelman, criminal offense attorney, had said that demeanor is everything when you're a witness in a hearing. His demeanor was pretty reticent, I would say, or how would you characterize it, and what impact do you think that might have?
He seems to me to be more, how you say, standoffish or unwilling. I mean, he said he's unwilling, but his body language shows that he really doesn't want to answer anything that they have to ask him really at all.
Right.
And you know, his answers are very measured and cautious, and he was getting to the point where he was saying, could you rephrase the question? And I don't understand what you mean. And when they start doing that, you know, maybe he's trying to think up what he could say to answer it, you know, and so give himself more time, or he's hoping they'll give up and just quit asking it. And sometimes the judge does say, okay, ask it differently, or, you know, change the way you ask the question.
And this has been quite a drawn out hearing. It's been quite some minutes or hours that we're already still seeing, as you can see on screen. This is a live view of the hearing, and it's still going on. We're at 3:49 p.m. Eastern Time. So one of the aspects of this, of the potential consequences of his testimony, is, according to Ms. Merchant, one of the defense lawyers, Mr. Bradley, who we're seeing on screen now, she says that he has information about when Mr. Wade began his relationship with Fani Willis, and she says that she has other witnesses that she plans to call as well, so this hearing could well stretch on into next week. And that she also, so these witnesses that she has planned, potentially including Terrence Bradley on screen now, that have proof that they lived together at one point, that Willis and Wade lived together at one point, as well as having some kind of romantic relationship before the date that Wade started working with Willis. So if these witnesses say otherwise, potentially Terrence Bradley's testimony will impeach them. How could impeachment come into this? That's the argument from Ms. Merchant.
Yeah, because she knows he has information because he already told her some things, but now he's saying he shouldn't have because of attorney-client privilege, and the client is the one who can invoke the privilege, not him. So he's saying, I misspoke, I shouldn't have told you that, and now I'm saying I can't talk about it. So she was hoping that he would talk and that he could tell everything that he knows, and if anybody else said something differently, his testimony would impeach them.
Right.
Arlene, I want to look at what's next. We're expecting to hear more testimony on Monday, but after the testimony is finished, what's next in this case?
So the judge will have to rule on it. He will have to rule whether or not Fani Willis and Nathan Wade should be disqualified from this case. And, you know, as some of your experts had said earlier, you know, they'll have to get another DA, maybe from another county, to take over the case. That DA will look through the whole case and decide whether or not the RICO statute is the right statute. and whether all of these defendants need to be in the case, and whether the case needs to happen at all.
And just to recap, we do have a ruling just breaking from Arthur Engeron in New York. The judge in former President Trump's New York civil fraud trial has ordered Trump and his companies to pay nearly $355 million in that case. But we are currently considering the Georgia case, which the hearing is still going on today. There are potential ethical violations in this case in regards to Willis as well. In particular, Willis attacking defendants publicly at the sermon that she made in a church recently regarding this case. And the rules are that one should refrain from making extrajudicial comments. So how could this potentially impact her? She could be targeted for these ethical violations alongside this case. Is that right?
If they are considered to be unethical, I mean, I believe there was some commentary by some legal expert that said in some instances a prosecutor can make statements about defendants, but it depends on the circumstances. So I didn't hear her whole speech, so I don't know exactly what she said. I know she said something about race, but I don't know what she said exactly about the defendants that would have harmed their defense in the case. But if that is the case and it's considered to be prosecutorial misconduct, then yes, something could be done. I even think, the defendants themselves could raise that, in the court during the course of the trial. They could raise that if she stays on the case. And there is probably an ethics board within Georgia, but someone would have to file a complaint initially.
I see.
Arlene, one of the things with this case is that if Fani Willis is disqualified from overseeing it, somebody else would be appointed the DA, and that person could decide not to go forward with this case. We're hearing people talk about that being a possibility, them looking at any potential future replacement for Willis could look at this case and say, this is so complicated, we're not going to go forward with it. What would that mean if they just decide not to go forward?
I think they'd have to find someone else and keep looking until they find someone, right? And as we talked about this previous case that I believe she was disqualified from, they haven't found someone yet. So I think it would be the same kind of a situation. It's not that the case is dismissed necessarily, but and then I don't know. It's 18 months with the other case reportedly. How long do you wait? How long is long enough? That's the next thing. And
we did hear from one of our guests earlier that it wouldn't have to stay within that county. It could be taken by another prosecutor, district attorney from another county within Georgia. So that could speed it up. I'm not sure if that applies to the other case that she was disqualified.
Yeah, I think so. I think, and so if a DA from another county doesn't want it or says I don't have, I can't do it, then maybe they would go to another county again.
Right. We are watching a live feed of the hearing in Georgia right now, the misconduct hearing in regards to the Georgia case against Trump. Of course, that's looking at the relationship between DA attorney, District Attorney Fani Willis and Nathan Wade, the special prosecutor on that case. There's another violation, a potential violation in regards to this case with Willis's emergency motion regarding a subpoena from the legal team of Joycelyn Wade, which was the wife of Special Prosecutor Nathan Wade, and she demanded Willis testify in Wade's divorce proceedings. Could you speak at all to why that may be a violation? Legally, I believe, or the potential outflow of that. This just doesn't look good anyway, does it?
Well, I'm not too familiar with that specifically. I mean, I remember that they wanted her to testify, and then before she was supposed to testify, Wade and his ex-wife settled. He resolved the divorce so that Fani Willis didn't have to testify. So I'm not sure what information you have, but that's the last information I recall from that case.
So I believe there was a motion regarding a subpoena from the legal team But we can touch on that a little later. One analysis from today that we've come across is that Willis's behavior, Fani Willis's behavior yesterday, was actually harmful to the prosecution. Whereas another analysis has been that the judge was perhaps too lenient on her. And they could both coexist at the same time, of course. But what's your take on that?
Yeah, I think as one of the experts said earlier, he believes the judge was allowing her to continue to act that way so that it would get on the record, so that if and when he has to rule that he's going to disqualify her, he has all of this on the record in terms of how she acted and how she presented herself on that day. Just looking at it and not having that knowledge, it appeared to me that the judge was letting her do this and was being kind of lenient. And as I said, she's highly respected. That's a highly respected office, the DA. That's a highly respected office. That security guard was coming up and giving her eyeglasses before she even asked for them. So she's given a lot of respect in that position. But she really, tainted it quite a bit by the way she performed. I mean, that's no way for a district attorney to present themselves, at any time, anywhere, regardless of what the situation is.
And there was quite a bit of talk right when she arrived about whether she is a hostile versus an adverse witness. And I'm wondering, what's the meaning of that? What's the significance of that?
So hostile witness would be someone who says, I don't want to testify, like Mr. Bradley. He's a hostile witness because he doesn't want to be there and he doesn't want to talk. So that's considered hostile, even though he's not angry and yelling and screaming, but that's how it's characterized. Adverse was her, she's angry, right? And so she's adverse to whatever you're saying or to the proceeding, but she's willing. She said, I'm willing.
So it seemed to potentially impact the line of questioning that the lawyers were to take with the witness?
I don't think so. I don't think it impacts that, but it's just how much will the witness cooperate? A hostile witness, you're not expecting any cooperation. You're not expecting them to give you any answers that you want, like Mr. Bradley, and it's going to be a real struggle to get anything out of this person, and you can, approach it in such a way. Her, it's like she says, I'm willing, I'll tell you whatever you want to know.
Oh, great.
Just
Perfect.
ask me. But, she's going to be difficult.
And we have some breaking news here. Former President Trump's attorney, Alina Habba, just made a statement in response to the judge's ruling, which ordered Trump to pay over $350 million in the New York fraud case. Here's part of what Habba said. She said, "This verdict is a manifest injustice, plain and simple. It is the culmination of a multi-year politically fueled witch hunt that was designed to take down Donald Trump." She said, and before Letitia James ever stepped foot into the Attorney General's office, countless hours of testimony proved that there was no wrongdoing, no crime, and no victim. She also said, quote, "Let me make one thing perfectly clear. This is not just about Donald Trump. If this decision stands, it will serve as a signal to every single American that New York is no longer open for business." And to discuss this, we are joined live by Paul Kamenar, lead counsel of the National Legal and Policy Center. Thank you so much for joining us again, Paul. We spoke with you yesterday about the case in Georgia. Focusing on this New York civil fraud trial, what's your take on this ruling here?
Totally outrageous. I mean, they're finding him over $350 million. They started out with $250 million and they ratcheted it up. But Alina Habba's statement is correct. I mean, this is clearly an abuse of the judicial process. There were no victims here. The banks got repaid all their money with interest. And so this is basically a persecution of Donald Trump because he's running for office. And they're going to bar him for 3 years, he and his family and his sons, from doing business in New York. It's outrageous, and they're going to appeal it. The judge, in his opinion, said, this is only a venial sin. It's not like you're Bernie Madoff. But then he basically lambasted them because you weren't contrite enough. You didn't say, "Oh, I'm so sorry, I'm sorry." And why say you're sorry if you're not guilty of the fraud? So he's holding that against him. So I think there's plenty of grounds for appeal, both on the liability issue, which he decided months ago that they were liable, and today's decision was how much they're going to assess him. But that money is totally outrageous, and it's not going to the victims. It's not going to the banks because they were defrauded. That's money going into the New York Treasury. So it clearly is a terrible opinion, and one that should be reversed on appeal.
And how do you think that appeal will play out when it does get made?
Well, they'll have 30 days to file their appeal, and they'll raise everything in that appeal, both with respect to the liability issue, which was decided last year, as well as the dollar amount decided this year. I mean, as their examples, they'll challenge everything. The evidence, the appraisals, for example, they appraised Mar-a-Lago at around 18 or $20 million. And Trump says, no, it's worth, 400 or 500 million, if not $1 billion. I mean, they're selling 1 acre lots down there next to them that are empty for over $25 million. And they're assessing Mar-a-Lago at 18 to $20 million. So that's one example of how the valuation is really messed up here. But again, the liability issue, I think, is also strong. But they'll raise all the issues in terms of the evidentiary issues, as well as the reasoning of the judge on the legal issues.
Now, there's a New York statute, Executive Law 6312, under which this case has been brought. It's faced strong rebuke. Hans von Spakovsky, the senior legal fellow at Heritage Foundation, who just spoke with my colleague Stephanie Cox, was basically calling this a Venezuela-type statute. Tell us about this statute and its impact on the law in New York State.
Well, I agree with whatever Hans said. I know Hans very well. And it looks like the way the statute reads is that you're basically guilty unless you prove yourself innocent. So it's generally rigged against the taxpayer here. But again, you go back to the fact that there was nobody harmed. The banks didn't complain at all, and they do their due diligence, and the financial papers they submitted, it's expected, and you're doing real estate appraisals, that the banks do their own due diligence to see whether the asset or the collateral is worth the loan. But they're not so much interested in the collateral, they're interested in whether there's cash flow to pay back the loan, and Trump had the cash flow to pay that. So again, this really is making clearly a mountain out of a molehill, and the statute that Hans spoke of really is one that does not do a good sense of justice the way it's applied here.
And we're talking about Trump's cash flow and his value, his net worth. What impact would a loss of $355 million have on Trump's willingness to keep campaigning in 2024?
Well, again,
any further exhibits that are self-authenticating? If counsel are able.
So I think it's not going to have an impact, but it will show his supporters how the government is out to get him on all these cases. Not only here, you've got the other cases, the criminal cases here in D.C., Georgia, Florida, etc. So I think that will actually work in his favor to show how he's being singled out here. Hello?
Can you hear me, Paul?
Yeah, I can hear you. Can you hear me?
Yes, I can hear you. We got you. Yeah, I'm wondering about the impact in the election, and everyone talks about how his supporters are just galvanized by all these lawsuits. But what about moderates? What do you know about their position on these kinds of cases coming to the fore?
Well, I'm not a political scientist. I'm more of a lawyer here, but I think the moderates will also be persuaded that this is an unfair ganging up on Trump. It may be different with the moderates if he's found guilty of some of the criminal cases that he's facing, but this one is a civil case. It's money damages, and it's one where no one was harmed. There was no victim. So I don't think the moderates who may be leaning towards him will abandon him on this, but I think this will galvanize his base for sure.
And I keep coming back to this with the different guests we talk about with Trump's legal cases. So much of this is unprecedented. Former presidents have never faced this kind of scrutiny. Trump has these 91 charges. What do you think about how unprecedented this is? What does this say about this moment in history?
Well, you're right. It's totally unprecedented, and we're going to have the first criminal trial of a former president in New York on March 24th next month in New York on the Stormy Daniels hush money payment case. But it is really a new chapter here. It does, as Hans said, kind of Venezuela justice, where you're going after your political opponent, and it's really an overkill here, and it really is terrible for our democracy to have this kind of political persecution of a former president who's the lead candidate in the upcoming election.
Yeah, and how do you see the next few months playing out? I mean, Trump's calendar is just full of these court appointments.
Yeah, you're right. I mean, he's supposed to be on the campaign trail, but now he's got to appear in all these court hearings and so forth. So it's definitely going to put a damper on his campaigning. But at the same time, it may be he can campaign from the courtroom, so to speak, in terms of using this to his advantage, at least with respect to his base, and hopefully with some of the moderates as well.
Now, Paul, I want to zoom in on this hearing in Georgia that we've been following all day. The focus of the hearing is District Attorney Fani Willis, Fulton County District Attorney Fani Willis, and Special Prosecutor Nathan Wade, their relationship as it relates to the Trump Georgia case. From everything you've seen, we haven't spoken since yesterday. You've had a day or so to digest yesterday's hearing. Not as much happened today, but what's your view on everything there?
Well, yeah, I did see the testimony today. Fani Willis did not come take the stand again like everybody thought she would, but I still think that it comes down to whether or not she had a romantic affair with Nathan Wade before he was appointed in 2021. And there's testimony that it started in 2019. So that's the key evidence there, whether that can be rebutted or not. But I think just that alone is showing that somebody's lying here. But then you get into the monetary aspect of whether that had a conflict. And again, it's only an appearance of conflict that matters. And this whole thing about her paying back in cash to Nathan Wade for the trips and all that, that sounds very suspicious here, and we haven't seen the receipts for this. So I think there's going to be a judgment here to disqualify her or Nathan Wade or both.
All right, Paul Kamenar, lead counsel at the National Legal and Policy Center. Thank you so much for your insight.
Yes, my name is Austin Dabney. That's AUSTIN DABNEY.
Good afternoon, Mr. Dabney.
Good afternoon.
I want to direct your attention. Well, first of all, how are you employed?
I am employed right now. I have my own firm.
You're a lawyer and you've got your own law firm?
That's correct.
All right. I want to direct your attention to 2000.
Okay, we're seeing a new testimony about to begin.
What was your employment at that?
We're just getting in with the initial proceedings to define who the...
And that's Nathan Wade, Terrence Bradley, and Chris Campbell?
That's correct.
All right. And what did you do in that firm?
I was an associate attorney.
All right. And don't need a whole lot of detail, but generally speaking, who in the firm did you work for? What kind of matters did you handle?
Well, I believe I worked for all of them equally. They would all give me tasks to do, which court dates to go to, what cases to work on.
I want to direct now your attention, Mr. Dabney, to a particular instance. Did you have occasion at any time to go to a club with Mr. Bradley?
Could you repeat the question?
Yeah. Did you have any occasion to go to a club, a nightclub or a bar situation with Mr. Bradley?
Yes, I have.
More than one time?
More than one time, yes.
The time that I'm going to direct your attention to, we spoke about a little earlier today. Do you recall any instance, Mr. Dabney, where Mr. Bradley, where you witnessed Mr. Bradley sexually assaulting him?
Your Honor, I object to this
Okay.
specific instance of
Sure.
impeachment is improper.
All right. How is this not extrinsic evidence of a collateral matter, Ms. Cross?
Maybe ask a better question. My question will be if this witnessed Mr. Bradley sexually assaulting another employee of the firm.
It's exactly, but same subject matter. How is that not issue on a collateral matter for impeachment?
I think it's not a collateral matter. Your Honor, the witness denied it. I think it is highly relevant. I think that it goes to the witness's credibility and his denial here this afternoon that he committed the assault as a witness. I will proffer to the court who has firsthand knowledge and witnessed the event. And so I think that's highly relevant to both Mr. Bradley's credibility and to the proceedings that we've had for the last 2 days.
Still object, Your Honor.
Oh, I understand, Mr.
The attempt to impeach Mr. Bradley, they have to live with whatever answer he gave. They can't have a sub-trial with the extrinsic evidence of the conduct here. So we would object. Right? 24-608.
Ms. Cross, under 608, I don't see how this isn't well beyond the core facts at issue. I think you confronted with him. I think he answered them as he saw fit. An argument can be made as a result, but to go down a whole mini trial on whether he did or did not do this and circumstances of his leaving the firm, I don't see how that gets past 608.
I understand the ruling, Your Honor. Disagree, and just for my objection, I put a proffer on the record, not a detailed one, but that
I think you already have.
I'd like to, with the court's permission, I'd like to make it clear that the sexual assault I'm referring to was the same employee that I asked Mr. Bradley about. I just wanted that to be clear.
Okay. All right. Understood. Is there anything else that is relevant to this witness?
Given the court's ruling, no.
All right. Questions from defense counsel?
Good afternoon, sir.
Good afternoon.
When did you start working at the law firm?
I believe I started working, to my recollection, in March 2021.
Okay. And at that time, do I understand that there was what I would call a three-way partnership or sharing arrangement at the law firm?
I'm not aware of any sharing arrangements that they had, but it was the Wade, Bradley, and Campbell law firm.
And did you work in the law firm office on a daily basis?
I did.
And during the time period you were there for the remainder of 2001? That is, you worked from March of 2001 at least to the end of 2001, correct?
I didn't even have a bar license in 2001.
I'm sorry, 2021. It's a little late. From March of 2021 to the end of 2021, correct?
That's correct.
Okay. During the time period that you were working at the law firm, did you see Fonnie Willis?
During my time, could you repeat the
In
question?
that time period between March of 2021 and November 1st of 2021, did you see Miss Willis?
I may have recalled one instance where I saw her in passing.
And when you saw her, was she at the law firm?
That would be correct.
And do you know who she went to visit?
I do not know.
You didn't see her go to Mr. Wade's office?
I do not recall.
Did you ever talk to Mr. Wade about Fonnie Willis?
Could you repeat your question?
Did you ever talk to Mr. Wade about Fonnie Willis during the time period of March of 2021 to November 1st of 2021?
No.
Did you know they were dating?
No, I did not.
Did you see anything did you ever socialize with Mr. Wade?
As far as being an employee, yes.
Well, I don't know what that means exactly, but did you ever go out to eat with Mr. Wade?
On occasion, he would take the office out to lunch.
Beyond that, did you ever go to a nightclub or drinking or any of that with him?
No, I did not.
Okay, so whatever relationship Mr. Wade had with Ms. Willis during this time period, you don't have personal knowledge, correct?
I do not have any personal knowledge.
Thank you very much for being here.
Thank you.
Any other questions from defense counsel? Mr. Stockton?
When you started in March of 21, was that just you gave them a resume and started working there?
I don't understand your question.
When you started working there, is it a situation where your first day on the job was the first day you may have met him, or shortly before you met him?
Again, I don't understand what you're asking.
Let me back up. Did you know Mr. Wade or any of his partners prior to March of 21?
Yes, I did.
How did you know them?
In a professional capacity. I used to be a community supervision officer with the Georgia Department of Community Supervision.
And where would that have been out of? Fulton County?
Cobb County.
How long did you know Mr. Wade prior to that?
I didn't see Mr. Wade in my professional capacity. I thought you were asking about all partners, but if you're only asking about Mr. Wade, if you could please clarify.
Okay, so you went to work for Mr. Wade in March of 21, correct?
I went to work for the Wade Bradley Campbell firm.
Okay. Prior to that, how long did you know Mr. Wade?
I did not know Mr. Wade prior to that.
At all?
At all.
No further questions.
Any other counsel? All right, seeing and hearing none. Any redirect, Ms. Cross?
No, Your Honor, subject to the court's ruling.
All right, can this witness be excused?
May.
All right, thank you, sir.
Thank you, Your Honor.
Next witness, Ms. Cross.
I believe I know the court's ruling, so let me proffer that the next witness the state would call would be Anna Rodriguez. Question Mr. Bradley about the sexual assault of Ms. Rodriguez, a client of the firm, who denied knowing her or recognizing her name. I believe Ms. Rodriguez's testimony would be impeaching of Mr. Bradley. I believe it's appropriate, but want to present that before I call it.
All right, thank you, Ms. Cross. And so, based on that proffer and the subject matter proffered, I still believe that would fall under 608B as extrinsic evidence of a collateral matter. And so I don't think it's allowed under our rules of evidence.
Understanding that, I just make a proffer on the record that Ms. Rodriguez would testify that Mr. Bradley sexually assaulted her. She was a client at the time. And that would be impeaching of his testimony that he denied.
All right, understood. Any further evidence or witnesses, Ms. Cross?
No, sir.
Okay. All right, then at this time, for now, I'll consider the evidence closed, subject to any certified submissions by counsel, and subject to the results of the in-camera hearing. We will coordinate with all counsel to find a date to come back for summation. And to that end, again, using Ms. Merchant as kind of running lead on this, I'd like you to consult on whether that's going to be a collective response on behalf of the defendants. If not, then we're going to have to get into time allotment, and if it's more than a handful of counsel, it'd probably maybe be 10 to 15 minutes per side. And so, Mr. Sadon.
When did you say this might happen?
We'll follow up by email so we can coordinate with everyone's schedules. I want to make sure we have our same court reporter as well, so that the record is all in one place. And I know we have a lot of schedules to coordinate, but looking at either late next week, as in next Friday, or the following week.
Would we at least have the opportunity to get a transcript before we do that?
I think that's probably highly unlikely, but we'll see. It's just that would require a rush, and I know again we're at a shortage of court reporters, but I think there are other means you can refer to the evidence with confidence as to what was said. Ms. Merchant. Okay. And like I said, we will. We're gonna follow up with scheduling. Mr. Gillen.
The argument would be on this hearing
And
also on the forensic.
yeah, any other claims brought in any of the filings regarding forensic misconduct, this whole line of questioning? All right. Any other questions from defense counsel? Anything from the state?
We would just ask that we be allowed to submit a brief as it relates to the rulings that you just made as relates to the objections by defense counsel under 607 and 6021 was to be impeachment by contradiction, which in the state's understanding would allow the use of extrinsic evidence to impeach the specific testimony here of Mr. Bradley. So we're just asking for leave to provide a brief and have the court to further consider your ruling.
Well, if you still got your witnesses here and you think you've got a better legal argument, I'm willing to hear it. You said 607 and 608.
607 and 621.
Okay, I see 621 and I see 608. And
in both of those instances, they allow testimony that related to the testimony of another witness here, Mr. Bradley, that we can prove this is patently false, as he testified that he didn't commit a sexual assault and that he didn't pay off witnesses and things of that nature.
okay, and how do you get around 608B's prohibition on extrinsic evidence of collateral matters?
Both 607 and 621 allow the use of extrinsic evidence to specifically impeach facts known to be false.
But if that held true, respectfully, that would mean that any time a witness denied something, you'd be able to, of a matter testified to, you'd be able to impeach with extrinsic evidence, and that's, respectfully, that's not.
Well, here's what I'm fine with. Mr. Avati, if you want to submit that brief on purely legal argument, you can, but I don't want to have this as a vehicle to essentially put forth an extended and long-winded proffer of what you expected the evidence to be. So if you think I've made a legal error on that point, feel free to brief it, and we can reopen the hearing if that's legally invalid. Okay? All right. Mr. Chopra, is your client still here?
I believe so, Your Honor, but I'm sorry. They went in the
That's fine. If he is still here, let's relocate to the jury room. Okay. We will be adjourned for today. Thank you all. Miss Taylor, I don't it logged out on me. Do you think it? Yeah. Do you think it lost battery? Or?
And that concludes our coverage just at this time of. You'll take it.
That's right. So we just heard that the court is adjourned for the day in the hearing that's focusing on Fulton County District Attorney Fonnie Willis's relationship with Nathan Wade. Their relationship is under scrutiny because it may have begun before District Attorney Fonnie Willis hired Wade as the special prosecutor in the case. What they're saying is that, in Trump's Georgia case. So, what the defense attorneys are saying is that Willis essentially, they speculate that Willis hired Wade before starting this case, and so if that's the case, then she essentially started dating Wade before prosecuting Donald Trump, and if that's the case, then you basically have a situation where she hired her boyfriend in the case to prosecute Donald Trump. And one of the things the defense attorneys are talking about is how it's possible she started this whole case in order to make money with her boyfriend. And this is the picture they're trying to paint. We heard testimony from Willis, we heard testimony from Wade.
And it looks like we're going to hear more testimony next week. Is that correct, your sense from how this all wrapped up today?
Yeah, that's what the experts are talking about. They didn't mention it here. Arlene was saying that as well. It sounds like there's more testimony. What's next after the testimony wraps up is the judge will have to make a decision. Is District Attorney Fani Willis disqualified from overseeing Trump's Georgia case?
And we do have a guest joining us shortly to discuss all of this, but this is a huge case, of course, and we also heard another huge update today, just minutes ago, which is regarding the New York civil fraud trial. Judge Engoron, in that case, decided that Trump and his companies must pay $355 million for what he said was inflating the cost of his properties and businesses in New York City. So there's a lot to talk about. And this week, of course, has also featured other movement on other cases regarding Trump. He's got quite a few cases going, 91 felony counts, I believe. But we're going to be speaking with a guest shortly about all of this. Stay tuned for that. And of course, we have Capitol Report coming up shortly as well, and they'll be covering that and more.
And former President Donald Trump is scheduled to speak at 5 p.m., likely about this New York civil fraud case ruling. He'll probably touch on what's going on in Georgia as well. And like you said, Capitol Report will be covering that. There's so much going on in Trump's legal saga this week. Multiple cases are sort of having these inflection points, and it's just causing a lot of media attention. Most of the media outlets were covering the Georgia case all day yesterday.
And I want to come back to one point that I started with Arlene, but not just yet, because first we're going to have a small break. Stay with us, but first a short break, and we'll speak to you soon.
Hi everyone watching at home. We're here to remind you that if you or someone you know were injured in an accident that was not your fault, listen up. We have live agents available right now to answer your questions and tell you how much your case is potentially worth. Hi, I'm Gina Bellich, here with spokesman and TV personality Tom Mustin with us in the Help Center. So Tom, phones are really busy over there. Tell us what kind of calls you're seeing.
Well, Gina, first off, thank you for having me here in the call center with you. We always enjoy talking to the viewers and getting folks the compensation that they deserve. You know, we're seeing calls about all kinds of accidents, but the most common by far has been car accidents. So if you or someone you know were injured in an accident that was not your fault, give us a call right now. You'll speak with a live person. They'll answer any questions you have and tell you if you have a case and how much your case is potentially worth.
Thanks, Tom. All right, folks at home, you heard it. Take advantage of this opportunity and call now.
All right, we just learned that former President Trump is going to speak at 5 p.m. Eastern from Mar-a-Lago. This in response to the ruling earlier this afternoon. A judge just handed down a nearly $355 million penalty for former President Trump and his companies in the New York civil fraud case. Trump is also banned from serving as an officer or director of any New York corporation or other legal entity in the state for 3 years. Trump's adult sons, Eric and Donald Trump Jr., as you heard earlier, are barred for 2 years. The former president's attorney said he plans to appeal the decision. The judge had already found Trump liable for fraud in the case. New York Attorney General Letitia James was seeking $370 million in damages. James said that Trump, his adult sons, and his company defrauded banks and insurance companies by inflating the value of Trump's assets. So we're going to speak about all of this and more with our next guest that's coming up, David Gelman, a criminal defense attorney. But before that, there is so much to look at. We can even check back in with what Trump said at the courthouse yesterday. You know, he called the case decision that happened on a different case there a disgrace. He spoke a lot about the state of New York City today, and you know, mentioned the crime rates, and he actually used this phrase, migrant crime and Biden migrant crime, a couple of times.
That's right. He said this is not a crime in reference to the hush money case brought against him. He's using this clearly as an opportunity to speak to the public. Somebody asked him, how are you going to campaign when you're going to all these legal cases? And he says, I'll campaign at night, going to lawsuits by day, campaigning at night, a very Trumpian sort of response.
And it may end up working in his favor in some sense, because he can show, perhaps he can show his stamina in regards to his opponent, which, that has been called into question recently with Special Counsel Robert Hur's report calling President Biden a well-meaning old gentleman with, a poor memory. We haven't seen much of President Biden campaigning at the moment, but former President Trump does seem pretty intent on getting out there and speaking directly with voters at rallies around the country. So he said that he would be campaigning at night.
That's right, and there's a lot for him to campaign on. I mean, you have President Biden, talking slower and slower. I mean, we heard today he was talking about Alexei Navalny's death, and he paused in the middle of the speech, and it made it seem like he tried to make it seem like he was thinking about something, but it was almost like a sort of Mitch McConnell type pause. It likely wasn't the same kind of reason behind that pause, but it had this sort of shocking effect.
Yeah, and we do have our guest. He's ready to speak with us now. David Gelman, a criminal defense attorney. Thank you so much for coming back on and speaking with us again today. So this breaking news, Trump and the civil fraud case, what's the potential impact of this, do you think?
Well, thank you for having me on again. I love doing double duty. What is the potential impact? Well, number one, they already said they're going to appeal. Nobody is surprised, obviously. In fact, they would have appealed last night if they could have, obviously. Everybody knew this was going to happen. The $355 million that Donald Trump was fined today, along with 3 years that he is not able to be allowed to serve in any capacity in the organization. Again, not a surprise to anybody. What is the impact, though? I think the impact, and I don't think this has been talked about yet, I think the New York Bar Association is going to be having to take a very deep dive into two people right now. One, Letitia James, and two, Judge Erdogan. Those are two individuals that I think have overstepped their judicial bounds tremendously. And when I say that, I want to let everybody understand why I'm saying this. Letitia James, she ran on the sole purpose of going after Donald Trump. All right. And that was the whole campaign, nothing else. And if you look at New York now, we all know what's going on. Violence, illegal immigrants running amok, you name it, that's what it is. It's a bad city as we speak. Now, Erdogan, on the other hand, he just imposed a sentence on the former president that is not only unprecedented, it has never been seen. And what it has done, it is making businesses, or is going to make businesses, not only think, oh, wait a minute, I'm not going to be doing business in the state of New York anymore, or at least in New York City, but if they already are doing business, they're probably going to leave. Because who would think in their right mind that if they made a mistake, or even didn't make a mistake, but just crossed a politician wrong, that they are now going to be in the eyes, if you will, of the shark, i.e. Letitia James or another politician. And now they are going to go into court and get fined hundreds of millions of dollars, which is illegal, and have to pay all these fines and fees of attorneys. Not going to happen. It's going to be a bad day for New York.
And you mentioned the New York Bar Association here being the one that would need to look further into these actions and potential motivations. And consequences of this decision. How would that kick off? How would that proceed? Is there some process that needs to take place for them to begin this reflection? And where do you think it will lead?
Well, there's a couple ways it can proceed. Number one, this is obviously a very national topic. Donald Trump is not a small figure. He's a very energetic individual. So I assume people at the New York State Bar have already taken notice of this. And if they haven't, they've probably been living under a rock. But in the event that nobody in that particular office does, Trump's attorneys are definitely going to be recommending that the New York bar take a look and at least file ethics complaints against James and Erdogan. If they haven't done so already, which if I was going to guess, they probably already have the papers ready and are going to be filing them. Because again, there's no reason or nothing that I can think of for them to be possibly, number one, have charged Donald Trump and the Trump organization with any of these charges, because there has not been a victim that we have seen, and nobody has testified that, hey, they've lost money. In fact, the banks testified that, in fact, not only did they make money off of Donald Trump and the Trump organization, but he was one of their best clients. He was what they called a whale, which meant they wanted him. They went after him. They courted him, if you will. All right. He was an individual that they charged more interest in compared to a regular Joe Schmo, if you will. All right. He paid on time. They made money. So what was the big deal? Who was injured? Nobody. So Erdogan really is making a point that you, Bank A or Bank B, cannot do business with Donald Trump and the Trump organization now. So he is telling a private company that you are not allowed to do business with an individual because we don't like you or we don't like your business practices. There's no law broken. It is completely asinine. The appeals court and the appeals courts of New York are going to see this process, and they are going to probably slap this down, and I'm hopeful that it's going to be slapped down very quick. The D.C. Circuit Court has already spoken about this, and they are already starting to render opinions regarding this. And the opinions are starting to go the way of Trump.
Oh, interesting. And to your point about whether there was an actual victim in this case, you know, if I'm not misunderstood, the $355 million fine will not be going to the banks who the prosecutors alleged were harmed in this case. It will go to New York State. Is that correct?
That's absolutely correct, because the banks weren't harmed. In fact, the banks made money. They testified multiple times that they, in fact, were the ones that wanted Donald Trump. They wanted the Trump organization. They courted them again. So they made money. In fact, they said Donald Trump, they never paid late. They always paid on time, and they made money from the principal and the interest payments. So nobody, again, did not make money on this, all right? Everybody was happy with the transactions that occurred. So the $355 million fine that is supposed to be paid, that obviously is going to be appealed, if that fine does have to be paid, will be paid to the state of New York.
And now I want to look briefly at the Georgia case and the Georgia hearing. Today and yesterday, it's 2 full days of hearings regarding Fani Willis and Nathan Wade. There are potentially more witnesses, but does Judge McAfee have what he needs to make a decision, do you think, about the nature of their relationship and when it started?
So, you know, yesterday when I came on NTD, I had a different opinion. But today, my opinion has definitely changed after hearing all the testimony from Fani Willis, and from Mr. Wade, and then again from today. The judge has all the evidence and all the testimony he needs. If he does not disqualify Fani Willis from being the district attorney on this matter, I would be flabbergasted. And I think, and that is honestly a very, very big understatement. And I think this whole country would be flabbergasted. The way she acted on the stand alone is an embarrassment to the law. All right. I'm a former prosecutor in the state of New Jersey. And if I ever acted that way on the stand, I would be admonished 7 ways from Sunday. So and I'm not talking about just any of the details that she said or did not say, or just, her arguments or lack thereof. I'm just talking about her demeanor alone. That was terrible. But if you want to talk about the details and what she was talking about, everything that she said went against her credibility yesterday. And then Mr. Wade contradicted most of the things she said, talking about cash and cash apps. And then her friend yesterday was talking about her relationship with Mr. Wade that started allegedly in 2019, not in 2022, as Mr. Wade and Miss Willis allegedly said it did, which will have a pretty big ethical violation, which the state of Georgia, I believe, I'm hopeful at least, will be looking into. And then Miss Willis, I think she stepped into a criminal investigation, most likely. She probably didn't realize this, but she talked about campaign violations that she committed and money laundering issues that she potentially committed with cash that she stored and cash that she's walking around with. Remember, she's a prosecutor. Prosecutors are government employees. They do not make a lot of money, but she's talking about carrying around thousands and thousands of dollars and keeping $20,000, $30,000, $40,000 in a vault in her house. I've never met a prosecutor in my life who does this.
Yeah.
I don't think Fani Willis is the first one who does.
And she did, you were speaking to her testimony yesterday where she said she was justifying where she got her cash from, and did at one point say that she withdrew a lot of cash from one of her previous campaigns. That's the part that you're speaking about, is that right, about potential money laundering charges?
That's correct. That's correct. So it's very rich that she is going after Donald Trump for RICO violations and campaign violations, yet she flat out admits under oath that she committed this, probably unknowingly, which again, as a prosecutor, as the chief law enforcement officer of Fulton County, Georgia, she should know a lot better.
All right. Well, thank you very much, David Gelman, criminal defense attorney. Great speaking with you. Thank you so much for your insights.
Oh, thank you for having me.
New York Attorney General Letitia James has just released a statement in response to the judge's ruling in the Trump fraud case. She called it, quote, a major win for everyone who believes that we must all play by the same rules, unquote. And she added, quote, no matter how big, how rich, or how powerful you are, she says, no one is above the law, not even Donald Trump. James is set to speak at 6 p.m. Eastern tonight, just in about an hour, so stay tuned. And the Federal Penitentiary Service said in a statement that Navalny, and that is Alexei Navalny, back to the news earlier today in Russia, felt unwell after going on a walk, almost immediately lost consciousness after that. Another update from earlier today. But we are looking today mostly at Trump's trials, and the big one, well, there were two big ones today, weren't there? One in New York and an ongoing hearing in Georgia.
That's right. We've been covering this Georgia hearing for the past 2 days, and it focuses on District Attorney Fani Willis's relationship with Special Prosecutor Nathan Wade in Trump's Georgia case. Now, why is that important? Because it's been alleged that their relationship could have started before Trump's Georgia case began, and if it did, that means that she hired her boyfriend to prosecute this case, and also, possibly benefit financially. We know that Nathan Wade has paid for trips around the world to go with Fani Willis, and Fani Willis says that she paid him back, but in cash. And she says there's no traceable payments because the cash wasn't withdrawn from an ATM because she carries cash on her. She keeps it wherever she lays her head, and she says this is because she's concerned about not being able to pay for things when as a woman she was talking about. Her father testified, and he actually spoke about. He said, "quote It's a black thing," saying that black people keep cash in their homes, and he gave this. He told this story about not being able to pay for something one time because the person. Supposedly racially motivated, didn't accept credit cards or debit cards from him, didn't accept any traveler's checks from him, and would only accept cash. So this is one of the part of the testimony he gave to back up Willis's statements about carrying cash. But it's still, either way, there's no, these cash payments, there's no traceability.
And so there's a big issue with that in lots of senses, in trying to prove it here, in questioning whether it really existed. And of course, as we just heard from David Gelman, a potential conflict of interest and potential money laundering issues that he pointed to in her testimony, Fani Willis's testimony yesterday, about withdrawing cash. She was trying to say where she got her cash from, and offhandedly did mention that she withdrew some cash from her previous campaign. So there's a lot of issues coming up. Another potential ethical violation that is all mixed in with this is the divorce case that Nathan Wade settled with his former wife recently. Involved a subpoena from the former wife and from her legal team, and Fani Willis entered a motion to quash that subpoena, but at the time she accused her name was Jocelyn Wade, of interfering and obstructing Fani Willis in her role as the prosecutor in the Trump case that this is all a part of. But the wording of what she said was basically potentially implying that she was seeking to bring criminal charges against Jocelyn Wade, which is, according to the defendants in this case, violating a rule which states that a lawyer can't threaten to present criminal charges solely to obtain an advantage in a civil matter. So it gets really potentially hairy in these weeds in a sense, but a lot of these really could blow up. We're just going to have to wait and see, but there's a lot of red flags and things to watch out for.
Right, and another thing about this testimony, this 2-day testimony that we've been hearing in this, is that Willis testified, before she testified, she basically stormed into the courtroom. That's what some of our experts were saying earlier today. And you could see her, there was the camera, and she was kind of standing in the corner and getting ready to rush in to the witness seat, to the witness stand. When she sat down, you could see she was really anxious. What I'm saying is you could see on her face, she did not look relaxed. And she right away came right off the bat calling the merchant's accusations in her filings a lie, just outright.
One of the defense lawyers, the main defense lawyer in the case. Yeah, if you haven't seen that footage, it's quite interesting because, as we heard from some of our other experts.
All right, and now we're going to cut to President Biden speaking in Ohio. He's at East Palestine, Ohio, talking a year after the toxic train derailment there. Let's tune in. So basically last year, as everyone remembers, a train derailed.
For coming. On behalf of the village of East Palestine, I want to welcome President Biden. As we pass the first anniversary of the train derailment, the village of East Palestine appreciates the support from the U.S. EPA, the Department of Transportation. We'd also like to thank Governor Mike DeWine, the Ohio EPA, the Ohio EMA, and the Department of Public Safety, and all of our state and local partners that have been with us since the beginning. Our village has faced many challenges, but as a community, we have shown resilience. We will not be defined by this single event, rather our response to it and our perseverance. President Biden, your long-awaited visit to our village today allows us to focus on the things we agree with Acknowledging this disaster should have never happened. Address the long-term health concerns and the economic growth of the village, and ensure this never happens again to another community. Our goal is to be collaborative and proactive, collectively taking control of what we can shape for a stronger future. This includes support of bipartisan railway legislation, federal tax relief for funds received from Norfolk Southern, along with your unwavering support and assurances that our long-term concerns and needs will be addressed, which we have expressed here today, sir. We will not stop working, though. We will continuously strive to improve, not relying on just external aid, but on each other and our own efforts to elevate the village. We are committed to seizing every opportunity for growth, enhancing our community's strength, resilience through initiative and perseverance. Here in East Palestine, we are rooted in pride, tradition, and unwavering in our drive for progress and to determine the outcome of any obstacle. I thank you all for coming here today, and God bless East Palestine and the United States.
Of East Palestine, Ohio, talking about President Biden's speech in that small town in Ohio. Last year, we all remember the train that derailed with toxic chemicals in it and just massive plumes of smoke covering the town. The toxicity of the water in the area, basically being ignored. It's taken Biden a year to get out to East Palestine, Ohio. Why wasn't he there in the first place? So many questions. You could hear almost a type of frustration in the voice of the mayor there in East Palestine, Ohio.
For sure, and he had previously said, "Oh, best not come. It's too late." But by now, yeah, he has been criticized by many, not just the mayor, for not coming to visit just yet. And of course, Biden had said there's a lot on his plate, and he just hadn't had the chance. But what a big day this has been. We've heard an actual decision on one case from Trump, a long hearing in the Georgia case regarding Trump and that election case. Letitia James we're going to hear from at 6 p.m. And of course that potentially very sad announcement about Alexei Navalny, the Russian opposition leader who reportedly has passed away. That's according to Russian sources, so it's not verified, but this is just quite a historic day.
Yeah, and we point specifically to the fact that it's not verified according to Russian sources, because one of the things people who follow Russia closely talk about is how Russia is this sort of enigma, and no one ever can really fully trust the rhetoric, the public statements coming out of Russia. They have what they call a managed election system, where basically anybody who doesn't step in line with President Putin's plans or agenda doesn't get to run.
Yeah, it's something we will definitely be keeping an eye on, and for sure has more interesting information surrounding it, as most things of this sort and coming out of Russia do have. We also heard from Biden earlier today, and of course, as we've been watching closely, the Trump cases, the ruling by Judge Engoron in New York City, that's likely to be appealed, so we'll be watching that. All of these are ongoing stories. Even the Georgia hearing looks to be like it may continue in the next week.
Yeah, I mean, that whole story, Trump's Georgia case, it's so tenuous right now, because we're waiting to find out if this. We're waiting to hear future testimony. We're expecting more testimony in that, in the hearing about the relationship between District Attorney Fani Willis and the special prosecutor there. But we're expecting a ruling on whether or not to disqualify the Fulton County District Attorney who's bringing this case against Trump in Georgia.
Yeah, quite the turn of events. And even as we heard earlier from David Gelman, a criminal defense attorney, he believes that the New York City civil fraud trial decision may potentially lead the New York Bar Association to reconsider the standing of Letitia James and Judge Engeron in that case, and their professionality and judgment and the potential effects of this decision, which
That's right. Yeah, and one of the things that we were talking about before with Arlene was about how this case threatens the potential of anyone to manage real estate under the
And we do have some breaking news. I'm sorry to interrupt you, Chris. President Trump himself just responded to the New York fraud case, ruling himself on Truth Social, calling the decision, quote, a complete and total sham.
Again, he says there's no victims, no damages, no complaints. He also called the gag order the judge imposed on him unconstitutional and said the judge used a statute never before used for this purpose.
Again, he called it election interference. His attorney has vowed to appeal the case. That right there was Trump's response to the ruling in New York City, and of course, more generally as well, he has said that these cases are election interference. And we will be watching closely to see how all of this potentially affects his election campaign and of course the other developments in his other cases. They're all still developing very much, and it's not certain which way these will go. But that concludes our special live coverage of the Trump trials for today.
But don't go away. Former President Trump is set to speak at Mar-a-Lago in just a minute at 5 p.m. Eastern. NTD's Steve Lance will be bringing you his remarks live on Capitol Report, and we'll continue bringing you the latest on the Trump civil fraud case. Be sure to tune in. Thank you, and see you soon.